ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಕೊಡಬೇಕಿತ್ತು. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇತ್ತು ಸರ್ ನಮ್ದು. ಇವಾಗ ಇರುತ್ತೆ ಅಕ್ನಾಲಜ್ಮೆಂಟ್
After vacation ಇದ್ರೆ ಕೊಡಿ. No urgency, after vacation ಮೆಮೊ ಕೊಡ್ಬೋದು. ಹಂಗೇನ ಪ್ರಾಬ್ಲಮ್ ಅಂತ ಹೇಳಿ. ಇದನ್ನ ಸ್ಪೇರ್ ಆಯ್ತಾಯ್ತು ಬಂದಿರುತ್ತೆ ಎಲ್ಲೋ ಇರುತ್ತೆ
ಮೇಡಮ್ ಅದೇನೋ ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್
ಆಫ್ಟರ್ ವೆಕೇಶನ್
ಫ್ರೆಶ್ ಮಾಡಿ
RFP up to 15 ಬಂತು ಸತೀಶ್
The total 22 matters memo for total 22 matters memo for moving posting memo for fresh man.
ಈಗ ಏನಾದ್ರು ಕೊಟ್ಬಿಟ್ರೆ ಆಮೇಲೆ ಸಡನ್ ಆಗಿ ತಂದ್ಕೊಡ ಅದು ಮೇಡಮ್ ಹೆಂಗೆ ಹೇಳ್ತಾರೋ ಹಂಗೆ 2:30 ಅಲ್ಲಿ ನನಗೆ ಹೇಳಿದ್ರು ತಿರ್ಗಿ ಏನಾದ್ರು ಚೇಂಜಸ್ ರಿಪೀಟ್ ಮಾಡಿಸ್ಬೇಕು ಸರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಸರ್ ಫ್ರೆಶ್ ಸರ್
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಫ್ಟರ್ ನನ್ನ ಕಡೆ
ಸರ್ ಅದ ಹೆಂಗ್ ಸೇರಿಸ್ತೀರಿ ಸರ್ ಸೊಣ್ಣಪ್ಪನ್ನ ಸೊಣ ಅದ ಹೆಂಗ್
Total 22 next week.
ಬಂದೆ ನನಗೆ ಸರ್ ಸೊಣ್ಣಪ್ಪ ಏನ್ ಪದ್ದೆ ಇದೆ ಎಲ್ಲರ ಜೊತೆ ಅಲ್ಲೂ ಬಿಟ್ಟಿಲ್ಲ
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಇದ್ರೆ ಕೊಡಿ ಯಾವ ಸ್ಟೇಜ್ ಇದ್ರು
Yes, my lord.
Hmm. When that order has been passed?
Order was passed, we have filed a review petition. Several judgments have been passed, which and it squarely covers the question, matter in question. We have it on Monday.
Not Monday. Yes, 23rd. Yes, 23rd.
Father, before parent to post the matter on 16th election.
Hmm.
You are to Berlin. Maybe Monday.
Yeah, no, fresh matter.
Fresh matter. You have filed application for the rejecting the matter.
Alay matters.
What the question is, put up in-
29. Yes, 29th. Yes.
Fresh matter for a preliminary hearing, my lord. The plaintiff cause of action, my lord, defendant filed an application for injunction, trial court granted. In the appeal, my lord, dismissed.
Yes, Tuesday, 22nd.
My lord, this honorable court was pleased to direct the office to list my matter on 9th. Matter is not listed for vacating stay. My lord. There is some urgency. My lord.
Yes, 28th. Yes.
Eviction, I challenged the lower court order where the IA was allowed. After 5th of May 2024, the matter has not been listed. The stay in elections.
Even if it is listed, madam, it will not reach. Yes, 26th. Yes.
Additional properties are sought to be added to the preliminary decree.
Hmm.
Because the court has, even though all the parties have consented to it, the court has rejected my application. Sent on for tomorrow, day after tomorrow, it will be taken up today at 2:30.
Monday. Yes.
It was moved today, but it has not come.
Yes, Monday. Nothing will happen, Mr. It's not the final order has been going to pass. Yes.
Police direction has been rejected. We have to two orders.
Why police protection? What is going to happen now?
Temporary injunction was granted in favor of the petitioner.
What they are doing now?
He was unable to implement the tribunal.
No, see whether defendants are putting up in a construction or interfering. What is the threat?
They are interfering.
ನಾನು ಹೇಳ್ಕೊಟ್ಟ ಮೇಲೆ ಆಯ್ತು ಹೇಳಿ 22nd. Yes.
ನಾಳೆ ಕೋರ್ಟ್ ಇಲ್ಲ.
Yes.
From last 8 months, no order has been passed on IA number 1.
Yes. 21st. Yes.
So Monday or Tuesday.
Yes. Tuesday. Yes.
Suit for partition, my lord, fresh petition, my lord, TAE was not granted ex parte, my lord. Now both the sides have appeared, my lord, they are selling the property.
Yes.
So the IA has to be decided.
Yes. 22nd. Yes.
Application for amendment of pleas for the defendant any day next week.
Yes. 24th. Yes.
Trial court is not accepting the notice.
So you would have received a
Order for rejection. ಮತ್ತೆ ಇನ್ನೇನಿದೆ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂತ ಅಂದ್ರೆ ಏನ್ ಹೇಳ್ತೀರಾ?
Not accepting the counter.
No, not accepting ಅಂದ್ರೆ have you filed an application? It is this. ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಾ ಏನಾರ ಇರ್ಬೇಕಲ್ಲ. ಆಯ್ತು ಹೇಳಿ 28th. Yes.
Lordship, trial court has passed emergency notice on IA, Lordship. Despite of non-disclosure and non-compete agreement, Lordship, respondent number 2 has opened a similar company next to my company only, Lordship, which my company is at stake, Lordship, for 24th, Lordship.
25th. Yes.
With my lord's kind leave, my lord, is a petition against non-passing of orders by the trial court. My lord, directed the matter to be listed today. It may kindly be listed on 21st, my lord.
Yes. What is that urgency, madam?
Well, the suit for permanent injunction, the petitioner has filed an application to restrain the defendant from putting up unauthorized construction.
Yes.
The arguments were heard on 17/3 and it was posted for orders on 2/4, but no orders have been passed. And
Yes.
has again been
23rd. Yes.
My lord, suit for partition, my lord. I filed 1 Rule 10 for impleading. The trial court has rejected. Earlier, the suit was decreed in favor of me by way of specific performance, my lord. The response has suppressed the true fact. I filed the partition.
Yes.
In the meanwhile, after came to my knowledge, I filed the 1 Rule 10, but trial court has rejected, my lord. That's
When
why.
is that next date?
26th, my lord.
Yes.
Trial court.
Yes. 28th. Yes.
Fresh matter, I have put a memo on 9. The matter is not listed. The
trial court has passed an order appointing the court commissioners to execute this verdict, my lord.
Yes.
End of the list, my lord.
Not end of the list. Monday, yes.
Your Lordship, the petitioner,
reachable.
Your Lordship,
Yes.
the petitioner herein filed an application, requesting the trial court.
No, that your application is rejected, then they have filed an application for suit for what? That order has to be passed after hearing that. It cannot be, yes, 23rd, yes.
Your Lordship, in this matter, I have filed a caveat and my caveat is not noted without serving me. This is the second time it's happening between the same parties. If Your Honours recalls, 2 weeks back, Your Honours disposed of an impleading application where learned senior counsel Mr. Shamsundar had appeared.
Yes.
And same matter, same parties. Second time, my caveat is not registered. An interim order is sought by them, and my suit has been stayed as a result. I'm requesting for urgent listing of the matter today at 2:30, my lord. My lord, there is a breach of procedural requirement. I filed my caveat.
No, madam. See, you go and verify in that office how many applications are there for vacating. All are urgent. What is that urgency in your case?
My lord, I have filed my caveat. My caveat is noted without even serving me a copy. My name is not shown in the cause list. I have no way of coming to know about the case. What is the purpose of me filing a caveat? This is the second time it's happening between the same parties. There's a direction by a coordinate bench of this court where there's a direction for the trial court to dispose of the matter expeditiously within a year's time. And they have again sought for a stay. My caveat is not noted. I'm requesting for 2:30 today, my lord.
22nd.
My lord, 21st. They've not even served me a copy of the petition.
22nd.
My lord, at least.
23rd.
My lord, 22nd, my lord.
Yes, take it. Yes.
22nd.
Yes. Yes, 22nd. Yes.
My lord, suit for partition filed without making me as a party, my lord. I filed impleading application.
Yes.
In that impleading application, my lord, the court, nobody objected for it, but the court still goes and dismisses my application. That relationship has not been proved without framing a preliminary issue. My lord.
Yes.
My lord.
Yes, 23rd.
My lord, fresh matter, my lord, sir.
Your lordship,
The non-payment of rent, they are trying to evict me from the suit scheduled property, my lord. Though we have paid 7 lakh rupees of rent, my lord. So there is urgency in this matter.
Yes, 23rd. Yes.
My lord, this matter we had moved on 15th, my lord, senior counsel had moved it. However, it's not been listed as an emergency, my lord, on Monday.
What is that urgency?
My lord, we have an interim order, however, conditions have been imposed. The trial court is proceeding with latency, my lord, because of which there's a lot of damage being caused.
No, what is that interim order passed by the trial court?
By this High Court, my lords, staying their ex parte order, my lords, however, conditions have been imposed on us, because of which we are not able to proceed with the project, my lords, because of which the damage is being caused and loss is being caused to us.
No, you are a petitioner here. Oh, first time matter is coming.
No, my lord.
Then
Last date interim order was granted, but we filed IA for modification of the interim order.
interim order is already obtained, then modification. Let us see.
Please, my lords, on Monday.
Your lordship.
Able to comply with that interim order.
Next week, my lords.
Yes, next week.
Lord, this
matter. 28th.
My lord.
It was supposed to post today, my lord, but it has not been posted. There's we are sought for injunction, my lord, but the trial court has just issued the emergency notice, my lord. The defendants were alienating the property and they're changing the nature of the property, my lord.
Yes.
And it will be listed at 2:30, my lord.
Monday, 25th.
Your lordship, it's
Permitted me to move
a
the
partition
matter
suit,
after
your lordship.
complete. The injunction of the tenant has been vacated.
Yes.
There's arrears of rent, IA, your lord. There's an urgency in the matter.
Yes, 22nd. Yes.
Your lordship, it's a partition suit.
My lord, appellate court rejected the temporary injunction application. The respondents are interfering in the peaceful possession of the petitioner.
Yes, yes.
Third time I'm moving the memo, my lord.
Yes, 23rd.
My lord, this matter, my lord,
Your lordship.
Fresh matter. Yes,
my
23rd.
lord, this matter, my lord, lordship is directed to be listed today on my memo, not listed. 22nd is the date, my lord, lordship. 21st, my lord.
Yes, 22nd.
Please
Yes.
apply.
Your lordship, it's a part.
Challenging the order of the trial court. The order of the trial court says that we are transferring to the suit to the land grabbing, my lord. The trial court has posted for arguments on Tuesday, my lord. Kindly listed on Monday.
Tuesday, yes.
Right.
Tuesday.
23rd.
Without possession. 2009 matter. When the matter is settled for defendant arguments, the plaintiff has filed application seeking possession by way of amendment. Trial court allowed. Next date is 22nd.
Yes, 24th, yes.
Your Lordship, it's a suit for partition. Trial court has ordered for auction without determining my share in the rental income. Next date is 22nd. Kindly have it on 21st, Your Lordship.
No, what is that order you are challenging?
We are challenging the order for auction proceedings without determining our shares in the
Execution, FDP or?
FDP, Your Lordship.
Yes, 23rd.
21st, Your Lordship. Next date is 22nd. Auction is scheduled on 22nd.
22nd, yes.
21st, Your Lordship.
22nd, let us, yes.
Well, I fight.
What is that matter? Yes, 21st, yes. ಎಲ್ಲ ಕೇಳ್ತೀನಿ ಏನು ಅರ್ಜೆಂಟ್ ಮಾಡಬೇಡಿ ಯು ಡೋಂಟ್ ರಶ್ ಇಟ್ ಎಸ್
One more application happened, not put up compound wall.
Yes.
Yesterday, order has been passed to permit the independent to put up the compound wall. I've already visited.
Yes, 21st, yes, Monday, yes.
They are not entitled to come on record as journals. They have brought on record and the matter is posted 21st for commissioner report.
Yes, 22nd, yes.
22nd.
ಏನು ಮಾಡ 29th, yes.
29th.
You want to seeking for vacating? Vacating, yes, 29th, yes.
29th.
Yes.
On last day of the year, the joint submission was made by the petition and
Yes.
So, as I said, we expect to note that colleague of the respondent one had to take very before the court and say, there is no settlement. Considering their submission, the matter is posted for judgment. It may take a Monday.
Yes, Monday, yes.
Suit is filed who are in possession of the property for the past 45 years.
Yes.
On the basis of their injunction is sought, an ex parte order is granted to them. They are trying to dispose. The FIR is registered. Trial court does not have the jurisdiction and the matter is posted for 16 minutes. It's adjourned beyond 30 days.
Yes.
Rather than requesting for 230 minutes,
No,
they
no.
are in possession for
20
the past 47 minutes.
Monday, yes. 29th, yes. 29th. Next week, 29th, yes. Vacating stay, we don't think so. Yes, 29th, yes.
29th.
Amendment application, yes, 23rd.
Because
My
my
lords.
has been rejected, restraining the defendants from
29th,
carrying up court work, my
23rd.
lords.
Yes.
Because my lords, the land has not been acquired, my lords, but they are forming the road to private property, my lords. Just on Monday, my lords.
Not Monday, Tuesday, yes.
Two fresh matters, my lords. This plaintiff has filed a suit for recovery, my lords, without giving notice to the defendant number 2, my lord. The decree has been passed, my lords.
Yes.
And thereafter, the defendant one has filed a commercial appeal before this honorable court. This honorable court was pleased to remand back the matter for fresh consideration.
Yes.
The trial court has rejected our claim for filing the return statement, my lords.
Yes.
It is a day-by-day matters are listed, my lords. It is going to
And yes,
2 matters.
yes. 23rd, yes.
23rd.
Vacating stay, 29th, yes, let us. 29th, 3rd.
29th.
Yeah, not this. 24th, yes, 24th.
AIDB has acquired the family property. Now the amount is ordered, is going to be ordered to be released on against one person, one sharer.
Yes.
I filed an impeding application. That application has been rejected.
What is your interest?
I am on as the sharer, my lord, and appeal against the partition suit is pending before this.
Yes, Monday, yes.
Monday.
One review writ is filed. It was passed by His Lordship Justice Krishna Kumar. I understand, my lord, the procedure is your lordships will have to pass an order, place it before the Chief Justice. Right? Therefore, I am moving this for Monday or Tuesday. The review writ is filed, this court pass an order directing not to alienate the property. On the basis of that, an injunction is also sought against me in the miscellaneous petition. I have filed a review writ, my lord, under Article 226, relying on 63 Supreme Court.
Yes.
I moved the matter before His Lordship Justice Krishna Kumar. Office said that the matter will have to come before your Lordship. You will have to pass an order directing to place before the Chief
Monday.
Justice.
Yes.
Please.
Yes. Company matters. When do you want, Mr.? After vacation. Yes, after vacation. Yes. Company matters all after vacation. Yes. Second list. List number 2, company matters. Serial number
55.1.
With respect to very same claim, they have made a suit for recovery.
Hmm.
Where we have entire principal amount has paid, interest also you not directed to deposit the 8 crores rupees.
Hmm.
You have deposited the 8 crores before the commercial. This company petition is not maintained.
I thought we'll have it on Monday.
May be taken up after vacation only. For this reason, I don't appear, my lords, in the suit.
Hmm.
I seek instruction from the party.
Yes.
Communication. That is why, my lord, I request you, may be taken up after.
And they request matter was.
Because, my lord, I don't appear, my lord, I am unable to contact them. Your lordship may
Yes,
have it.
Mr. What you say? After vacation?
After vacation, any date
Yes,
may be.
all matters after vacation.
Number 1, page wise adjournment, page number 1, serial number
ಅದೇನೋ
1.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂತ ಒಂದಿದೆಯಲ್ಲ ಏನದು? Is that CA 56
English 2.
56 ಆರ್ಗ್ಯುಮೆಂಟ್ CA ಏನ್ ಪಾರ್ಟೆಡ್ ಏನಪ್ಪ ಅದು?
ಅದನ್ನ ಬೇಕಾದ್ರೆ next week.
ಇದನ್ನ ಪೋಸ್ಟ್
24th.
24 yes.
My lord, I am for the respondent, my lord.
56
I am for the respondent, my lord. Senior is out of station due to a family emergency, my lord.
24th next week
Okay.
yes, it will before the same court we can make a yes.
List number 1 for page wise adjournment, serial number 1 to 5, page number 2, serial number 6 to 18, page number 3, serial number 19 to 29,
Serial number 13.
30
13.
13 yes. At the
number
request
1.
of counsel for the petitioner, there is this matter of 2 weeks yes.
Page number 3, serial
22 yes. You are appearing for, you want time? No, it is only for adjournment, Mr. Yes.
page number 3, serial number 19 to 29, page number 4, serial number 30 to 34, page number 5, serial number 35 to 40, page number 6, serial number 41 to 47, page number 7, serial number 48 to 51.
51, reviewed to the petitioner.
Yes.
This is a matter, my lord, wherein in fact I have to file an application seeking the expunging certain remarks which they have made in the statement of it. That's
No,
why
what do you want time?
after it's a vacation, my lords.
Yes, at the request of counsel for the
Interim order may kindly.
petitioner. Have you informed other side?
Because he is in Mysore.
Yes. Leave this matter after vacation.
Interim order.
Granted earlier is extended till next date of hearing. Yes.
Page number 8, serial number 52 to 55, page number 9, serial number 56 to 58, page number 10, serial number 59 to 62, page number 11, serial number 63 to 65.
Appearing for the petitioner in serial number 63, my lord.
63 yes.
My lord, I need an adjournment, my lord, since.
Yes.
Senior is not available today, my lord, due to personal inconvenience, my lord.
And 50 lakhs have been deposited and they have paid. Let them deposit at least.
Now, what is the directions of this court? By
Direction is complied, my lord.
50%.
No, not 50%, only 50 lakhs out of 2.5 crores. So let them deposit at least.
Matter requires due consideration, my lord. Senior is not available today. Any date may be fixed after vacation or in the last week of the.
Wait, mister, wait. Not after vacation.
Yeah, any date may be fixed in next week.
Yes. If you want, we'll fix an after vacation, but no interim order will be extended.
And let them deposit.
Lord, interim order is already duly complied with, my lord.
No.
Whatever interim order was.
That is not for till
the disposal only, my lord, the interim
you
order.
understood that? Yes. You see, it is not that till that you have to be, matter has to be reached. It is for temporary, we have granted that.
Yes,
Maybe-
my lord. It requires due consideration of your lordship, my lord. I'm not denying that, my
Now,
lord.
taking that, you can't take an after
No,
vacation.
my lord. Any date may be fixed, my lord.
Yes. Then we can, after seeing that, we can say that pay some amount, then we can adjourn that. It is all by paying a installment, that's all. Yes. When do you want? Yes, 24th. Yes, let us see on that.
Page number 12, serial number.
Order granted earlier extended till next year. Yes.
Page number 12, serial number 66 to 68. Page number 13, serial number 69 to 72. Page number 14, serial number 73 to 76. Page number 15, serial number 77 to 81. Page number 16, serial number 82 to 84. Page number 17, serial number 85 to 88. Page number 18, serial number 89 to 91. Page number 19, serial number 92 to 97. Page number 20, serial number 98 to 103. Page number 21, serial number 104 to 111.
My lords, serial number 108, my lords. I am for the petitioner, my lords. My lords, matter may be listed after vacation. My senior
Yes,
is
at the request
hospitalized.
of counsel for the petitioner, leave this matter after vacation.
Yes, ma'am.
Page number 22, serial number 112 to 120. Page number 23, serial number 121 to 129.
My lord, 124, my lordship.
Hmm.
Well, I'm for the petitioner in this case. This case has actually been listed under preliminary hearing, my lordship, but we are actually put up an IA.
Hmm.
So kindly have it on Monday, my lordship. There's an order which has been, in the trial court has already been posted for orders on 24th, my lordship. Kindly have it on Monday for hearing on IA, my lord.
No, IA is there.
It's there, my lord. We have put it on 9/4, my lordship.
No, IA is there in that. Learned counsel for the petitioner has submitted that. Petitioner.
Yes, my lord.
Petitioner has filed an application. IA, office to verify and put up the same. Yes.
On Monday, my lord.
Yes, on Tuesday. Yes.
ನೂರ ಇಪ್ಪತ್ತೆಂಟು 128
Hmm.
after vacation.
Yes, you are appearing for
Petitioner.
at the request of petitioner after vacation.
Page number 24, serial number 130 to 136. Page number 25, serial number 137 to 142. Page number 26, serial number 143 to 147. Page number 27, serial number 148 to 153. Page number 28, serial number 154 to 157.
156. 156, yes. What you want after vacation? Yes, at the request of counsel for respondent. Leave this matter. Yes, respondent in 21526 of 21 and petitioner in 295. Leave this matter after vacation.
Page number 29, serial number 158 to 161. Page number 30, serial number 162. List number 1 for preliminary hearing, serial number 1, Joseph Anthony for petitioner, M.N. Madhusudan.
Here for the petitioner. Lord, this is it's been sent by email also, my lord. I have the acknowledgement having sent it by email as well to them.
Yes.
Both of them, my lord, we've served. They
No, email. No, unless the rules provides that you can serve it by email.
It permits, my lord, us to serve by email.
That rule has
I
not
think
been notified. I don't think so.
It's one of the modes, my lord, by which we can serve, which we've served them. Email, no, no.
Monday, what is that urgency?
No, urgency, I'll tell you, lordship. If you lordship give me one moment.
Agreed for Monday. You give the copy, we'll have it on Monday. Yes. Yes, that's what,
I'll
for
give a
that
copy.
purpose only, Mr. Yes.
Lord, lordship has record, it's been served on them right now, my lord. Another copy has been given to both of them.
Yes, learned counsel for the petitioner has served on a copy of petition to counsel appearing as a caveator for a caveator. Yes.
Monday on preliminary hearing, it
Sees this matter on Monday.
Yes.
Serial number 2, X.M. Joseph for petitioner, Vinay N.
Please, Lords. This is a case where
Yes.
the cross-examination of plaintiff witness is denied
Yes.
on the ground of non-filing of written statement. The
Yes.
settled law, my lords, that even if the right to file,
That order.
your lordship gets it at page, annexure G, my lords, at page 89, my lords.
Yes.
Lordship will kindly see at page 99.
Suit for?
Suit for money recovery suit. There are multiple defendants,
Yes, there is no.
few defendants of cross-examined.
Yes, where is that finding?
My lords, at page 99,
Yes.
para 19.
Yes, read.
In this case, admittedly, the defendant number 11 has not filed a written statement. The order sheet reveals that on number of occasions PW has been recalled. This is contrary to the proceeding sheet. I'll produce the proceeding sheet, my lords. At the instance of other defendants. PW1 admittedly resides in so and so. She has to travel on all that. Then later, my lords, at page 101. It is worthwhile once again to note that defendant 11 has not at all filed a written statement. Therefore, the right to cross-examine is denied. Now, my lords, at para 15, my lords, at page 98.
Yes.
The impugned order, my lords, makes certain allegations which are contrary to the order sheet.
Yes.
Now, if your lordship goes to page para 23 at page 20 of my writ petition.
Yes.
I've set out those dates. 23,
Yes.
23. In fact, the PW1 was absent that day.
Yes.
The lordship will kindly see the order sheet.
Yes.
Now pass on the order sheet, my lord.
Yes. Anyhow, you have mentioned there.
Yes, my lord.
Yes.
Posted for marking documents. Exhibits P1 to P59 marked for plaintiffs are adjourned for cross-examination of PW1. And 17(7), defendant files IA, that's for adjournment.
Yes.
That's rejected. 27, defendant number 3 and 5 partly cross-examine PW1 and adjourned to immediate next date, 22/11/23 for want of time.
Yes.
28/11/23. PW1 cross-examined by defendant number 3 and 5. Adjourned to 16/12/23 for further evidence of plaintiff.
Yes.
A plaintiff counsel submits the plaintiffs have no further evidence on 16/12/23. Next date is PW 26/2/24. PW1 is cross-examined partly by me, which was for about 1 hour, and it is adjourned to 26/3/24. Continuously have cross-examined. Now, what has happened, my lords, if your lordship will kindly see, para 5 of my writ petition.
Yes.
At the stage of cross-examination of PW1, I was engaged to cross-examine. I filed wakalatnama that also finds a place in the order sheet.
Yes.
For defendant number 2. I proceed with the cross-examination.
Yes. Who is appearing for other side?
One more.
Yes.
And second issue, my lords, is the statement of objection. It is filed by the plaintiff advocate. There is no verification. Truthfulness of whatever, at least facts to the facts. It's only the plaintiff who has to depose to the correctness of the pleadings.
Yes.
If your lordship will kindly see the annexure D, my lords, at page 70. There is no verification at all.
Of what?
Verification of the statement of the pleadings. Let's see.
No, that is not the issue here. Here
Not
issue
the
is that
issue.
only cross-examination.
That has been acted upon, but I should be given an opportunity to cross-examine.
That is the only issue now.
Yes.
Where notification was filed by another defendant.
Yes.
Summoning of the document.
Yes.
That is a different issue. If I don't produce that document, ask what they want me to deposit in the court. It's a personal document. That is not an issue here.
No, let us see. Yes.
Petitioner here is none other than the wife of the second.
Yes.
But the respondent 1 and 2 were the plaintiffs who decided to one. He has come down for cross-examination and represented us for cross-examination 7 occasions. In fact, on one occasion, that is on 1/2/2024. But the request was made that defendant number 2, 4, 6, 8, and 11 and 17, that they may be given an opportunity to cross-examine because it is closed. But we said, all right, you can go ahead, but you should not take time again because she's coming from Oman. What they did is, prior to it, she had come for cross-examination. At that stage, they filed a memo after she came present in court for cross-examination. They filed a memo saying that her affidavit has to be rejected because according to them there were certain lacunas in the affidavit. Therefore, she was not cross-examined. Then they challenged that order before the Supreme Court, and this petition also was dismissed. After which, they sought for permission to cross-examination. Cross-examination was done, and defendant number defendant number 5 cross-examined her on multiple occasions. 7 occasions she was cross-examined, including by my learned friend who cross-examined the PW1. Now, after everything is over, many government will just show me a few dates. But para 5 of my objection at page 70.
Really the objection.
Page 70.
Where is your objection?
Page 70, not of the.
Page 70, my lords.
This is a clear case of abuse of process. And they want to track the proceeding because suit for recovery of money.
Yes.
But page 70 is not please turn para 3.
Yes.
Instance suit was posted for cross-examination PW1 on 3/6/2023. And defendant number 2, 4, 6, 7, 8, and 11 filed an appeal in very same day, seeking for rejection of the affidavit evidence of plaintiff tendered to plaintiff number 2, knowing fully well PW1 had traveled from Oman to Bangalore for the purpose of cross-examination. Said application was filed to drag the proceedings and to harass PW1. But then after which what from that paragraph, this honorable court video order dated 27/6/2023 rejection certificate with cost of ₹5,000 on said defendant adjourned the cross-examination PW1. On 17/7/2023, though PW1 was present before the Supreme Court with the object of delaying the suit, defendant number 2 counsel, who also represent defendant number 11, not defendant number 2 is the husband of defendant number 11, that is petitioner. Here is the wife of defendant number 2.
Yes.
Defendant number 11, they had the same counsel. Filed an application under Order 70/1 seeking an adjournment. The Supreme Court rejected the said application, orally observed that PW1 is traveling from Oman to Bangalore for cross-examination, and that it was made clear that on the last hearing date that no further adjournment would be entertained, and closed the cross-examination PW1 and adjourned the matter for defendant evidence on 4/8/2023. PW1 had again incurred traveling expenses for the actions of the defendant. But again, the matter was adjourned because they requested. Then para 5. In the meantime, defendant number 2, 4, 6, 7, 8, and 11.
No, you give me that order sheet when he has requested what dates.
Well, but not have it on Monday, not again, because the order sheet that they have produced.
Sorry for interrupt.
Yes.
Entire order sheet is
On
not.
inter-
Order sheet, what are the dates they have requested? You will see that Monday.
I have brought the order sheet. The entire order sheet.
You have.
I have not made any request. In fact, my lords, if your lordship will, I'm sorry, I'm giving it left hand. If your lordship will kindly see para 18 of my
You have given the
petition.
copy.
The petitioner herein and defendant number 2, though they are husband and wife, they are at loggerheads. This is there on the record.
We are not. See, I want to see which are the dates, who are the parties as
Please,
asked
please,
the
please, my
adjournment
lords.
and all. That is
Entire
the
order
only
sheet is
point that
Entire order
Entire-
sheet.
purposefully it has been dragged or that.
No, I have not dragged.
No, by seeing that
Yeah,
order sheet,
please.
I can make out. That's what
Entire
that-
order sheet is there before the court, my lords.
They are all polluting with one another. But one application is filed by one of the defendants.
Yes.
Then the other defendant won't turn up. Then the next advocate files another application on the next day.
Each one is exercising the right.
No, see, both of them given an order sheet and point out that what are the dates when that defendant has sought, then we can easily make out that. Otherwise, I can't.
Yes, not have it on Monday, I will do that.
Yes, which are the dates? Then we can make out that whether they have really needed the cross-examination or they are.
Please,
Refer to in the order, because the court has noticed on how many occasions they have sought for.
That's defendant number 3 and 5.
See, that he has said that some of them dates which has been mentioned on request of the defendant is wrong because it is
The order sheet reflects
not on the
that.
request of the defendant. Then I have to rely on that order sheet only.
I shall produce that.
Yes, that's what. Monday.
Have it on Monday.
Yes, Monday.
The matter is set down for today for argument stage. Let them not precipitate.
Nothing is going to happen.
No,
No, Mr.
It is everything
Counsel.
is going on here. Your lordship
No,
will kind-
Mr. Counsel, till that matter has to be posted for orders. If you succeed, your application will be allowed, then party has to be
What
cross-examined.
happens,
Why
my
do you worry
lord,
that?
sir, today the matter will be heard, then they will not, I'm not making any allegation against the presiding judge. The court may say that the arguments of defendants taken as nil. I have to file one more application. Let them not do that.
No, arguments, today it is for arguments.
Today,
On the main, what has happened is.
that is how it is.
Application for summoning of the document from me. That application has been rejected. Now they find a review.
Now, your lordship,
That you argue. On review, you argue for evidence is concerned. If you succeed, then I will fix the date. On that day, further evidence has to be got.
please,
That
please,
will not, yes.
please, my lord.
Yes, Monday.
Monday,
Cover sheet, both of them, you
Monday,
serve,
Monday.
copy each other, then easy for the reference.
Monday, my lord.
Monday.
I take
Or
the-
you want Tuesday?
No, Monday, my
Monday,
lord.
yes, Monday.
Serial number
May I
3,
take the order
Madhyantara.
sheet, my lord? May I take the order sheet?
Order sheet, could you? Yes.
Lord of petitioner, my lord, the plaintiff before the trial court, my lord, if I suit my lord for permanent injunction, my lord. During 20 days of this petition, suit, my lord, the defendant filed application, my lord, that is annexure C, my lord. Per section 1, annexure C, my lord. That 151 of CPC, my lord, in one application, my lord, is seeking, my lord, multiple prayers. Kindly see, my lord, this application, my lord. For the defendant applicant.
Page number?
Page number 25, annexure C, my lord.
Yes.
You want to, my lord, repair the works, construction.
Carry out the repairing work, constructions, renovation,
Please.
ಎಲ್ಲ ಒಂದೇ ರೀ ಅವು. Eastern side of
Eastern side wall.
work.
Work.
The construction, renovation, or if they are not to interfere, then it is a different. Application for not to do work, not to construct, not to renovation, ಮೂರು ಬೇರೆ ಬೇರೆ ಹಾಕಕ್ ಬರಲ್ಲ. Or ಅಂತ ಅದು ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ.
Recently, my lord, 2014, my lord, he renovated his house. I have not produced this copy, my lord, just I have taken print out. This is the my house. 2014 alone. Again, my lord, trial court, my lord, on technical government allowed the application. Kindly see, my lord.
Where is that?
That is para number 5, page number 45. Para number 5, last para, my lord. Last para.
45.
45.
No, that you are the plaintiff.
Please.
You have filed an application.
No. Defendant filed application.
Application for what?
For repairing work, for revocation and construction of the eastern side of the wall.
You have filed a suit for?
Permanent injunction.
Permanent injunction.
Please.
Yes.
45, page number, last paragraph.
Yes.
On the other side, the plaintiff submits that the suit schedule property belongs to the plaintiff and not belongs to the defendant. On perusal of the order sheet dated 25/9/2019, the plaintiff counsel himself submits that he is not pressing the IA order 39 rule 192 of CPC and seeks to post the matter for issue. It is clear that the defendant is not carrying any trouble to the plaintiff. Further, the defendant submits that he is residing in his own property, not on the plaintiff property. That is the finding, matter. I have withdrawn the application for the reason that my lord is not given. Definitely, my lord is not given. No, my lord, if filed application, my lord, if my lord is constructed as eastern side of wall, kindly see my annexure, my lord, H photo. Original photo I have produced, my lord.
39 rule.
Page number, my lord, 38. This is my house.
Where is that application?
Application annexure C, my lord, page number 25. Is application. And also in the written statement, my lord, he not mentioned his schedule, my lord. That is the finding, my lord. And that is the, my lord, taken to defense in my objection. Annexure C, my lord, page number 25. That is application. Affidavit is page number 26, my lord. He says that the house is which is 50 years old house. He stated in the affidavit. 50 ವರ್ಷದ ಅಂತ ಹೇಳ್ತಾರೆ. 2014 he renovated his house, my lord.
No, that Anyhow, that his house is renovating, how it will affect your, should not.
Kindly see
claim
my
anything.
photo ನೋಡಿ. ಆ photo ಅವರು just ಅವರು ವಾಲ್ ಮುಟ್ಟಿದ್ರೆ ನನ್ನ ಮನೆ ಬಿದ್ದೆ ಬೀಳುತ್ತೆ. Already kindly see my annexure H, my I have kindly see annexure H.
No, they are doing their home, their house.
ಹೌದು ದೇರ್ ಹೌಸ್.
ನಿಮ್ದು
ಅಲ್ಲ ನನಗೆ ಏನಿದೆ ಕಾಮನ್ ವಾಲ್ ಇದೆ ಅದು.
ಯಾವ್ದು ನಿಮ್ದು ಮನೆ ಯಾವ್ದು ಇದ್ರಲ್ಲಿ?
ನನ್ನ ಪಕ್ಕದ ಮನೆ.
ಅಲ್ಲಿ ಅನೆಕ್ಸರ್ HL ಫೋಟೋ ಇದೆಯಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಇದು ನಂದೇ ಮನೆ ಅದು.
ಅದೇ ನಿಮ್ದು ಯಾವ್ದು ಮನೆ, ಅವ್ರದ್ದು ಯಾವ್ದು, ಅವ್ರ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಯಾವ್ದು?
ನನ್ನ ಮನೆ ನನ್ನ ಮನೆ ಇರೋದು ಮೇಲೆ ಕೈಂಡ್ಲಿ ದಿಸ್ ಇಸ್ ದಿ ರೈಟ್ ಪಕ್ಕದಲ್ಲಿ ಇರೋದು ರೈಟ್ ಸೈಡ್ ಇರೋದು ಅವ್ರ ಮನೆ. ಇದು ನನ್ನ ಹಳೆ ಮನೆ, ಇದು ಈ ಪ್ರೆಸೆಂಟ್ ಅಂತ ಹಾಕಿರೋದು.
ಯಾವ್ದು ಅವ್ರದ್ದು?
ಅಲ್ಲಿ ರೈಟ್ ಸೈಡ್ ಇದೆಯಲ್ಲ
ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇರೋದು ನಿಮ್ದಾ?
ಅಲ್ಲ ಲೆಫ್ಟ್ ಇರೋದು ನಂದು ಹಳೆ ಮನೆ. ಇದು
ಹಳೆ ಮನೆ ಅವ್ರದ್ದು. ಅವ್ರು ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ? ಹೊಸದಲ್ಲ ಅದು?
ಅಲ್ಲ ಅವರು 2014 ರಿನೋವೇಟ್ ಮಾಡಿದಾರೆ ಆಲ್ರೆಡಿ. ತಿರ್ಗಾ ಈಗ ಗೋಡೆ ಬೆಳೆಸ್ಬೇಕಂತ, ಈ ಗೋಡೆ ಬೆಳೆಸಿ ನನ್ನ ಮನೆ ಬಿದ್ದೇ ಬಿಡುತ್ತೆ ಈಗ ಆಟೋಮೆಟಿಕ್.
No, which is the suit scheduled property?
This is the eastern side of the wall also.
See, they are seeking permission in the suit scheduled properties or separate properties?
Suit scheduled property.
Suit scheduled property ಮತ್ತೆ ಅವ್ರ ಜಾಗದಲ್ಲಿ
his intention to my lord to encroach this property also. His intention in the statement returned is not stated in the suit scheduled property. ಮೊದಲೇ ಇರೋದು ಹಳೆ ಮನೆ, ಈಗ ಅದು ನಾನೇ ಆಕ್ಚುಲಿ ರಿಪೇರಿ ಮಾಡ್ಬೇಕು.
Issue notice stay of order dated 18/3/2025 passed by third additional civil judge JMFC Tumkur in OS number 459 of 2016 till next date of hearing.
Please.
Serial number 4, Ravi Kumar NR for petitioner JN Ravi.
Worship, I appear for the respondent number 1, Worship. I seek for a passover, Your Lordship. I will present at 2:30 physically, Your Lordship. Some difficulty now.
Yes, pastor. Yes.
Please.
Today is posted for the orders before the trial court at 4:30.
Yes.
Serial number 5, Pradeep GC.
Seeking a writ of mandamus, my lords.
Yes.
Suit for partition by the petitioner against his family members, being tenants in common, my lord. Suit was filed on 19/8/2024, my lords. Thereafter, they had filed caveat, my lords, but they were unavailable. Thereafter, I took orders from the court for special process server, and I have got the service summons served on February 2025, my lords. As of 7/3/2025, the pleadings are complete. So I pressed the court to hear the matter on IA number 1, not to alienate. What the court has adjourned the matter to June, my lords.
Where is that order sheet?
I produced order sheet at Annex A, my lords. The relevant page is at page number 24, my lords. On 7/3/2025, the defendants have filed the written statement.
No, when you have filed an application?
I have filed application along with the plaintiff, my lords.
Yes. Then what is the next date?
Next stage was for hearing on IA, my lords. 39/1 and 2. I had a very serious threat with regard to disposition.
Issue summons notice on IA caveat also to the other defendant. When they are appeared?
Yes, my lords. On 7/3/2025, they appeared. Page number 24, my lords.
7/3.
No, prior to that, 3/2/25, they have appeared.
Yes.
3/2/25, they have appeared. All the defendants have appeared. And on 7/3/2025, the defendants have completed their pleadings.
Yes. They have filed an objection to that.
Objections as well as written statement.
ಆಮೇಲೆ ಏನಾಯ್ತು?
ಆಮೇಲೆ directly the matter is, I sought for hearing on the matter on the very same day. The court has adjourned it to 12/6. My apprehension is, my lords, I sought for partition way back in the month of May 2025, that 24. That is the part of the pleading. Upon my claim, the defendants 2 to 4 being my brothers, siblings, and defendant number 1 being my mother, and I having derived the property in the year 2000.
Correct that by next date of hearing, they let them dispose of that application.
Lords, dispose of. Till then, what has happened, my lords? The nature, if the pleadings can be seen, non-claim madmel legal notice court mel property maritar. So before filing suit schedule property.
Where is the documents?
I have taken a plea, my lords. My plain pleadings also. Page number 33, my lords, para 7 of the plaint.
No, you have sought for only a mandamus. I will allow this petition.
Allow this petition, my lords. What happens? I'll move the matter on Monday, my lords. I'll make a application permission.
I will permit you to move that matter. preponing that matter.
I'll prepone the matter.
If court taken, yes.
Yes,
taken.
my lord, please, my lord.
Yes, in this writ petition, petitioner sought following relief. Petitioner plaintiff has filed a suit for partition. Along with that plaintiff, he has filed application under order 39 rule 1 and 2. When you have filed a
Same date, my lord, along with the plaintiff.
other date,
Annexure C, my lord, page number 41,
date entry,
page 45 with this one.
date entry,
19/8/2024 is the IA date.
19/8/2024
IA date. Suit is filed on
2024 has filed an application. The trial court by order dated 9/5/2024
7/3/2020
has issued a summons to that respondent. Thereafter, respondent has appeared on 3/2/2025. On next date, on 7/3/2025, they have filed an objection to that IA. The trial court has not passed any order on application filed by the plaintiff. The matter has been adjourned to 12/6/2025 to hear IA number 1. Learned counsel for the petitioner submitted that taking advantages of not granting any injunction order, the defendants are alienating that property. Hence, he sought for early disposal of the application. In view of the above, without expressing any opinion on the merit of the case, the plaintiff petitioner is permitted to advance the case by filing in a memo after intimating other side. The trial court is directed to dispose of that application on next date of hearing. It will be fixed by the trial court. Yes, in accordance with law, after giving notice to all the parties.
Serial number 6, Sampath A.
But this petition by the plaintiffs, my lord, they filed an application to production of documents. So that application was rejected. Annexure A is the order. Lord's the suit is for declaration injunction. Lord's the dispute is with respect to the survey number of the subject property. Lord, I stated, my lord, it belongs on survey number 31/C. Lord's in written statement at Annexure C, my lord, the defendant's written statement, page 31.
Suit for
declaration injunction against the respondent defendant, my lord.
Yes.
Lord, subject matter of property survey number 31/C.
Yes.
Lord,
What is that order you are challenging?
Lord, I wanted to produce certain POD documents that, my lord, the original number is coded into 31/C. Lord, that documents are rejected, that I moved a belated application. I'm filing it belated. Lord, because they are disputed, my lord, it's also stated the documents are manipulated. Page 31, my lord, Annexure C is the written statement of the defendant. Lord, they denied, my lord, the existence of the documents. Page 35, my lord, relevant portion. 35, my lord. In the written statement, running page 35, internal page 5, my lord. The bottom 12 lines, my lord. 31 verse 1C ಅಂತ start ಆಗುತ್ತೆ. Bottom 12 lines. ಅದಾದ್ಮೇಲೆ the original document was manipulated by way of forging serial number 31S 31/1C. So for this, my lord, I wanted to produce all the POD Atlas Tippani documents. The trial court rejected.
This stand is taken by you.
Please, this stand is taken by the defendant respondent. I am the plaintiff.
Oh, they said that you have.
These all forged and manipulated documents. Lord, I wanted to produce the document, my lord, by way of applications. The annexure, my lord.
When they have filed this tender? Now that written statement.
My lord, written statement, my lord, was filed, my lord, on quite long back.
6/9/19.
Please, my lord. My lord,
then
these
when-
documents, my lord, some documents were produced. My lord, these 4D documents, my lord, the council, my lord, was in a wrong, bona fide in belief that my lord, is also all were produced. When we are preparing the arguments, we'll notice that these important documents are not produced. RTC, other things are produced. My lord, this fact,
Where
my
is
lord,
that your application?
my lord, the application also find at annexure. E, my lord, is the annexure, my lord, for recalling the witness. Production document lordship find at annexure. E2, my lord, page 45.
E2.
Please, my lord, page
Yeah.
45. Your certified copies of survey records.
Show me that what is the reason you have given.
Plus reason, my lord, at page 46. Documents, my lord, para 3. My lord, I stated that, my lord, I pleaded about the body, everything.
No, why 2019 you have come to know that there is an allegation against you that you have manipulated.
Please, my lord, but it really.
And after that, 6 years you have filed an application.
Plus,
What is the reason you have to be
The
sure?
reasons, my lord, that these documents were not available for that time. And my lord, is also one mistake from the
ಯಾವಾಗ
council.
ಅವೈಲೇಬಲ್ ಇಲ್ಲ ಯಾವಾಗ ಸಿಕ್ತು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಹಂಗೆ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದಲ್ಲ.
ಇಲ್ಲ ಇದರಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ some junior calling, my lord, is not filed some documents.
These are all the application which are filing after 9 years, 5 years.
But my lord, this is a crucial document. I still deposit, my
If
lord.
there any law show that just because juniors has been filed that delay.
Let's even I don't, my lord, I accept that, admit.
Yes.
But my lord, I shall deposit cost of 10,000 because these are crucial documents. Because they are disputed.
What is the suit for?
Declaration, my lord. I'm saying that I am the owner based on the sale deed. My lord, survey number they were disputed.
Where is the property situated?
My lord, situated in Nelmangla, my lord.
Situated?
At Nelmangla, my lord, the plaint lordship find at annexure.
Is all you deposit 25,000 rupees.
15,000, my lord, I shall deposit.
Or issue notice. Stay of further proceedings in OS number 589 of 2018 pending in the file of Senior Civil Judge Nelamangala. Subject to condition, petitioner has to deposit 25,000 rupees before this court. 20,000 rupees before this court within 2 weeks.
Deep low.
Bill number 7, Satish SP.
Petitioner, my lord, it's a suit for injection, bare injection, my lord. I made an application for appointing of the commissioner. The same was rejected by the Honorable Trial Court. My lord, see, I purchased the
Suit for injunction.
injection.
Why do you
permanent
want to
injection.
appoint a commissioner?
So regarding that, this defendant taken the contention that
What is application?
as per the annexure D, my lord.
Annexure D.
That ink page number 27. my
May please to appoint a commissioner for spot investigation on the memo of instruction that they may file by the parties to the suit by. Why the spot inspection, Mr.?
My lord,
For injunction ಅಲ್ಲಿ ಏನ್ spot inspection?
ಅಲ್ಲ ಏನಾಗಿದೆ ಅಂದ್ರೆ ನಾನು 2 ಸೈಟ್ ನ ಕೊಂಡ್ಕೊತೀನಿ ಸ್ವಾಮಿ, ಡಿಫ್ರೆಂಟ್ ಡೈಮೆನ್ಷನ್. ಇದರಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಅವರು OS ನಂಬರ್ 471 ಆಫ್ 1996 ಅಲ್ಲಿ ಒಂದು ಸೈಟ್ ತಗೊಂಡಿದ್ದಾರೆ. ಅದ್ರದ್ದು ಡೈಮೆನ್ಷನ್ 20 into 25. ಇದರಲ್ಲಿ ಒಂದು ಸೈಟ್ ಅದೇ ಸೈಟ್ ಅಂತ ದೇ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಟೇಕ್ ಅನ್ ದಿ ಕಂಟೆನ್ಷನ್. ದೇ ಆರ್ contending that the res judicata will apply on this suit, my lord.
What is the order passed by the trial court? Reasoning.
As per the annexure.
Reasoning in
Annexure F, my lord.
defendant in the instant para 11.
Reasoning.
In the instant case.
Yes, my lord. Instant, the plaintiff seeking the relief of permanent injunction in respect of the suit scheduled property. The perusal of the order sheet and other document available on record, it is observed that the evidence of both the parties is not yet completed. It is a well settled position of a law that court commissioner is appointed for the purpose of local investigation only when there is an ambiguity. In this case, it is sought for appointment of commissioner for the identification of the suit scheduled property. In such a situation, if the court commissioner is appointed, it amounts to collection of evidence, and for that purpose, Appointment of court commissioner for ascertaining the identity and position of the plaintiff in the suit scheduled property is prohibited. The plaintiff has to prove the fact regarding the identification through the independent evidence, and the plaintiff cannot collect the evidence through the court by appointing commissioner. The aim of the appointment of commissioner is not to collect evidence, but to secure the evidence for enlightening the matters which are local in nature, which is discretionary. Moreover, the present suit is still the stage of plaintiff evidence. So I am of the opinion that if the court commissioner is appointed to identify the property, certainly amount to collection of evidence, which is directly related with the matter of position. If the report obtained at this stage, the amount to collection of evidence, and it will not elucidate the matter in dispute. So under the facts and circumstances, I am of the opinion that there is no ground for the appointment of commissioner for the purpose as prayed by the plaintiff, and so answer the point number is negative, my lord. See what is the
Further proceedings in OS number 507 of 2015, pending in the file of 5th Additional City Civil Judge JMFC Shimoga till next.
Serial number 8,
Obliged,
K.V.
ma'am.
Narasimhan, petitioner Dinesha E.P.
I appear for the petition. The petition is by the defendant.
Yes.
My lord, the grievance is, my lord, one is grant of the police protection order, and second is, my lord, not considering of my stay application by the MA court, where, my lord, my miscellaneous appeal is filed. My lord, it so happens, my lord, a suit for permanent injunction is filed against me.
Yes.
My lord, the trial court grants an order of temporary injunction. My lord, on 19th of December 2023. My lord, I immediately challenged before the miscellaneous appellate court. My lord, the notice is, my lord, ordered at the first instance. My lord, the plaintiff, my lord, evades the service of the notice in the MA proceedings. My lord, I take a fixture. My lord, the affixture is permitted, and thereafter, my lord, he enters appearance and files wakalat. Thereafter, my lord, he keeps on taking adjournments, my lord, for filing the objection to my stay application.
Yes.
Now, my lord, that miscellaneous appeal is still pending, and it is posted on 24/4/2025. In the meantime, what he does is, my lord, he goes before the trial court and files an application for police protection. I say that my miscellaneous appeal is being filed, is pending. Now, kindly defer it because it will have a bearing on it. Now, my lord, on one instance, my application is not being considered.
Yes.
No orders are being passed. On the other hand, my lord, police protection has been granted.
Yes.
That is the two orders, my lord, that I am challenging.
Which are the two orders?
My lord, one is, my lord, the miscellaneous appellate court order, my lord,
That matter.
page number 45.
Yes.
My lord, that is where the notice was ordered at the first instance.
Yes.
Now, 4/3/2024 notice is ordered.
Now, what is that next date?
My lord, the next date is 24/4/2025.
24/4/2025. I will direct to dispose of that.
Dispose them in the meantime, my lord, till such a exercise is done. Let this be kept in abeyance, my lord.
No, it cannot be. It will be disposed of on that day. If I say that, then notice has to go to other side. I can't
There
pass
is
an
a caveator now.
Where is that
No,
caveator?
he has not come now.
Who is caveator?
Serial number 8, Dinesha E.P.
ಅವ್ರು ಇದ್ದಿದ್ರೆ ಮಾಡ್ಬೋದಿತ್ತು. Where is he? You get him?
Please.
Get him?
Pass on.
Yes, pass.
Serial number 9, Mohan Kumar N.
Petitioner Milan. This is third defendant's writ petition. The suit for relief of partition and separate possession. The evidence was commenced. At the time of leading my evidence that I filed an application under order 8 Rule 1A for production of the documents. These are all the certified copies of the sale deeds. But in the application, my lord, that the reasons has not been assigned, that why it is the relevant. But these documents, my lord, that the properties were sold in respect of sir number 163. And out of these sale proceeds, the other suit schedule item number 1 is acquired. It is my specific contention in the defense.
Yes.
That in other aspect, my lord, the other sale deed has been already allowed.
Yes.
And they are marked. But in this application, my lord, that since I have not mentioned the reasons, that the respondent number 2, that the defendant number 2 has objected for it. So therefore, the trial court has rejected my application for production of the documents.
Where is that?
That annexure A, my lord, that I have put at the time of evidence only that I have produced. Suit for partition and separate possession.
You are the
That I have set up a counterclaim in the said suit
What is that, your self-acquired property?
No, that I am also entitled for a share because they have set up the will and other things, my lord. Therefore, that I am claiming that I am also one of the sharer that are entitled.
Where
That the
is that
defendant
order?
number,
Impugned order.
the impugned order at annexure A at page, my lord, that 20. That the
By the right of producing the document mentioned in the list. Where is the reasoning? Yes, read.
the may I read, my lord?
Yes, read.
In the affidavit supported by the application, page 20, my lord.
Yes, page 20, second para.
Second paragraph. The counsel for the plaintiff submits no objection to allow the application because that it's my counterclaim.
Yes.
The plaintiff has said no objection. On the other hand, the counsel for defendant number 2 has filed objection statement and submits that the application is not maintainable on account of inordinate delay. The defendant number 2 submits that the defendant number 3 has filed the present application after lapse of 11 years from the date of suit and also not assigned valid reasons for delay in filing the application. Further, it is submitted that if the application is allowed, then the same will cause prejudice to the rights of the defendant number 2. It is submitted that the defendant number 3 has made the present application to protect the proceedings and therefore prays to dismiss the application. On perusal of the materials and records and application, it is the specific contention of the defendant number 3 that he has procured the proposed documents very recently and therefore he has made the application. It is observed that the defendant number 3 has produced 34 certified copies of various registered sale deeds. However, it is observed that the defendant number 3 in his application has not assigned valid reasons for delay in making the present application. And furthermore, important thing that the defendant number 3 has not whispered single word as to how the proposed documents are relevant for the proper and effective adjudication of the case. Therefore, the court is of the view that if the application is allowed, which is filed by the defendant number 3 after lapse of 11 years from the date of suit, that too without assigning valid reason for delay and as to the relevancy of documents will certainly produce.
What is the reason you are given?
The reason, my lord, that of course I have not assigned, but if that is, my lord, that I may permitted to withdraw this application to file a fresh application with a valid reason because these documents, my lord, are very relevant because it is my specific contention that out of these sale proceeds, the present social item number 1 is.
These are all that one more.
Of course, my lord, that in the application to annexure H, my lord, that it is G. Of course, that the very bald application is filed, but there is no. But if that is so, my lord, that I may permitted to withdraw this application with filing.
No, that still was your file delay in filing the application for dragging the matter.
No, that
now you have already dragged.
No, it is not that dragging, my lord. At the time of my leading evidence, I have produced. It is not that I have produced it after because
when you filed an application,
that I filed an application annexure G on 30/11/2024. 24. Will also may kindly peruse the order sheet. Peruse the order sheet.
Permitted to file another application. Then again, 1 year will be taken.
No, it will not be. If I assign the reason, my lord, that the court may consider my
application. That doesn't mean that reason should be proper.
The reasons, my lord, that this is.
You don't have any reason in the first instance.
No, the first instance that all these certified copies are obtained very recently because I am not aware about the registration numbers and all other things. So that in the application it is not stated.
delay application documents
No, it is not with regard to that. You will also may kindly say that the evidence was commenced when the matter was posted for defense evidence. At that time I have filed. It is not
when it is posted for defendant's.
The defendant's evidence, my lord, that defense evidence. The others have already adduced evidence 1 and 2 that I have cross-examined, and thereafter it is 1 minute.
I do take notice.
Please
take it. Hand summons. Yes.
I will take hand summons.
Yes.
That it's on 2/8/2024.
In addition.
2/8.
Also permitted to take out hand summons to the respondents. Yes.
Serial number 10, Manjunath Prasad V.
The case is set down tomorrow. my lord.
Pass over, yes.
The case is set down on
Let
19th.
us take, you take hand summons.
Please.
And move that matter, yes.
Serial number 11, T.N. Vishwanatha.
Yes.
First respondent is the appeal has filed this writ petition, my lords. When the first respondent filed a eviction suit, eviction suit was decreed. And Chikkashettappa, that is the husband and father of different number 30, respond number 2 to 9 was tenant. Subsequent to the death of Chikkashettappa, the LRs continued as tenant. Now, this first respondent is one R. Sinappa is none other than the brother of Chikkashettappa. He has no right over this property, and the suit has been decreed. Thereafter, the other LRs of Chikkashettappa have not filed appeal, and this the respondent number 1 has filed appeal before the questioning the judgment and decree passed by the trial court, and that there was a delay and also an application for stay. The trial court, without noticing, at the first instance, without condoning the delay, grants ex parte interim stay of decree. Then I filed an application along with an objection stating that the IA has to be heard first, IA number 1 for condonation of delay, and thereafterwards the order has to be to consider the interim application. The trial court, instead of considering the application, now annexure A may kindly be seen, please, Lords. That is 5th of February 2025, the order has been passed. When IA2 filed by so-and-so is hereby, appellant defendant number 9 is hereby allowed by staying the suspending the operation of the judgment and decree. Now, may I take lordship to order 41 rule 3A may kindly be seen, please.
What is that?
That before, when there is a delay,
Yes.
that the appellate court has to consider the question of delay and then that has to proceed. So in the instant case, admittedly, there was an application. That application has not been considered. Straight away decides IA number 2.
Where is that order sheet?
Which order sheet may kindly be seen at page number, one second.
Yes.
At page number 112, please, man. 113 is the order sheet. There is a note that is.
Where is that note?
First, your lordship kindly see the second page, Limitation Act, IA number 1, bottom of the page number 113, please.
Yes, 113.
Bottom, IA number 1, but 2025, Limitation Act 5.
IA number 1.
IA relief, that for the reasons mentioned in the accompanying affidavit of the appellant, this
Here order sheet ಅಲ್ಲಿ IA number 1 ಗೆ ಏನಂತ notice ಮಾಡಿದಾರೆ ಏನ್ ಮಾಡಿದಾರೆ ಏನಿಲ್ಲ
ಏನಿಲ್ಲ ಅಷ್ಟೇ the heard on IA number 2, that's what next on 6/1/2025 heard and thereafterwards posted for orders. Then IA number 1 ಮೇಲೆ in the affidavit so and so
ಏನು ex parte ಮಾಡಿದ್ರಾ
ex parte order ಕೊಟ್ರು
ಆಮೇಲೆ ನೀವು appear
ಆಮೇಲೆ then I appeared and then I filed objection to both the applications. But instead of considering IA number 1, now passes orders on IA number 2.
Now final order has been passed on.
Not final order. Now further proceedings has been stayed. The judgment decree has been suspended.
No, that's final order has been passed on that IA.
Final order was passed on that IA. That's IA number 2.
Yes. Heard. Issue notice. Stay up. Order dated 5/2/2025. You sought for further proceedings. Why further proceedings? Let that appeal may go on. Stay of interim order dated 5/2/2025. Passed by First Additional Senior Civil Judge CJM Kolar in area number 2 of 2025. Till next date of hearing. Yes.
And fix a date, please. Date may be fixed, so that
let notice go and come.
No, that's what date may be
Why
fixed. So
that their appeal? Why do you worry? They will come. That if order is stayed, they will come. Yes,
please.
Serial number 12, Kavita HC.
Yes. Yes.
Petitioner in this matter, my lord, he had entered into a compromise with his father and his mother and his brother, my lord, in a partition suit.
Yes,
That is as per Annexure D, my lord.
yes.
My lord, in that 4 acres of property was agreed to be given up by the family members, that is his father, brother and mother, to the petitioner, my lord. 4 acres of property was in survey number 12, my lord,
Yes.
of Gavalkatte Grama was agreed to be given up in favor of the petitioner in this suit and partition suit, and compromise decree was entered into as per Annexure D, my lord.
Yes.
This very same property, my lord, was made subject matter of another partition suit, my lord, between his father, his aunt, his uncle, and his cousin, my lord.
Yes.
That is Annexure A.
Yes.
Without arraying petitioner as a party in this suit, my lord. This is also a partition suit. The very same property which was agreed to be given up in favor of the petitioner in the earlier suit as per Annexure D,
Yes.
wherein the compromise decree was entered into between his father and the petitioner and his family members, my lord.
Yes.
That very same property, without arraying petitioner as a party in the another suit, my lord, petitioner was not made aware of this suit, and a compromise decree was entered into as per Annexure A, my lord. That is what is challenged before your lordship, my lord. Because
Where compromise has been entered.
Annexure A, my lord. Annexure A is the compromise, my lord. And the
Compromise petition drawn finally.
Yes.
Now that against that writ is not maintainable.
My lord,
You have to file an application before the same court.
my lord, I have, my lord, I have, but what I'm that is not an efficacious remedy.
No, no, the Supreme Court said that you have to be file an application before the same court.
My lord, what I'm saying, my lord, because the court below, my lord, has erred, my lord, they ought to have issued notice to me as a party interested
See,
under Order
Supreme
23
Court
Rule
said
3B.
Compromise petition has to be, now that under Order 23 Rule 3A suit
Yes.
is barred.
Yes,
Therefore, application has to be filed before the same court, even the stranger, application has to be filed before the same court, either application or review.
please, my lord. I have, my lord.
Because that court has knows under what circumstances compromise has been entered.
My lord, my submission is, my lord, the court, my lord, has
You go
erred.
on before the same court and file an application.
I have, my lord, there is a miscellaneous application. All I'm seeking is, my lord, because I want to urge, my lord, that under Order 23 Rule 3B, my lord, as a party interested, I ought to have been issued notice.
That is
my
what
lord,
that
as
you
a
have
party
a right now.
interested.
Party interested having a right has to file an application.
And my lord, no, this error has happened by the trial court, my lord.
No, that Supreme Court judgment is there. If you want, I will consider and pass an order on that.
Yes, my lord. My lord, what I'm.
Not there something other. Yes,
My lord, in that miscellaneous petition,
except if that compromise is entered in that Lok Adalat, writ is maintainable.
this is not in the Lok Adalat.
It is
This
a
is in the
civil
court, my lord.
Then you
But
have to
the
go
court,
because
my lord,
Lok Adalat proceedings, it is, there is no further appeal is provided, only that they said.
the court has erred in not recording the
All that will be
its
considered
agreements,
there.
my lord.
Yes.
Its leave ought to have been recorded. Court ought to have recorded its leave, my lord. Saying that I'm permitting the parties to enter into a compromise by issuing notice to all the parties interested, which has not happened in this case, my lord.
That fresh suit is not maintainable. One more judgment is that 20. Yes,
My lord,
that's all.
yes, my lord. Annexure K, my lord, that miscellaneous
No, that's-
petition, which is
you-
already pending
I will
before.
give a liberty, go and approach same
Yes, my
court.
lord, I have, my lord. Annexure K is the miscellaneous petition. My lord may direct the court below to dispose of this miscellaneous petition in an expeditious manner. It has
No.
been
What is that miscellaneous petition?
to recall the
You have
compromise.
already
decree.
approached that.
Yes, my lord, I have, my lord. I've disclosed that in my petition also.
Now,
But
where
it
is
is
that, where is that application?
Annexure K, my lord.
Annexure?
K,
Yeah.
K. Annexure K, my lord. Because my alternative prayer, my lord, my alternative prayer may please
Yes,
be
yes.
seen, my lord. Direction, directing the,
Now, what is the stage there?
my lord, there it is inquiry anta hogta ide swami.
Your bond. So, where is that application you have filed?
Application, my lord, my lord, I have produced the order sheet of the
Order sheet is
court
there.
below.
Under which provision you have filed
But
there?
this miscellaneous,
Yes, thirdly. In this writ petition. Petitioner. Sought for direction. The principal civil judge CJM Hassan to dispose of miscellaneous petition 38 of 2023. As expeditiously as possible. The petitioner, the net counsel appearing for the petitioner has submitted that the respondent herein, without making petitioner as a party, even though petitioner has interest in that suit scheduled property,
and already, my lord, that property is agreed to be given up in favor of the petitioner in an earlier suit.
yes, you are interested in that such.
Yes.
Yes. Without making petitioner as a party in OS number
OS number 292,
292 of 2023 and matter was compromised and the compromise degree was been passed on. What is the date, madam?
my lord, 10/8/2023.
10/8/2023.
24/8, my lord. 24/8/2023.
24/8/2000.
2023.
ಮತ್ತೆ ನೀವು ಫಸ್ಟ್ ಪ್ರೇಯರ್ ಏನ್ ಕೇಳಿದ್ರಿ ಅಲ್ಲಿ?
My lord, first prayer is the quashing of,
10/8/2023 ಕೇಳಿದ್ರಾ?
my lord, there in the order sheet, it says decree of defendant number 2 on 24/8/2023 on the
Then
left
see
hand side.
your prayer, madam.
Yes, my lord.
Hmm,
Actually, order, as per order sheet, it is 10/8/2023, my lord. As per order sheet. But ಕೆಳಗಡೆ final decree of defendant number 2 is drawn up on 24/8 ಅಂತ ಇದೆ.
ಯಾವ್ದನ್ನ ಕೇಳ್ತಾ ಇದ್ದೀರಾ ಮತ್ತೆ?
10/8 ಅಂತ ಹಾಕ್ಬೋದು.
Yes, on 10/8/2023. Therefore, petitioner has filed a miscellaneous petition before the principal senior civil judge CJM in miscellaneous number 38 of 2023 for set-asiding that compromise petition passed in OS number 292 of 2023.
May I pass on the miscellaneous application?
Yes, the same has been filed on. Correct provision alla ಹಾಕಿದೀರಾ ನೀವು ಮತ್ತೆ ಸುಮ್ಮನೆ ಚಾಲೆಂಜ್
ಇಲ್ಲ, alternative, this is an alternative prayer, my lord.
11/9/2023.
I've sought the alternative prayer.
Till today, no order has been passed. Hence, she sought for early disposal of that miscellaneous petition. In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to dispose of that miscellaneous petition, miscellaneous 38 of 2023, as expeditiously as possible, not later than 1 year from date of receipt of copy of this order. Yes.
Obliged.
Cell number 13 adjourned, cell number 14 Suppareddy KL.
Yes.
Matter where your lordships had, similar matter, your lordships had passed an order of stay. That was as against the application of amendment. Now, my lords, this application is on the impleading application and WP has been preferred. This matter has to be connected along with that matter, my lords.
Yes. Issue notice. Call this matter along with its own.
WP number 1767 of 25.
Yes.
Serial number 15 Vijay Prakash BR.
Appear per the petitioner, my lord. Plaintiff is petitioner, my lord.
Yes.
Suit for permanent injunction filed by my lord. At the time of evidence completion, my lord. Defiant number 4 filed by the 26 rule 10 applicant, appoint the court commissioner applicant. That application is allowed, my lord. This cross examination yearly. Suit for permanent injunction, my lord.
Yes.
After completion of the evidence, my lord. Defiant number 4 filed the application 26 rule 10.
For what?
For appointment of surveyor, my lord. To appoint this survey sketch and to produce, my lord. That application is allowed.
ಆಯ್ತು ಬಿಡಿ ನಿಮ್ದು ಸೂಟ್ ಫಾರ್ ಇಂಜೆಕ್ಷನ್ ನಿಮಗೆ ಅನುಕೂಲ ಆಯ್ತಲ್ಲ ಸರ್ವಿಸ್
ಅವರೇ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕ್ಲಿಯರ್ಲಿ ಅಡ್ಮಿಟೆಡ್ ಮೇಲಾಡ ಅವ್ರಿಗೂ ನಮಗೆ
stated in that affidavit it is made this honorable court may please to allow this application and appoint suitable survey commissioner to show the location of the plaintiff's site and house property and the defendant Anjaneya Swami temple properties are situated and between the defendant and the plaintiff's house. The site is ಆಯ್ತು ಪ್ರಾಪರ್ಟಿ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾಡ್ತಾರೆ ನಿಮಗೇನು ಅದ್ರಲ್ಲಿ ವಾಟ್ ಇಸ್ ದ ಪ್ರಾಬ್ಲಮ್ ಯು ವಿಲ್ ಆಲ್ಸೋ ಗೆಟ್ ಬೆನಿಫಿಟ್ ಮಿಸ್ಟರ್ ಇಸ್ ಇಟ್ ನಾಟ್ ಇಫ್ ಇಟ್ ಇಸ್ ಡಿಮಾರ್ಕ್ಡ್ ಅಂಡ್ ಯುವರ್ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ಶೋನ್ ಯು ವಿಲ್ ಗೆಟ್ ಎನ್ ಇಂಜೆಕ್ಷನ್ ಆರ್ಡರ್
ಎಕ್ಸಾಮಿನೇಷನ್ ಇಯರ್ ಕ್ಲಿಯರ್ಲಿ ಅಡ್ಮಿಟೆಡ್ ಮೇಲಾಡ ನಾವು ಅವ್ರು ಯಾವುದೇ ಪ್ಲಾಂಟಿಫ್ಗೂ ನಮ್ಗೇನು ಸಂಬಂಧ ಇಲ್ಲ ಅಂತ ಅವರೇ ಕ್ರಾಸ್ ಒಪ್ಕೊಂತಾರೆ.
ಈಗ ಪ್ರಾಪರ್ಟಿ ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ರೆ ನಿಮಗೆ ಇನ್ನೂ ಒಳ್ಳೇದಾಯ್ತು. ವಾಟ್ ಇಸ್ ದಟ್ ರೀಸನ್ ಗಿವನ್ ಬೈ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಪೇಜ್ ನಂಬರ್ 15
examination admitted that so and so submitted it in this stage the commissioner appointment is necessary about any document and connection to that reason not given in application for the different days. There is no absolute bar. It is not the business of the court to collect the evidence in favor of the party. Advocate commissioner wanted to gather the evidence.
Para number page number 15.
No, this is where is your order?
My order in page number 15, my lord. 15 in para number. The land council for the plaintiff submit that the objection contained defined number has also right no interest of suit schedule.
Interest or suit schedule property there is no
Counted.
application.
And clear in admitted different witnesses have admitted position of the plaintiff.
For evidence completion portrait and careful perusal of the petition, it is important to note that defendant has disputed the measurement of the property and the plaintiff has completed the house without leaving any space in claiming that belongs to the Anjaneya. Therefore, it is appears that reason correct ಕೊಟ್ಟಿದ್ದಾರೆ. That's all. ಐಡೆಂಟಿಫೈ ಮಾಡ್ಲಿ ಬಿಡ್ರಿ ನೀವು ಟೆಂಪಲ್ ಲ್ಯಾಂಡ್ ನಿಮ್ಮ ಇದೆಯಾ ನಿಮಗೆ ಅವ್ರದ್ದು ಹೋಗಿದ್ಯಾ ಅಂತ ದೆನ್
ನೀವು ಸೆಂಟ್ರಲ್ ಸಿಸಿ ಸಿಮೆಂಟ್ ರೋಡ್ ಇದೆ, ಗ್ರಾಮ ಪಂಚಾಯತ್ ರೋಡ್ ಇದೆ.
that is why that they are appointed to identify whether this road is belongs to that suit scheduled or not. I tell in this petition is filed by plaintiff challenging order dated 23/7/2024 passed by additional civil judge JMFC Pavgada, whereby IN number 18 filed by the defendant under order 26 rule 9 CPC in OS number 254 of 2015 was allowed. Plaintiff has filed a suit for bare injunction. On service of summons, defendant has appeared through counsel and filed a written statement. On the basis of the pleadings of the parties, trial court has framed the issues. Matter has been shut down for evidence of the parties. After completion of the evidence, The defendant has filed an application for appointment of the court commissioner. Since the defendant has disputed the measurement of the properties of the plaintiff and contended that plaintiff has constructed his house without leaving any space and is now claiming that land belongs to that Sri Anjaneya Swami temple. After going through the evidence of the parties, the trial court is of the opinion that for the limited purpose for determining the location of the suit scheduled property, appointment of the commissioner is necessary. Appointment of the surveyor is necessary. And the same will be helpful for the court to pass in a judgment and degree. Therefore, the application for appointment of surveyor has been allowed. There is no error or illegalities in the order passed by the trial court. Accordingly, the writ petition is dismissed.
Serial number 16, Somashekhara RP for Governor, A.V. Gangadharappa.
In this case, Malad,
Yes.
yesterday, ಅದು ಡಿಗ್ರಿ ಇದು small piece of land, we have secured the records, permitted to.
You report.
ಅದೇ report.
What?
ಒಂದೇ ಮಾಡಿಸಿದ್ದು.
ಎಲ್ಲಿದೆ ಯಾರ್ಯಾರಿಗೆ ಹೆಂಗೆ ಅಂತ ಕೊಡಿ.
Malad, page number 65, Malad. Page number 64. ಒಂದು ಕಾಲ್ ಕುಂಟೆ ಆಮೇಲೆ ಎಲ್ಲರಿಗೂ ಸೇರಿ 6 ಕಾಲ್ ಕುಂಟೆ ಅಂತಾರೆ. ಇಲ್ಲಿ ಡಿವಿಷನ್ ತೋರಿಸಲ್ಲ ಟೋಟಲ್ ಆಗಿ. 64 ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 34 ಅಲ್ಲಿ. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಸರ್ವೆ ನಂಬರ್ 103 ಒಂದು
ಸರ್ವೆ ನಂಬರ್ ಪೇಜ್ ನಂಬರ್ 64.
64.
ಏನಿದೆ 64 ಅಲ್ಲಿ?
64 ಅಲ್ಲಿ ಇಲ್ಲಿ ಡಿವಿಷನ್ ಎಷ್ಟೆಷ್ಟು ಭಾಗಾಂಶದಂತೆ ಹೆಸರು. ಒಂದು ಕಾಲ್ ಕುಂಟೆ ಆಮೇಲೆ 6 ಕುಂಟೆ ಅಂತ ಎಲ್ರಿಗೂ ತೋರಿಸ್ತಾರೆ. ಎಷ್ಟೆಷ್ಟು ಅಂತ ಇದು ಮಾಡಲ್ಲ. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ 65 103 1.5 ಕುಂಟೆ
ಭಾಗಾಂಶದಂತೆ ವಿಸ್ತೀರ್ಣ.
ಒಟ್ಟು
ಇದು ಯಾರೋ ಒಬ್ರೊಬ್ರದ್ರಿ ಬಸವನಹಳ್ಳಿ ಹೋಬಳಿ ಗಂಡಸ ತಾಲೂಕು ಹೊಸೂರು ಜಿಲ್ಲೆ ಡಿಗ್ರಿ ಆದೇಶದಂತೆ ಅಳತೆ ಮಾಡಿ ಕೊಡಿ.
ಇದರಲ್ಲಿ ಎಲ್ಲ ಅರ್ಧ ಗುಂಟೆ ಕಾಲ್ ಕುಂಟೆ ಬರ್ತವೆ ಎಲ್ಲ ಬೇಕು. ಪ್ರಿಪೇರ್ಡ್ ದಿ ಟೈಪ್ಡ್ ಕಾಪಿ ಆಫ್ ಇದು. ಇದರಲ್ಲಿ ಯಾರ್ಯಾರಿಗೆ ಎಷ್ಟೆಷ್ಟು ಬರ್ತೈತೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅದ್ರ ಪ್ರಕಾರ ಅಷ್ಟೇ ಬರ್ತೈತೆ. ಅರ್ಧ ಗುಂಟೆ
ಅಷ್ಟೇ ಇರೋದು ಅಷ್ಟೇ ಬರ್ತದೆ.
ಅಲ್ಲ, ಅದು ಭಾಗ ಬರೋದು. ನಾವೇನ್ ಹೇಳೋದು, ಒಂದ್ ಕಡೆ ಕೊಟ್ಬಿಡ್ತೀವಿ. ಸೆಕ್ಷನ್ 2 ಆಫ್ ದಿ ಪಾರ್ಟಿಷನ್ ಆಕ್ಟ್ ಮೆಲಾಡ್.
ನೀವು ಎಷ್ಟು ಜನ ಇದ್ದೀರಾ?
ಒಟ್ಟು
1/7 share has been
1/7 7 ಜನಕ್ಕೆ 7 ಜನ. ಅದರಲ್ಲಿ ಪೀಸು ಸಿಗಲ್ಲ
ಅಲ್ರಿ. ಇದ್ರಲ್ಲಿ ಯಾರ್ಯಾರಿಗೆ ಯಾವ್ದಾವ್ದು ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? ಏನ್ ಹೇಳಿ
ಇಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಇವರಿಗೆ ಒನ್ನೇಗೌಡಂಗೆ 1 ಕಾಲ್ ಕುಂಟೆ. ಇದು ಪೇಜ್ ನಂಬರ್ 64 ಮೆಲಾಡ್. ಪೇಜ್ ನಂಬರ್ 64 ಅಲ್ಲಿ ಒನ್ನೇಗೌಡಂಗೆ 1 ಕಾಲ್ ಕುಂಟೆ. ಅದು ಒಟ್ಟು 9 ಕುಂಟೆ ಇರೋದು. ಡಿಗ್ರಿ ಅಂತೆ ವಿಸ್ತೀರ್ಣ.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಅಂತ ಹೇಳಿಲ್ಲ.
ಸರ್ವೆ ನಂಬರ್ ಹೇಳಿದ್ದಾರೆ. ಸರ್ವೆ 34 ಈ ಕಡೆ.
ಸರ್ವೆ ನಂಬರ್
34
34 ಅಲ್ಲಿ.
ಆಮೇಲೆ ಡಿಗ್ರಿ ಅಂತೆ ವಿಸ್ತೀರ್ಣ 9 ಕುಂಟೆ.
ಅಲ್ರಿ, ಸರ್ವೆ ನಂಬರ್ 34 ಇಶ್ಯೂ ನಂಬರ್ 1.
ಹೌದು. ಇದರಲ್ಲಿ ಡಿಗ್ರಿ ಅಂತೆ ವಿಸ್ತೀರ್ಣ ಅಂತ
5ನೇ ಅಂತೆ ವಿಸ್ತೀರ್ಣ
9 ಕುಂಟೆ. ಅದನ್ನ 1 ಕಾಲ್ ಕುಂಟೆ ಒನ್ನೇಗೌಡ, 1 ಕಾಲ್ ಕುಂಟೆ ನಂಜುಂಡಪ್ಪ, ಇನ್ನು 6.5 ಕುಂಟೆನ ಈ ಎಲ್ರಿಗೂ ಹೇಳ್ತಾರೆ. ಯಾರ್ಯಾರಿಗೆ ಎಷ್ಟೆಷ್ಟು ಅಂತ ಹೇಳಲ್ಲ. Therefore, we have made application.
That report which my learned friend is relying upon is the report submitted by the court commissioner during the pendency of the FTP proceeding. That they participated in the Commissioner Warrant, my lord. In spite of their participating, they did not sign the report. And my lord, they did not file any objection before the FDP court. But on the basis of the report submitted by the court commissioner, the FDP court has passed the final decree. Now at this stage, my lord, when
Final degree is passed.
Final
Please,
decree is passed.
based on
against
that,
which
my lord,
matter
I have
preferred
filed the
appeal.
execution petition.
Appeal is.
My lord, in the execution petition, the petitioner wanted to the trial
FDP proceedings ಎಲ್ಲಿ ಇದೆ ಕೊಡಿ copy.
annexure A, my lord, the decree passed by the
I
FDP
produced
proceedings.
annexure A is the final decree proceedings, my lord. Against
ಇದ್ರಲ್ಲಿ
which
ಏನು
appeal is
ಭಾಗ
filed,
ಕೊಡಿ?
my lord.
ಇದ್ರಲ್ಲಿ ಭಾಗ ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ?
Page number 17.
The commissioner report 5/123 filed by the court commissioner and 40 sketches annexed to this report shall form part and parcel of the final decree. Adunna nani produce, this is challenged by me by filing appeal, raising the similar contention, my lord. My lordship, page number 19, my
ಏನಾಯ್ತು?
lord.
ಅಪೀಲ್ ಏನಾಗಿದೆ?
Appeal ಅಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ.
ಮತ್ತೆ ಅಲ್ಲೇ ಹೋಗಿ ಸ್ಟೇ
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ. ಆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆದಾಗ ಇಮಿಡಿಯೇಟ್ಲಿ ದೇ ಫೈಲ್ಡ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ
go and ask that appellate court that now they're
no, my lord, in the execution proceedings, my lord, I have filed application instead of dividing the property, sale ಮಾಡಿ. ಇಲ್ಲ ಯಾರಿಗಾನ ಒಬ್ರಿಗೆ ನಾವು ಒಂದ್ ಕಡೆ ಎಂಟೈರ್ ಎಕ್ಸ್ಟೆಂಟ್ ಅವ್ರಿಗೆ ಏನ್ ಬೇಕೋ ಈಗ 10 ಗುಂಟೆ ಅವ್ರಿಗೆ ಬರ್ತೈತೆ ಅಂತೆ ಒಂದ್ ಕಡೆ 10 ಗುಂಟೆ ಕೊಟ್ಟು ಬಿಡ್ತೀವಿ ನಾವು.
ಅವರು ಒಪ್ಕೊಂಡ್ರೆ ಪಾರ್ಟಿಗಳು ಮಾಡಬಹುದು. ನಿಮಗೆ
ಹೌದು.
ಹಾಕಿದೀರಾ?
ಇದು ಪಾರ್ಟಿ ಡಿವಿಷನ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ ನಮ್ದು.
ನೀವು ಅಪೀಲ್ ಹಾಕಿದೀರಾ? ಅಪೀಲ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಸ್ಟೇ ಕೇಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಆರ್ಡರ್ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿದ್ರೆ ನಮ್ ಅಪೀಲ್ ಬಿಕಮ್ ಇನ್ಫ್ರಕ್ಸಿಯಸ್ ಅಂತ ಗೋ ಅಂಡ್ ಆಸ್ಕ್ ದ ಸ್ಟೇ ದೇರ್.
ಅಲ್ಲ ಅಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ. ಅಲ್ಲಿ ಪ್ರೆಸೈಡಿಂಗ್ ಆಫೀಸರ್ 3 ಸಲ ಚೇಂಜ್ ಆದ್ರು. ಅಲ್ಲಿ ನಮ್ಗೆ ಸಿಟ್ಟಿಂಗ್ ಸಿಗ್ತಾ ಇಲ್ಲ.
ಸಿಟ್ಟಿಂಗ್ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಪ್ರೆಸೈಡಿಂಗ್ ಆಫೀಸರ್ ಚೇಂಜ್ ಆದ್ರೆ ಸಿಟ್ಟಿಂಗ್ ಎಲ್ಲಿ ಹೋಗ್ತಾರೆ? ಇದ್ದೇ ಇರ್ತಾರೆ.
ಅಲ್ಲ ಪ್ರೆಸೈಡಿಂಗ್ ಆಫೀಸರ್ ರಜಾ 3 ಸಲ ಇದೆ ನಮ್ ಪಾರ್ಟಿ ಹೇಳಿದ್ದು. ಪ್ರೆಸೈಡಿಂಗ್ ಆಫೀಸರ್ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ, ಹಂಗಾಗಿ ಪೋಸ್ಟ್ ಪೋನ್ ಆಗ್ತಾ ಇದೆ ಅದು ಮ್ಯಾಟರ್ ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
No.
ಇದರಲ್ಲಿ I have made application under section 2 of the Partition Act, my lord, I have made application. There is a specific, if it is properties are not eligible, not entitled for.
No, that has to be decided in that appeal. I can't
My lord,
decide
it cannot
now.
be, my lord, it cannot be
That-
divided amongst
that
the
has to be-
parties. Court can take so much decision under section 2 if the properties are not divided.
Mister,
Cannot.
that is in respect of that final degree proceedings. Now final degree
Final
proceedings is
decree
over.
ಆದ್ರೆ final decree ಅಲ್ಲಿ
ಹಾಗೆ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ಆರ್ಗ್ಯೂ
ಹೌದು.
ಮಾಡಬಹುದು.
ಈಗ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದಾರೆ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲೂ ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್. ಆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡೋದು, ನೀವು ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿಲ್ಲ, ದೇರ್ ಫಾರ್ ಐ ಕಾಂಟ್ ಎಂಟರ್ ಇನ್ ದಿ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ.
ಎಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿದಿರಲ್ಲ ನೀವು?
ಅಪೀಲ್ ಹಾಕಿದ್ದೀನಿ, ಬಟ್ ದ ರೀಸನಿಂಗ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮೆಲಡ್
Where is that?
ಮೆಲಡ್ ರೀಸನಿಂಗ್.
But that contention has not been stated in the affidavit.
Let me see.
My learned friend has not stated with regard to the filing of the appeal along with the application filed before the executing court.
Elli, where is that, mister?
ಮೆಲಡ್ ಪೇಜ್ ನಂಬರ್ 38 ಮೆಲಡ್. Page number 41, my lord. And going through the record, the decree order has mentioned the extent of so and so. The decree order not included land bearing so and so. The decree order has sought for possession, this has already dealt in. No contention raised in this related to section 2 of the Partition Act. First, further at the time of drawing the final decree, this court has held the properties are eligible for decrease, and therefore there is no ground to respect of the matter. It is well settled.
No, section 2 of Partition Act has to be invoked in final degree proceedings, not execution. That's what they are saying that.
I have filed appeal. ಅದರಲ್ಲಿ ಫೈನಲ್ ಡಿಗ್ರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಏನಾಯ್ತು, ದ ಮ್ಯಾಟರ್ ವಾಸ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಆರ್ಡರ್ಸ್ ಮೆಲಾಡ್. ವಿ ಹ್ಯಾವ್ ಮೇಡ್ ರಿಕ್ವೆಸ್ಟ್ ಟು ದಿ ಕೋರ್ಟ್ ದಟ್ ವಿ ಆರ್ ಸೆಟ್ಲಿಂಗ್ ದಿ ಮ್ಯಾಟರ್ ಮೆಲಾಡ್. But unfortunately, my lord, the line judge has passed the order. Therefore, immediately we have filed the appeal, my lord.
See, now you have filed an appeal, rightly filed. Go and agitate. But section 2 of Partition Act cannot be invoked in that execution. That's what the court said. There is nothing wrong in that execution court order. You go and approach that appellate court and seek for an stay.
My lord, now the commissioner is directed to hand over possession, my lord. Possession court put a whole appeal itself will become infectious, my lord.
Mister, that is the ground you have to be urged in that appeal.
Appeal is filed long back, my lord. ಹಾಕಿದ್ದೀನಿ ಬಟ್ 21 ಅಲ್ಲೇ ಹಾಕಿದ್ದೆ 23 ಅಲ್ಲೇ ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಹೇಳಿ ಈ ತರ ನೀವು ಸ್ಟೇ ಕೊಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ ಅಂತ.
ಅಲ್ಲ ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡೋರು ಅದನ್ನ ಗಮನಕ್ಕೆ ತಂದಿದ್ದೀವಿ ಕೆಳಗಡೆ ಕೋರ್ಟ್ಗೆ. ಅಲ್ಲಿ ಪ್ರೆಸೈಡಿಂಗ್ ಆಫೀಸರ್ ಇರುತ್ತೆ, ಅವ್ರು ಪ್ರೆಷರ್ ಹಾಕಕ್ಕಾಗಿಲ್ಲ. ಹಂಗಾಗಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ನಾವು ಅದನ್ನ ತಗೊಂಡ್ಬಂದ್ವಿ.
That will
We have made all efforts, my lord.
we will get any instruction that whether proceeding officer will there or not.
Lord, suit is of the year 1981. Suit is decreed in the year 1990. FDP proceedings is filed in the year 1990.
You have filed an
The
appeal
FDP
before
proceedings, my lord, proceeded for
Same
for 23 years, my lord. These petitioners.
Where is that order sheet in that REA, mister? To show that the proceeding officer is not there.
REA order sheet.
REA order sheet ಕೊಡಿ ತೋರಿಸಿ.
REA order sheet.
Only to drag on the proceedings, my lord, so to see that, my lord, the
ಹಾಗೇನಲ್ಲ, ಅವ್ರಿಗೆ
fruits of
ಏನ್
the
ಪ್ರಾಪರ್ಟಿ
decree
ಬೇಕೋ
cannot
ಒಂದ್
be.
ಕಡೆ ಕೊಡ್ತೀವಿ ಅಂತ ಇದ್ದೀವಿ ನಾವು. ಇಲ್ಲ ಪರ್ಚೇಸೇ ಮಾಡ್ಬಿಡ್ಲಿ, ನಮ್ದೆಲ್ಲ ಶೇರ್ ಕೊಟ್ಬಿಡ್ತೀವಿ.
Yes, mister.
Lord, he is not agreeable for any settlement, my lord. Whatever the decree that has been passed by the trial court, that has to be.
ಅಂತಂದಿರ್ ಜಗಳ.
Now at this stage, my lord, after lapse of 45 years.
ಅಕೌಂಟ್ ತೊಂದ್ರೆ ಮಾಡ್ತಾನೆ, ಉಳಿಮೆನೂ ಮಾಡಕ್ಕಾಗಲ್ಲ ಯಾರನ್ನು.
ಏನಿದೆ ಅದು, whatever is there is there.
ಎಂಟೈರ್ ಪ್ರಾಪರ್ಟಿ ವಿಲ್ ಗಿವ್ ಇಟ್ ಹಿಮ್. ಇಲ್ಲ ಇನ್ನೊಂದು ಸರ್ವೆ ನಂಬರ್ ಬೇರೆ ಎಕ್ಸ್ಟೆಂಟ್ ಅವ್ನಿಗೆ ಎಕ್ಸ್ಟೆಂಟ್ ಬರುತ್ತೆ. ಒಂದು ಪ್ರಾಪರ್ಟಿ ಇದೆ, ಫುಲ್ ಪ್ರಾಪರ್ಟಿನ ಅವ್ರಿಗೆ ಕೊಡ್ತೀವಿ.
Don't make me as an FDP court. Now you are only on the ground.
Yes, my lord.
That whether section 2 can be invoked in that execution. That cannot be, that's what they said. Yes.
Section 2 can be invoked, my lord.
Where is that?
That is section 2.
Section 2 of Partition Act. That can be invoked only in that FDP, mister. Their partition properties will be divided. ಇಲ್ಲಿ ಅಲ್ಲಿ ಆಗಿರೋದನ್ನ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಷ್ಟೇ, ಇಲ್ಲಿ ಏನು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಹೇಳಿದ್ವಿ ಸಾಹೇಬ್ರು ಆರ್ಡರ್ಸ್ ಇಟ್ಕೊಂಡಿದ್ರು, ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂತೀವಿ ಅಂತ. ಬಿಫೋರ್ ದಟ್ my lord, the learned judge has passed the order. When the case
Can be
was
urged before the appellate court,
prior to
not
the
before
date
the
of
Supreme
passing the
Court.
order.
Whatever the contention that my learned friend wanted to urge, let him urge before the
You are
appellate court.
settling with whom?
With the
He is not agreed, he has not that.
ಅಲ್ಲ, ಅವರು ಪ್ರಾಪರ್ಟಿ ಯಾರು ತಗೊಳ್ಳಿ, ಇಲ್ಲ ನಮ್ಗೆ ದುಡ್ಡು ಯಾರು ಕೊಡ್ಲಿ.
No, settlement means both the parties has to be agreed. Is it not?
ಹೌದು, section 2 provides for that. If it is a property, ಭಾಗನೇ ಮಾಡ್ಕೊಡಕ್ ಆಗದಿದ್ರೆ ಪೀಸ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
ಆಯ್ತ್ರಿ,
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಡಿ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಡಿ.
That is the purpose of section 2 of the Partition Act. That is the, therefore my lord, that section is there, my lord.
Yes, in division in the partition suit.
ಹೌದು.
This is not a partition suit, this is an execution, mister.
ಅಲ್ಲ, ಪಾರ್ಟಿ section 2 ನಲ್ಲಿ Partition Act, section 2 of the Partition Act, that can be, the properties cannot be divided amongst the property.
ಆಯ್ತ್ರಿ,
small bit of
ಆ ಗ್ರೌಂಡ್ ನೀವು ಅಲ್ಲಿ ತಗೊಂಡ್ಬೇಕು, ಈ ಕೇಸ್ ಅಲ್ಲ ಅಂತ. That is what the trial court is also said.
ಅಲ್ಲ, ಅಪೀಲ್ ಹಾಕಿದ್ದೀವಿ, ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
Appeal court ಅಲ್ಲಿ ಹೋಗಿ you seek for an
But
stay.
if they take position, my lord, then it will become
That will be
infructuous.
subject to the result.
ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಸಲ್ಟ್ ಅಂದ್ರೆ ನಾಳೆ ಬಂದು ಅಲ್ಲಿ ಉಳುಮೆ ಮಾಡಕ್ ಬರ್ತಾರೆ, ಇದ್ ಮಾಡಕ್ ಬರ್ತಾರೆ.
ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಸ್ಟೇ ತಗೊಳ್ಳಿ, ಅಪೀಲ್ ಹಾಕ್ಬಿಟ್ಟು ನೀವು ಸ್ಟೇ ಕೇಳ್ತಾ ಇಲ್ವಾ?
Presiding officer there, my lord, will move the court. Till then, my lord, not to proceed.
You will verify that whether proceeding officer is there or not. Kelri.
That cannot be a reason for the stay to be granted in this
Wait,
proceeding.
mister.
ಬಂದಿದ್ದಾರೆ.
ಹೋಗಿ ಮಾಡಿ.
ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಡಿ.
Please, my lord, till such time not to.
ಇಲ್ಲ, ಈ case you go and move that, mister. Till that stage ಅಂತ ಅಂದ್ರೆ you are getting an entry order again.
ಅಲ್ಲ, till Monday, my lord.
No.
Till Monday to enable me to process the application.
Yes, you go and move that. Yes, list this matter on Monday.
My lord,
ಆಗಲ್ಲ Monday ಒಳಗಡೆ. Yes.
Monday, let there be a direction. ಅದಿಲ್ಲ ಅಂತಂದ್ರೆ ಅಲ್ಲಿ ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಳಲ್ಲ.
ಅಡ್ವಾನ್ಸ್ ಮಾಡೋದು ನಿಮ್ದು ಲಾಯರ್ದ ಕೆಲಸ ರೀ, ನನ್ನ ಡೈರೆಕ್ಷನ್ ಚಾಕ್ರಿ ಕೊಡ್ತೀವಿ.
ಇವಾಗಲೇ ಹೋಗಿ ಮಾಡ್ಬೋದಲ್ಲ ಅಡ್ವಾನ್ಸ್ ಅಪ್ಲಿಕೇಶನ್.
With liberty to the petitioner, my lord.
It is always there. You go and move that matter saying that they are delivering that this thing. If the entry matter ಕೊಡಲ್ಲ ಅಂದ್ರೆ ರಿಜೆಕ್ಟ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿ, then you can challenge that. But court cannot keep it pending. Yes.
That Tuesday,
Tuesday, yes.
Tuesday.
Bill number 17, SV Prakash for petitioner.
this defendant's. Lord, this is in regard to, my lord, the stamp duty. The suit is for specific performance of an agreement
Yes.
for sale, not executed by the defendants, dated, my lord, 14/6/2021. My lord, the recital in the agreement is, your lordship kindly take, my lord, I have called out that portion of in the petition.
Suit for
Suit for specific performance, page 10, my lord.
What is that order you are challenging?
No, what happened, my lord? When ex parte evidence was recorded, and thereafter, my lord, we appeared and our placing ex parte set aside in the file written statement. Then we made an application in terms of 34, 33 and 34, saying that this agreement, suit agreement, did not suffer adequate stamp duty because there is a recital in the agreement to the effect that the defendants would hand over possession of the property on 1/2/2022 after harvesting the Jover crop. This is the, my lord, recital in the agreement. And therefore, what I said is, this attracts Article 5(1)(e). If there is a, my lord, agreement, if both parties agree.
Impounding
Now court says, "Lord, my application rejected on the ground that on the date of execution of agreement, there is no handing over of possession."
the order kodi.
The page 35. But this is my, the court has rewritten, my lord, the law on this aspect. Page 30 commences from page 34. 37, your lordship, reasons. The para 7, my lord. Para 7, your lordship kindly come to page para 9, my lord, page 38. The counsel for the plaintiff in support of defense relied on the decision of so and so between Srinivas versus so and so, held that the possession is being delivered after 5 months. The Article 5(1) of the schedule to the act is not attracted. On perusal of the agreement of sale dated 14/6/21, marked Exhibit P1, the agreement of sale entered into between the parties on 14/6/21, and as per the recital, the defendant agreed to deliver possession on 1/1/2022 after taking out the Jover crop. Thus, it is clear that as on the date of agreement of sale, the possession is not delivered, and the possession agreed to be delivered as on 1/1/2022. Thus, as per the decision, so and so.
Take notice. Issue emergent notice.
My lord, further proceeding, they are going to, my lord, it is, my lord, evidence on 4/6, my lord. They may close the.
I thought the 6+3, 9 months ಆಯ್ತು ಆರ್ಡರ್ ಆಗಿ. You kept quiet.
Evidence ಆಗ್ತಾ ಇದೆ. ನಾನು I have not, my lord.
Take notice, we'll see that. Yes.
Office objection, first time matter, serial number 18, Chandrasekhar Reddy, MOB.
For the petition, respond, my lord.
Yes. Office objection.
Office objection, I'll rectify, my lord, there is
Pass out.
there is
Yes.
an urgency in the matter.
Pass over, you rectify it, Mr. Yes.
Serial number 19, R. Gopal.
Only a small thing, my lord, I will, my lord, rectify. That I will do it during the course of the day, subject to your lordship's hearing this matter, my lord.
Pass over.
Serial number 20, Nagabhushan R.
There are only 2 office objections. One is
They have to be stated
the
correctly.
synopsis
Here,
yet to be mentioned.
as per the MEA petition, all the parties are not
Lord,
made a
sir.
parties to clarify, cost settlement interpretation will be. Why that you are not made all the persons?
That's because plaintiff is the party who has obtained order against me. That's why I have not made other parties as.
Yes, what is this matter?
Lord, sir. This matter, my lord, sir, I have been sentenced to imprisonment for 3 months for violating the interim order passed by the Honorable Trial Court.
What is the suit for?
My lord, suit is one for partition and separate possession, my lords. Lords, by only relying upon the photographs, which was not even evidenced by section 65B.
No, first you come to that, then what is the order passed, then what is the.
Kindly come to
Suit for partition.
partition and separate possession.
Then.
Lords,
What is that injunction order has been passed?
My lords, on 6/2/2020, my lords, an injunction order saying that status quo to be maintained by the parties.
Yes. Where is
Was
that
passed.
order?
Lords, that order is in order sheet, my lords. Kindly, this may be seen.
ಅದನ್ನೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಲ್ರಿ?
Lords, the order,
ಆಯ್ತು ಸ್ಟೇಟಸ್ ಕೋ ಆಯ್ತು ಆಮೇಲೆ
ಸ್ಟೇಟಸ್ ಕೋ ಆಯ್ತು. ಸ್ಟೇಟಸ್ ಕೋ ಆದ್ಮೇಲೆ ನಮ್ಮನ್ನು ಹಿಯರ್ ಮಾಡ್ಲಿಲ್ಲ. ಸ್ಟೇಟಸ್ ಕೋ ಕೊಡೋಕ್ ಮುಂಚೆನು. ಸ್ಟೇಟಸ್ ಕೋ ಆದ್ಮೇಲೆ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು. ಆರ್ಡರ್ 39 rule 2. They have filed an application. That application was heard. Since I was not correctly advised by my advocate, my lords, I could not contest the matter. The honorable trial court dismissed the application.
Application filed by
Plaintiff.
You are the plaintiff.
I am for the defendant number 5.
ಆಯ್ತು ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
Thereafter, they have challenged it in MEA, my lords, miscellaneous appeal. The miscellaneous court, my lords, the first appellate court has granted the order, allowed the application by setting aside the order of the trial court. By only relying upon exhibit P 11 to 19, which are photographs. Let's kindly come to the page number 22, my lords, of my petition.
Where is that order of the trial court?
Lords, order of the trial court is at page number.
Rejection of
Application.
ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋದು ಎಲ್ಲಿದೆ ಫಸ್ಟ್?
Yes, ma'am. It is at page number 41, my lords.
Yes.
This order came to be, this application came to be rejected for the reason that the photographs are not supported by any 65B certificate and those photographs cannot be relied upon.
The nature of the punishment. No, this not under order 39 rule or order 39 2A.
Yes, my lord.
2A application.
2A.
No, that 39 1 and 2 there is an order.
No, my lords. At that time there was no order. Only status quo order in view of the urgency was passed.
Yes, that is also an order. Status
that was also an order, my lords, because the photographs, my lords, which
then you have filed an appeal that the appellate court has allowed.
At appellate court has allowed, my lords. Saying
ಏನಂತ
that
directions ಮಾಡಿದ್ದಾರೆ? Yes, undergo civil imprisonment for a period of.
Page number 22, my lords.
ಏನಾಗಿದ್ದಾರೆ? ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರಾ?
ಇನ್ನ ಇಲ್ಲ.
ಏನ್ ಮಾಡಕ್ ಹೋಗಿದ್ರ?
ಏನು ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. ಅದು ಫೋಟೋಗ್ರಾಫ್ಸ್ ಅಲ್ಲಿ ಡೇಟ್ ಇಲ್ಲ, ಏನಿಲ್ಲ. ಒಂದು 4 ಫೋಟೋಗ್ರಾಫ್ ಕೊಟ್ಟು ಅದನ್ನ ಇಂಜೆಕ್ಷನ್ ಇದ್ ಮಾಡಿದೀವಿ ಅಂತ. The photographs, my lords, are here. I may be permitted to produce the photograph.
Vacant site or this thing?
Evidenced.
No, is it a vacant site or suit settled property vacant jagan and
Vacant. Lords, now they say that this was built after the passing of status quo order.
Your case is that before that you have.
Yes, my lords.
ಇದನ್ನ ನೀವು ಕಟ್ಟಿದ್ದೀರಾ ಅನ್ನೋದಕ್ಕೆ ಏನು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದಾರಾ?
Yes, my lords, they have evidence. They have led their evidence.
ಮತ್ತೆ ಪ್ರೂವ್ ಮಾಡಿದ್ದಾರೆ. ನೀವು ಆಮೇಲೆ ಕಟ್ಟಕ್ಕೆ ಹೋಗಿ.
No, my lords, I did not lead my evidence also because I was not advised. I was not given the opportunity, my lords. That's why.
Not given opportunity ಅಲ್ಲ, ನೀವು you have not given.
No, my lords, my advocate did not even advise me.
Advocate ಏನ್ ಮಾಡ್ತಾರ್ರಿ? Yes, out issue notice stay of order dated 16/4/2024 passed by second additional senior civil judge JMFC Kollapura in miscellaneous appeal number 12/2024 till ಮತ್ತೆ ಇಲ್ಲಿ ಸ್ಟೇ ಆಯ್ತು ಅಂತ ಬಿಟ್ಟು ಮತ್ತೆ ಏನಾರ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ರೆ ವಿಲ್ ಅಗೈನ್ ಸೆಂಡ್ ಇಟ್. Yes, till next date of hearing. Yes, what is that detail stated correctly? Yes, submission is accepted. Office objection is overruled. Yes.
Cell number 21, Rajesh.
Court fee is to be paid.
Court fee has been paid. Your
When?
It was paid on the 5th of April. I have the receipt as well.
No, this is 16th April that again that office objection has been
My
raised.
lordship, 200 rupees has been paid. There are 2 petitioners and only 1 prayer that is there.
Nothing. Yes. Innondenu photo copy of the proceedings to be furnished.
Your
Yes,
lordship,
what is?
Your lordship, it's an uncontested P and SC.
Yes.
In which Evidence was led and final arguments were done on the 29th of November. If I may kindly take your lordship to Annexure A.
Yes.
It was posted for orders on 13/11 to 29/11. ಇವತ್ತವರೆಗೂ order pass ಮಾಡಿಲ್ಲ. The last date of hearing after filing this writ petition on 19th of March, I approached the court and requested, because the petitioners are in dire need of money. 26 lakh rupees ಸಿಕ್ಕಾಕೊಂಡಿದೆ ಅವರು ಇದರಲ್ಲಿ. Succession certificate ಇಲ್ಲದೆ ಅದು ರಿಲೀಸ್ ಆಗ್ತಾ ಇಲ್ಲ. Approached the court and requested the court to kindly pass orders. However, since I requested the court to pass orders, it has been posted for further arguments ಇವಾಗ. There's no further ಯಾರು respondents ಇಲ್ಲ. The court has already been convinced on 13/11. Arguments have been completed.
Order by 29/11.
Order by 29. ಅದಾದ್ಮೇಲಿಂದ 4 ಡೇಟ್ ಹೋಗಿದೆ your lordship. 4 ಡೇಟ್ ಅಲ್ಲೂ ಆರ್ಡರ್ಸ್ ಪಾಸ್ ಆಗಿಲ್ಲ. All that I'm seeking is direction to pass orders before vacations. They're in dire need of money your lordship.
No. See, further hearing ಅಂತ ಅಂದ್ರೆ ಅಲ್ಲಿ again if they are not passed an order within 3 months, they will post it for further hearing.
I understand.
ಎಲ್ಲಿದೆ ಅದು further hearing ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
It was passed on 19th of March. It's posted for day after tomorrow, 19th of April. The direction may be given. I will argue anything that is required. I will assist the court on 19/4.
You wait for 19/4. What will happen? We'll have it on 22nd.
Yes.
We'll see after that.
Yes,
Is this matter on 22nd?
Serial number 22, S. Vijay Kumar for petitioner.
Represent petitioner. Copy has been served on the other side.
Copy to be served to the cavator. Yes,
Served.
you have served.
Served. Lordship, this suit for bare injunction. Petitioner filed suit for bare injunction in respect of the property bearing survey number 66/15A, measuring 1 acre 1 gunta.
Yes.
This property has been allotted to the petitioner herein by way of the decree.
ಆಯ್ತು, ನೀವು injunction suit ಹಾಕಿದ್ರಿ, ಏನಾಯ್ತು? What is that order?
Injunction has been granted in my favor against the defendants. The defendants preferred miscellaneous appeal before the appellate court. Appellate court reversed the orders passed by the trial court, saying that I have not produced any document to show that there is a structure putting up by the defendants in the suit schedule property.
Where is that order passed by the trial court?
Order passed by the trial court is at Annexure B, page number 22. Para number 11.
Page number 22.
22. OS 397/2023.
Consequently, upon a defendant, their agent, any person claiming under them hereby restrained by temporary injunction, put up a construction encroachment suit schedule. Yes, what is that first appellate court? Why?
First appellate court.
What is the reason?
Reason is at para number 16, my lord. The plaintiff has not prima facie produced any document to show that the site was allotted to the said survey number 66/15A. However, the defendants appellants have produced.
No, what is the documents you have produced to show that?
RTC extract and the judgment and decree passed in my favor. As per the judgment and decree, the land bearing survey number 66/15A, measuring 1 acre 1 gunta, has been allotted in my favor, which has been reflected in the revenue records. I have produced the RTC.
In that partition suit.
Please,
then why the court said you have not produced any title deed and all?
I have produced all the documents before the court, trial court. On the basis of the documents relied upon by me, and after contest, the order has been passed by the trial court. It is not an ex parte order. The trial court holds that I have produced all the documents before the court below, while considering the application under order 39 to 1 and 2 at para number 11 of the orders.
Stay off. Order dated 28/1/2025, passed by. ಯಾವತ್ರಿ ಆರ್ಡರ್ ಆಗಿರೋದು?
28/1/2025.
Yes, 28/1/2025, passed by Senior Civil Judge JMFC Magdi in MA number 21/2024 till next date of hearing. Yes, submission is accepted. Office objection is.
I served the copy, sir.
Yes.
Highly.
Number 23, HR Ananta Krishnamurthy.
No, the learned counsel for the petitioner submits that copy has been
Copy
served.
not
to the
served.
caveat.
ಇಲ್ಲ ಕಾಪಿ ಕೊಡ್ತೇನೆ
It's
ಈಗಲೇ
opposite.
ಕೊಡ್ತೇನೆ ಕಾಪಿ ಕೊಡ್ತೇನೆ ದಿ
23.
ಅರ್ಜೆನ್ಸಿ ಸ್ಮಾಲ್ ಮ್ಯಾಟರ್
I will file my detailed objection. One more petition is pending.
No, wait. You are the caveator.
Yes, yes.
And then you have to serve a copy.
I'll serve it. The matter set down for arguments and merits. Pressure from the court to dispose of the matter. Suit is of
File my
year
detailed objection.
2016.
One more petition is pending on same subject matter, same application.
ಇಲ್ಲ ಬೇರೆ
That is the two suits pending.
You copy kodi, you will have it on Monday.
Monday.
Yes.
And along with the one more writ petition,
What is that writ petition?
25068 of 23.
ಎಲ್ಲ ಕೊಡ್ತೇನೆ
ಅಲ್ಲ ಒಂದು ಇನ್ನೊಂದು petition pending ಇದೆ
ಹಾ
in this court. Please.
ನೋಡೋಣ.
ಅಲ್ಲ,
ಇಲ್ಲಿ ಬರಲಿ ಬಿಡಿ.
similar application was filed in another suit.
Another
Was pending
suit.
here.
That's a different suit.
ಆಯ್ತಾ ಪೆಂಡಿಂಗ್ ಇದ್ರೆ ಏನಂತ ಇದ್ರ ನೀನು ನಾವ್ ಇನ್ನು ಅಡ್ಮಿಟ್ ಮಾಡ್ ನೋಟಿಸ್ ಮಾಡ್ಬೇಕಾ ಇಲ್ಲನೆ
ಅಲ್ಲ,
ಹಿಯರಿಂಗ್
it may
ಮಾಡಿಲ್ಲ.
be disposed ಮಾಡು. ಅದ್ರ ಜೊತೆಗೆ along with ಬಂದ್ರೆ ಸೇಮ್ ಅಪ್ಲಿಕೇಶನ್ ಸೇಮ್ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಹಾಗಾಗಿ
Yes. What is that he has
the court commission case.
court commissioner?
That the application has been rejected on this short ground
Both
that the properties are developed. It is difficult to identify. Drone is there. Similar matter, similar circumstances
claiming,
in
different
respect of the
assignment
very
number.
property.
No, what is that connected matter?
25068 of 23.
ಏನ ಇದೇ ಸೂಟಾ ಬೇರೆ
ಅಲ್ಲ,
suit?
ಬೇರೆ
the injunction suit. Their suit is the equation.
It's different.
Yeah,
Why
yeah.
it connects to has to
ಅಲ್ಲ,
be-
kind of maybe connect.
67th of November.
Call this matter on 21st, let us.
21st.
First we'll see.
22nd.
22nd, yes.
Number.
Serial number 24, Srinivasan T.
Copy ಕೊಡಿ ಅವರಿಗೊಂದು.
ಈಗಲೇ ಕೊಡ್ತೇನೆ.
For the petition number.
Date of the impugned order on IA 24 and 25 at the prior doesn't tally. Date is not tallying, Mr. Prior ali.
My lords, may kindly see page number 21. Date is 23/6.
23/6.
Please, my lord, at the bottom,
Yes, see,
Below.
page number
page number 21.
21. Yes.
23/6 is the date.
Hmm.
The same date has been mentioned by me in the impugned at page number 11. 23/6/23.
ಅಲ್ರಿ ಮೇಲ್ಗಡೆ ಇನ್ನೊಂದು ಸೈನ್ ಮಾಡಿದಾರಲ್ಲ ಅಂತ ಅದು ಸಿಗ್ನೇಚರ್ ಅದು ಅಲ್ಲಿ ಡೇಟ್
ಸಿಗ್ನೇಚರ್ ಸಮಯ ಅದು ಡೇಟ್ ಅಲ್ಲ ಅದು.
ಡೇಟ್ ತರ ಸಿಗ್ನೇಚರ್ ಮಾಡಿದಾರ?
ಸಿಗ್ನೇಚರ್ ಆಗಿದೆ ಅದು ಡೇಟ್ ಅಲ್ಲ.
ಇಲ್ಲ ರೀ 31st 5
ಅದು ಸಿಗ್ನೇಚರ್. My lords, may kindly see even in page number 20, the signature is same as it is signed in page number 21.
ಅಲ್ರಿ ಎಲ್ಲಾ ಇದ್ರಲ್ಲೂ ಸಿಗ್ನೇಚರ್ ಕೆಳಗಡೆ ಡೇಟ್ ಹಾಕೊಂಡು ಹೋಗ್ತಾ ಇದಾರೆ ಅವರು. ನೋಡಿ ಅವ್ರ ಹಿಂದಿನ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ನೋಡಿ ಅವ್ರು ಸೈನ್ ಮಾಡ್ಬಿಟ್ಟು ಅದಕ್ಕೆ ಡೇಟ್ ಹಾಕ್ತಾ ಇದಾರೆ. ಡೇಟ್ ಅನ್ನು ಸಿಗ್ನೇಚರ್ ತರಾನೇ ಬರಿತಾ ಇದಾರೆ ಅವರು. ದಟ್ ಈಸ್ 31st 5. ಇದು 23/6 ಏನ್ ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲ. ಆಯ್ತು, ಹಿಂದಿನ ಡೇಟ್ ಯಾವತ್ತಿಗೆ ಹೋಗಿತ್ತು ನೋಡಿ.
ಹಿಂದಿನ ಡೇಟು it is at page number 18.
ರೇ ಇಲ್ಲೇ ಇದೆಯಲ್ರಿ. Post this matter on 31st 5 2023. Then order is on 31st 5 2023.
I'll change that.
You correct it, password.
Please, ma'am.
ಅದನ್ನೆಲ್ಲ ನಾವೇ ನೋಡಿ ಈ ಸ್ಕೂಟ್ನಿನ ನಮ್ಮ ಕೈಲೇ ಮಾಡಿಸ್ಬಿಡ್ತೀರಾ?
ಅದು ಗೊತ್ತಾಗೋದಿಲ್ಲ ಸಮಯ ಆ ರೀತಿ.
Objection, second time matter, serial number 25, Jaitra J. Narayan.
Yes, the Lordship heard this matter for some time. That we inform the learned judge, the matter is posted to 25th. Lordship kindly dispose the matter with the liberty to permitting the petitioner to address the arguments on the transfer petition. Similar order, my lord,
Just give that brief facts.
Lord, what has happened is this: there is a transfer petition filed by my learned friend before the principal judge. In that transfer petition, I am 1118 of.
There is a direction by
Yes, this
court.
Yes, my lord. Page number 36. There was a direction that I should file an application for recalling the order, which was already posted for orders, and I should be permitted to argue the matter. Page number 36, minute.
ಆಯ್ತು, ಅವತ್ತು ನೀವು ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಕೊಡ್ಲಿಲ್ವಾ?
No, ಅದ್ರಲ್ಲಿ ಏನಾಯ್ತು
ಮೆನ್ಷನ್ ಮಾಡ್ಕೊಂಡು ಹೋದ್ರಲ್ಲ ಅದೇ ತಾನೇ?
ಅವತ್ತು ಮೆನ್ಷನ್ ಮಾಡ್ದು matter is posted to 25th.
For orders, what the learned judge there expressed was on 17th, that is today. He is free, they can come and argue the matter.
ಇವತ್ತೆಲ್ಲ ಆಗೋದಿಲ್ಲ. ಇವಾಗ ಅಡ್ವಾನ್ಸ್ ಮಾಡಿಸ್ಬೇಕು ನಾವು ಅದನ್ನ. ಇವತ್ತು ಹೆಂಗ್ ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ? Anyway, matter is posted
Today morning, afternoon at 2:45.
Lord, it is not possible that way.
He will take
25th, the matter is listed on 25th.
ಮೊನ್ನೆ ಯಾವತ್ತಿತ್ತು ಮ್ಯಾಟರ್ ಅದು?
ಮೊನ್ನೆ ಇತ್ತು ಸ್ವಾಮಿ.
ಯಾವತ್ತು?
That is on 15th.
15th matter was there. 15th ಇಂದ ಯಾವತ್ತಿಗೆ ಹೋಯ್ತು?
25th. ಅವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಡ್ತೀವಿ ನಾವು ಅಷ್ಟೇ.
15th ಇಂದ 25th ಹೋಗಿದೆ.
ಹೌದು. We informed your lordship.
Because the plaintiff made a submission saying that this petitioner was not concerned to make a submission. At 3 PM, the plaintiff has gone and made a submission. The matter is pending before the court. It has come up today. So therefore, the court adjourned the matter to 25th. The 25th for orders only the matter has been posted.
ಮತ್ತೆ ಇವತ್ತಿಂದ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರ ಅಲ್ಲಿ ಕೇಸ್ ಪೋಸ್ಟ್ ಆಗ್ತಾನೆ ಕೋರ್ಟ್ ಮುಂದೆ.
ಅಡ್ವಾನ್ಸ್ಮೆಂಟ್ ಮಾಡ್ಕೋಬಹುದು ಸ್ವಾಮಿ.
ಅದನ್ನೇ ವಿಲ್ let them argue on 25th and
ಅಷ್ಟೇ
order end of April.
Yes, please.
Yes. Let them pass an order by end of
Please,
April. That's what, yes.
But just for your lordship,
Just give the facts.
paragraph 36 may kindly be seen, page number 36 may kindly be seen, not?
Yes.
Page number 36 ಅಲ್ಲಿ, this is the order passed by this honorable court.
Yes.
This was my grievance. The petitioner's grievance is that although the petitioner is arraigned as respondent number 13 in OS number 3932 of 2017, the defendant 1 and 2 filed a petition under section 24 of CPC and sought for dispensation of service of notice onto the petitioner. Thereafter, the trial court, without hearing the petitioner, has posted the matter for judgment. Therefore, the petition is disposed, reserving the liberty to the petitioner to file an application to reopen the case, and such an application is filed. The trial court to allow the application and pass an appropriate order after hearing the petitioner. But this order was passed in the month of December 2000, that is 31st December 2024. No, as per the order of this
dispensation of notice to petitioner andre, petitioner is what?
Respondent number 13 in the transfer petition. And also defendant number 13 in the original suit filed by the university. That is 13
in the suit.
Yes. Then, my lord, as per page number 97, IA number 6 was filed.
97.
Yes, ma'am. Page number 97, IA 6 was filed on 6/1/95. This is recorded in the order sheet at page number 31. 6/1/2005, we filed in the court, though it is dated 23/12.
That's all. We'll permit them to argue.
Please, please.
Yes. This petition is filed by respondent number 13 under Article 227 of Constitution of India, seeking following relief prior extract. The plaintiff has filed a suit for?
But suit for injunction.
Suit for bare injunction.
That is the respondent number 3 before your lordship.
In OS number?
3932 of 2017.
3932?
Of 2017.
2017. Innonde a suit.
Innond 5148. That is not the subject matter before this court now.
Yes, this only we want to.
Yes.
Filed a suit for bare injunction.
Bare injunction.
During the pendency of that suit, the plaintiff, who has filed that application?
Respondent 1 and 2. Respondent 1 and 2 before your lordship. Were the defendants 1 and 2 in that suit?
Defendant number 1 and 2 has filed an application under section 24 of CPC for transferring this suit OS number 3932 of 2017.
Numbered as miscellaneous 1118 of 2024.
The petition that filed under section 24 of CPC has been numbered as miscellaneous 1118 of 2024. Since notice to petitioner defendant number 13 has been dispensed in miscellaneous petition, the defendant number 13 has approached this court in filing a writ petition in WP number 35780 of 2024. This court, by order dated 31st December 2024, has reserved liberty to the petitioner to file an application to reopen the case. Such an application is filed. The trial court is directed to pass an appropriate order after hearing that petitioner. First, that order passed by this court The petitioner has filed an application on 23/12.
No, my lord, it was filed on 6/1/2025, numbered as IS6. ಅದು dated ಅದು, but open court ಅಲ್ಲಿ 6/1/2025.
Yeah, 6/1.
6/1/2025.
Yes, filed on 6/1/2025.
Numbered as IS6.
The same has been numbered as IA number 6. Learned counsel appearing for the petitioner has made a grievance that without passing any order on that application, the miscellaneous petition has been posted for orders,
Final orders.
posted for final orders. In view of that order passed by this court in earlier writ petition, he sought for an opportunity to argue the case in miscellaneous petition. Learned counsel for respondent
1 and 2.
1 and 2. You are a defendant?
I am respondent 1 and 2. Defendant
Defendant 1 and 2.
The respondent, defendant 1 and 2 has submitted that the matter is posted on 25th.
25th.
25th for orders. This court can permit the petitioner to make his submission on 25th in miscellaneous case number 11118 of 2024.
Also formal objections.
In between,
Yes. Yes.
if he wants to file any objection, within that time he can file an
Yes,
objection
yes.
after serving the copy.
Yes.
In view of the above writ petition is disposed of. The trial court is directed to permit that petitioner to file an objection, if any, to that application filed under section 24 of CPC on or before 24th after serving in a copy to
Monday, Tuesday, Wednesday, apparently CCH1 is not sitting minutes.
ನಿಮಗೆ ಕಾಪಿ ಕೊಡಕೇನ್ರಿ?
ಅಲ್ಲ ಕಾಪಿ ಕೊಡ್ಬೋದು.
ಸರ್ವ್ ಮಾಡಕ್ಕೆ ಕೋರ್ಟ್ ಇಲ್ದೇನೆ ಸರ್ವ್ ಮಾಡಕ್ ಬರಲ್ವಾ? ಮಾಡ್ಬೋದು, ಆಫೀಸಲ್ಲಿ ಹೋಗಿ ಮಾಡಕ್ ಆಗಲ್ಲ. ಅಲ್ಲ, ಫೈಲ್ ಮಾಡಕ್ ಆಗಲ್ವಾ? ಬೇಡ ಬಿಡಿ, ಫೈಲ್ 25ಕ್ಕೆ ಮಾಡಿ. ಕಾಪಿ has to be served to you.
Correct.
Yes, on or before 24th. And permitted that petitioner, defendant number 13, to make his submission in miscellaneous 1118 of 2024, and parties has to be concluded their submission on that day.
Yes.
Thereafter, the trial court is directed to pass an order in accordance with.
Yes.
ಅದು ಒಂದು ಟೈಮ್ ಬೌಂಡ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಬಿಟ್ರೆ
ಅವರು ಅರ್ಜೆಂಟ್ ಅಲ್ಲೇ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ ಇದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ವೈ ಐ ಹ್ಯಾವ್ ಟು ಗಿವ್ ರಿಸ್ಟ್ರಿಕ್ಟೆಡ್.
ಯಾಕಂದ್ರೆ ಆಮೇಲೆ ಮತ್ತೆ ವೆಕೇಶನ್ ಸ್ಟಾರ್ಟ್ ಆಗೋಗುತ್ತೆ.
Yes, trial court is directed to dispose of that miscellaneous petition on or before end of April.
Yes, please.
25. Yes.
Bill number 26, Shanta Viraya.
Petitioner.
Yes, annexure to be
For
state
recovery of recovery suits. Kindly,
Prior
page number
copy
25.
IA to be filed.
Page number 25.
ಏನು, what is this matter?
Decree amount 15,80,000 sir. ಅದರಲ್ಲಿ 9 lakhs repayment ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀವಿ. Kindly
ಏನು ಸೂಟ್ ಫಾರ್
recovery amount.
ಎಷ್ಟು ಎಲ್ಲಿದೆ ಟಿಕ್ರಿ?
Decree page number 25 execution petition ನಲ್ಲಿ ಮೆನ್ಷನ್ ಆಗಿದೆ ಸರ್.
ಎಷ್ಟಿದೆ?
15 lakhs 80,000.
Where is that, Mr.? 15 lakhs 80,000.
ಹ್ಞೂ ಸರ್. Decree amount 15 lakhs 80,000.
ಎಷ್ಟು ಕಟ್ಟಿದ್ದೀರಾ ಅದ್ರಲ್ಲಿ?
9 lakhs ಕಟ್ಟಿದ್ದೀವಿ ಸರ್.
ಎಲ್ಲಿದೆ? What is that proof to show that you have paid 9 lakhs?
DDS ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ.
Calculated at the rate of 18% per annum, rupees 15 lakhs 80,000. As per the judgment of degree.
Kindly, page number 21. madam.
Outstanding amount is 15 lakhs 80,000, Mr.
Awesome, along with the interest ಎಲ್ಲ ಇದು. ಅದೇ ನಿಯರ್ಲಿ 9 lakhs ಕಟ್ಟಿದ್ದೀವಿ ಸರ್ ರೀಪೇಮೆಂಟ್ ಅದಕ್ಕೆ.
ಎಲ್ಲಿದೆ reference? We have paid, all that order sheet shows that outstanding due is 15 lakhs, Mr.
Kindly see annexure A, sir. Every month ನಾನು 1 lakh ಕಟ್ಕೊಂಡು ಬರ್ತಾ ಇದ್ದೀನಿ ಸರ್.
ಎಲ್ಲಿದೆ ತೋರಿಸ್ರಿ.
ಪೇಜ್ ನಂಬರ್ 21 ಸ್ವಾಮಿ. Both the side council present paper reissue attachment of warrant movable. ಮತ್ತೆ ಆರ್ಡರ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ. ನಾನು 11/3/25 ನಲ್ಲಿ. ನಾನು ಕೈಂಡ್ಲಿ annexures ಪೇಜ್ ನಂಬರ್ 32 ನಾನು ರೀಪೇಮೆಂಟ್ ಮಾಡಿದ್ದ ಅದಕ್ಕೆ ಡಿಡಿಸ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ?
ಪೇಜ್ ನಂಬರ್ 32 1 lakh. ಆಮೇಲೆ 34 35 36 38 ವರೆಗೂ 9 lakhs ಇಲ್ಲಿವರೆಗೂ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. 19th ಅಟ್ಯಾಚ್ಮೆಂಟ್ ವಾರೆಂಟ್ ಅಂತ ಇದು ಮಾಡಿದ್ದಾರೆ. Kindly stay the order dated 11/3/25.
ಅಂತ ಅಂದ್ರೆ ಇನ್ನೆಷ್ಟು ಬ್ಯಾಲೆನ್ಸ್ ಇದೆ?
ಇನ್ನ 6 ಲಕ್ಷ ಏನಿದೆ ಸ್ವಾಮಿ, 6 ಲಕ್ಷ.
ಆಯ್ತು, 3 ಲಕ್ಷ ಕಟ್ಟಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಮಂತ್ಲಿ ಒಂದು 2-3 months ಅಲ್ಲಿ ಎಲ್ಲ ಫಿನಿಶ್ ಮಾಡ್ಬಿಡ್ತೀವಿ. ವಿತಿನ್ 3 months ಅಲ್ಲಿ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಯಾವ್ದು ಬರೋ ಅಮೌಂಟ್ ಇದೆ.
ಫಸ್ಟ್ ಈಗ 2 weeks ಅಲ್ಲಿ 2 ಲಕ್ಷ ಕಟ್ಟಿ.
ಆಯ್ತು ಸರ್.
ಆಮೇಲೆ ಬಾಕಿತ್ತು ಇಶ್ಯೂ ನೋಟಿಸ್. Stay of order dated 11/3 na
11/3 sir
11/3/2025 passed by ಯಾವ ಕೋರ್ಟ್ ರೀ?
ಟೋಟಲ್ ನಂಬರ್ 89 ಸರ್, ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್. ಎಕ್ಸಿಕ್ಯೂಷನ್ ನಂಬರ್ 561/24.
ಪ್ರಿನ್ಸಿಪಲ್ ಸಿಟಿ ಸಿವಿಲ್ ಅಂಡ್ ಸೆಷನ್ ಜಡ್ಜ್ ಅಲ್ಲ 88 additional city civil and session judge Bangalore.
CCH 89 sir.
Bangalore in execution number 561 of 2024 subject to condition petitioner has to deposit 2 lakhs before executing court within 2 weeks from today. Yes, submission is accepted. Office objection is over.
Bill number 27, HM Madhusudana.
Another 2 matters are there. Kindly be date may be fixed for 24, 10/2056 and 10,000.
Call this matter along with that so and so.
24.
In the meantime,
senior
comply.
counsel, senior of subjection comply matters.
In the meantime, directed to comply.
Date may be fixed to 24th.
ಜೊತೆ ಬರುತ್ತೆ.
24th may be senior counsel ಬರುತ್ತೆ.
ಅದು ಯಾವ ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿದೆ ಅವತ್ತು ಬರುತ್ತೆ. Yes.
Yes. Bill number 28, Nataraja Babake.
For the petitioner, my lords. This office objection is I have sought for consequential relief, my lords, because my application under 41 rule 5 application rejected, my lords.
Age of the defendant.
That I will correct, my lords.
Yes, pass on.
My lords.
Pass on.
Please.
Serial number 29, A.L. Mariappa.
Yes.
Petitioner, my lord. My lord, the office objection is in respect of the writ petition, page number 5, my lord.
Typed copy of the cost title to be paid.
Page number
yes.
5, my lord.
Yes, typed copy, it's okay. Yes. What is this, Mr.?
The petitioner before your honor, my lord. Previously, the respondents have filed the original suit 61/92, suit for partition and separate portion, my lord. That suit is declared on 28/98. Thereafter, these that suit is dismissed, my lord. That judgment decree, my lord, the respondents herein have preferred the RFA before the Sam report. That RFA is decreed, my lord, allowed and decreed, and consequently, original suit is decreed, my lord. Suit for partition, my lord.
Yes.
Thereafter, my lord, these respondents have filed the FDP proceedings, and that FDP proceedings also, that is annexure B, my lord, that is allowed. Thereafter, my lord, now the petitioners, the respondents have filed the miss number 4/20 before the court below, and wherein the court below issued the warrant. Kindly peruse the annexure
No.
B, my lord, page number 36.
Who has filed this miss?
Miss those who succeeded in the RFA, that is give original plaintiffs.
Yes.
Kindly peruse the annexed email or page number 36.
ಏನಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ miscellaneous petition?
This petition is a execution case. Execution to possession ಗೆ ಕೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. The shara is there, they ಏನು bailiff shara ಇದೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಪ್ರಾಪರ್ಟಿನ ಐಡೆಂಟಿಫೈ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತಲೇ ಶರ ಬಂದಿದೆ ಸ್ವಾಮಿ. Once again, even though they,
where is that order passed by the trial?
Page number 37, my lord. Bailiff shara. ಕನ್ನಡದಲ್ಲಿ ಇದೆ, ಇದನ್ನ ಟೈಪ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. Page number 39, my lord. May permit to read in Kannada is there. Page number 39, typed copy.
39.
ಹೌದು ಸ್ವಾಮಿ. ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಮೇರೆಗೆ ಈ ಸ್ವಾಧೀನ ವಾರೆಂಟ್ ಕಂಡ ಡಿಕ್ರಿದಾರ್ಗೆ ಸ್ವಾಧೀನ ವಹಿಸಿಕೊಡಲು ಸದರಿ ವಾರೆಂಟ್ ಅಲ್ಲಿ ಡಿಕ್ರಿದಾರ ಪೂರ್ಣ ವಿಳಾಸ ಇರುವುದಿಲ್ಲ. ಸದರಿ ವಾರೆಂಟ್ ನಮೂದಿಸಿದ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ಯಾವ ಗ್ರಾಮ ಎಂದು ನಮೂದಿಸಿರುವುದಿಲ್ಲ. ಹಾಗೂ ವಾರೆಂಟ್ ಲಗತ್ತಿಸಿದ 12 ಶೆಡ್ಯೂಲ್ ಇರುವ ನಕಲು ಕಾಪಿ ಶೆಡ್ಯೂಲ್ ವಿಳಾಸವು ಕೆಲವು ಬೇರೆ ಬೇರೆ ಸ್ವಾಧೀನಪಡಿಸಬೇಕೆಂದು ಸದರಿ ನ್ಯಾಯಾಲಯ ಆದೇಶವನ್ನು ಸದರಿ ವಾರೆಂಟ್ ನಮೂದಿಸಿರುವುದರಿಂದ ಸ್ವಾಧೀನ ವಹಿಸಲು ಸಾಧ್ಯವಾಗದೆ ಈ ಸ್ವಾಧೀನ ವಾರೆಂಟ್ ಅನ್ನು ಸನ್ನಿಧಾನಕ್ಕೆ ವಾಪಸ್ಸು ಮಾಡಿರುತ್ತೇನೆ ಸ್ವಾಮಿ. That is the shara by the bailiff.
ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಮೇರೆಗೆ
as per the shara, bailiff unexecuted and delivery warrant due to for the want of complete address court order. Once again, in spite of this, bailiff shara idru swami. Kindly peruse that order sheet. Once again, the court below is directed to warrant issue delivery warrant. My respectful submission. In the FDP, exactly the commissioner not properly did that marking up those and also property the FDP decree prakar madilla. That's why now the bailiff has rightly made an shara. In spite of that shara idru kuda, that is now the court below issued the once again the additional that
where is that order?
That typed copy from the ಅದು 23 ಇಂದ ಬರ್ತಾ ಇದೆ ಸ್ವಾಮಿ. That is 25/20. Office issue delivery warrant in respect of the petition. ಅದು ಅದೇ await ಅಂತಲೇ ಬರ್ತಾ ಇದೆ ಸ್ವಾಮಿ.
ಅವರು ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಕೊಡಲ್ಲ, ಅದಾಗಲ್ಲ ಬಿಡಿ.
Now one submission, my lord. ಕಮಿಷನರ್ ರಿಪೋರ್ಟೇ ಸರಿ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅದನ್ನ ಸರಿಯಾಗಿ ಮಾಡಿದ್ನೆ ಇವರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿ ಮಿಸ್ ಪಿಟಿಷನ್ ಹಾಕಿರೋದು ತಪ್ಪಿದೆ ಸ್ವಾಮಿ.
ಆಯ್ತು, ನೋಟಿಸ್ ತಗೊಳ್ಳಿ. ಎಸ್
my lord, in the meantime, my lord, because
23ರಿಂದ ಏನು ಮಾಡ್ದಾನೆ ಸುಮ್ಮನೆ ಹೋಗ್ತಾ ಇದೆ. ಈಗ ಯಾಕೆ ನಿಮಗೆ
ನಾವು ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಇದ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ಅಲ್ಲಿ
ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಈಗಲ್ಲ 23ರಿಂದ
ಇದೆ ಸ್ವಾಮಿ. ಬಟ್ ಮೈ ಇಟ್ ಇಸ್ ಟ್ರೂ ಮೈ lord.
He cannot identify the property, therefore he can't execute at all.
I mean next date ವರ್ಗಾದ್ರೂ ನನಗೆ ಸ್ಟೇಟಸ್ ಹೋಗ್ಬೇಕು ಸ್ವಾಮಿ. ಅದರ್ವೈಸ್ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಯಾವ್ದೋ ಪ್ರಾಪರ್ಟಿ ಬಂದು ಅವ್ರು ಇದ್ ಮಾಡ್ತಾರೆ.
ಯಾವ್ದೋ ಪ್ರಾಪರ್ಟಿ ಬಂದ್ರೆ ನಿಮ್ದು ಅಲ್ದಿದ್ರೆ ನೀವ್ ಯಾಕೆ ಇದ್ ಮಾಡ್ತೀರಾ? That is what that bailiff said. ಊರ ಹೆಸರು ಇಲ್ಲ, ಪಾರ್ಟಿ ಹೆಸರು ಇಲ್ಲ, ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ. Every time he is sending back. Court say that at least court has to ask the parties to give a correct address, and either they have to say that these are all the suit scheduled properties. Nothing will happen there.
ಈಗ ಅದು ಶರ bailiff ಏನ್ ಶರ ಇದೆ ಅದು ಕರೆಕ್ಟ್ ಮಾಡೋದನ್ನೇ ಮಿಸ್ ಪಿಟಿಷನ್ is not itself is not maintainable.
Reissue delivery warrant ಅಷ್ಟೇ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ. When the bailiff categorically mentioned the due shara, the court has to give the direction to the mispetitioners. ಅದು ಸರಿಯಾಗಿ ಮಾಡ್ಬಿ ಅಂತ ಹೇಳ್ಬೇಕು. Without that, the learned judge has passed this once again delivery warrant. That's why my lord, I am seeking this.
Yes, issue notice stay of further proceedings in miscellaneous 4 of 2020 pending in file of which court, Mr.?
That is Honorable Intermediate Court, Kortagere, Senior Civil Judge and JMFC, Kortagere, my lord.
Yes, Intermediate Court, Senior Civil Judge, JMFC, Kortagere, till next date of hearing. Yes. Typed copy. Office objection is accepted. Submission is accepted. Office objection is over. Yes.
Fourth time office objection, serial number 30, Noor Muhammad.
30, I filed a memo for dismissal of writ petition, not
Yes.
writ, Your Honor.
Yes, filed in a memo seeking leave of this court to withdraw that, dismissed as withdrawn. Yes.
Fifth time office objection, serial number 31, Ramana G.
Already complained, ma'am. Is the highlighted portion is removed like that, they have objected. That is
There are
removed
6.
already. Removed already. And Aadhaar card of the
To be marked properly at writ petition.
Yes.
Annexures mark ಮಾಡಿಲ್ಲ. petition to be stitched properly.
That is already over.
Highlighted portion. Writ petition to be
removed,
stitched
removed.
properly.
Removed.
Indexed and the pagination checked later.
Clearly.
I think all office
mentioned.
objection will be checked later.
Yes, ma'am.
Yes, annexure to be marked properly in the writ petition. You have not marked the annexure properly.
Yes,
You have marked.
marked already.
Argue. Yes, what is?
The respondent has been filed suit for injunction for trial court. Order 39 rule 1 and 2 allowed. I have filed MA. The same is dismissed.
Suit for?
Suit for injunction.
Both the court has
Yes, ma'am.
concurrently held.
Yes, ma'am.
What is wrong in that?
That is the suit settled property is the Jodidar property. We are in the property cultivators since 100 years, and also have paid the taxes to the Jodidars. Already the documents also filed. This RTCs in my name since 19.
Then why that both the court has rejected your application?
Rejected means they have filed this property since 100 years. We are tenants under Jodidars. In the meanwhile, this respondent and his legal heads, this ancestors, as a sandbogas, they have collecting the taxes. And after death of the Jodidars, they have created RTCs in their names and objected to me to cultivating the properties. At that time, we have filed Form 7 applications in LRF number 206/7879. The LRF is my Form 7 applications is rejected, and we have challenged before this honorable court in WP number 16/835/2023. Honorable court directed to the both the parties not change the nature of the property like that. At the stage, the respondent has trying to current line has been fixed there only, but electricity board has not given any electricity in this.
No, I'm asking that why the trial court has rejected your application?
Yes.
What is the reason?
Yes, ma'am. Reason is they have filed some documents. They are possession like that.
Yes, madam. What is this?
Yes,
Your Lordship, this is the third round of litigation before this honorable court,
Yes.
fifth round of litigation before the tribunal. Also, there is a writ petition pending wherein in fact they have protected our
Now
rights.
that
Please,
it is only in respect of the temporary injunction.
please.
What is the reason given by the trial court to show that you are in the possession of the
That
property?
from 1960s,
Yes,
it has been continuously only in our possession. We've been grantees, it has been observed.
you are
All
the grantees. You are
Please, Your
claiming as
Lordship,
a grantee.
please, from 1960s.
Yes,
And there is no break in our entries anywhere.
yes.
Now the entries that he's claiming suddenly, while we, that also at page, might I just hand over, Your Lordship, a set of documents? I will serve the other side also. Your Lordship may kindly see, there is actually no such entry. So the entries that he's claiming are all false.
Yes.
And he also continuously claims that I have no,
Produce this before the trial court.
no, he has not, Your Lordship, what he has done is,
Has he produced this?
now he has latest come up with this because 3 rounds he has lost. Now
Sir,
he's
I
coming
can't
up with
take
this.
that, whether that, what is produced before
No,
the
no.
trial.
Maybe,
Now we will see that what is that reason given by the trial court.
Please, Your Lordship.
Yes.
All those annexures that have produced, Your Lordship, from serial number 24 onwards, Your Lordship.
Yes.
Your Lordship is looking at the order, Your Lordship, at page 201.
201.
Please, from there it starts.
Impugn order is on 201.
Your Lordship, will file it in our objections also. Your Lordship, the document that I've handed over now, Your Lordship.
No, in this you are.
In this, in the last, it is there.
Yes.
Your Lordship, at page 197,
Yes.
page 197 is the order of this honorable court. Same party, same advocate,
Yes.
which is at 195, Your Lordship.
197.
And 197, Your Lordship may kindly see.
What is that order?
Your Lordship, read senior counsel appearing respondent refer to the observations regarding possession being with respondent's hearing in terms of order dated 19/1/2023. That was the LRF's order. It is further submitted that respondents have filed suit for injunction. Parties are directed not to change the nature of the property, and civil court is entitled to decide the matter. No interim order was granted to him, and though please.
This is filed in that LR application.
Please.
No, that. Land
Next
reforms
page,
matter.
next page, your lordship had sought for. That is at 199.
Yes.
Lordship may kindly see orders on IA number 1. The relevant portion starts from para 12, your lordship,
Yes.
page 210.
Yes.
Applicant plaintiff in support of his contentions has produced RTC extracts in respect to suit scheduled properties, taxpayer receipts, and order of the Land Tribunal Magadi and other orders of the Special Deputy Commissioner and Inam abolition. I've carefully gone through the RTC extracts of suit scheduled properties. On perusal of RTC extract, it clearly shows that the name of Ramarao, Narsappa, Bhaskaraya appearing there are occupants and owners, and since 1997 till date of filing of the suit, name of ancestors of the plaintiffs are appearing. I've carefully gone through the order of the Revenue Appellate Tribunal, Special DC for abolition of inams. Revenue Appellate Tribunal, Special DC have rejected the applications filed by Bhairappa and Ganga Bhairappa and Dodda Basappa and Kala Bhairappa, stating that they are not entitled for occupancy rights in respect of suit scheduled properties. And even the Land Tribunal Magadi has also rejected the application filed by these 4 persons after inquiry as per the order of the Honorable High Court of Karnataka. And moreover, the defendants in their written statement also admitted an order of the regarding the order of the Land Tribunal. Further, the plaintiff in order the plaintiff with respect to their possession at this juncture have produced the reports of borewell, electricity bills and water rights certificates. On perusal of the documentary proofs placed by the applicants in proof of contention, no doubt the suit scheduled properties stand in the name of the father of the plaintiff as per the order of the Land Tribunal. Applicant plaintiff have established prima facie case that placing materials. The case is totally different from the title. Opponents have not challenged the prima facie material placed by the applicants by placing documents in support of their contention. Under the circumstances, I am of the opinion that plaintiff have made out a prima facie case in his favor. Point number 2 and 3. These points are taken up together for discussion for the sake of convenience. Person who approaches the court for equitable remedy of temporary injunction, besides making out strong prima facie case, must necessarily show that balance of convenience lies in his or her favor and would satisfy that irreparable loss and hardship would be caused to him, her, which cannot be compensated in terms of money. Therefore, it is incumbent upon the applicant plaintiff to show the balance of convenience. Considering the question of balance of convenience, court has to consider to whom hardship or inconvenience to be caused. If temporary relief is not granted, defendants would not be put to loss of hardship. Had discussed supra, applicant plaintiff is well established prima facie possession over the suit scheduled property as on date of the suit. If an order of temporary injunction is not granted, opponent defendant will be successful in interfering with the applicant plaintiff from the suit scheduled properties. In such an event, the applicant plaintiff would be left to go nowhere. Therefore, balance of convenience. Point 4. In view of my points number 2 to 3, I'm of the considered opinion that applicant plaintiff have made out a prima facie case and also made out a fit case for trial. Besides this, applicant plaintiff has also established a balance of convenience in his favor. Order of TI is denied, therefore so and so. Your Lordship may kindly see the date, 26th February 2024.
Yes.
Your Lordship, more than 1 year, 2 months now.
Yes.
Now he is coming, Your Lordship. Next, Your Lordship may kindly see MA. MA as page 214, Your Lordship may kindly see. Your Lordship, the relevant portion, Your Lordship, page 218, last portion. 218, last but 4th line. That the Land Tribunal members had visited the suit scheduled properties and dismissed the application filed by the ancestors of defendants.
Where 218?
218, last but 4th line, Your Lordship.
Yes.
This spot inspection and all has been done, that the Land Tribunal members had visited the suit scheduled properties and dismissed the application filed by the ancestors of the defendants.
Dismissed the application filed by the ancestor. Defendant are interfering the plaintiff is with the suit scheduled property. Hence, that plaintiff has. In case of the defendant, plaintiff has not. No, that lines are not found in that 218.
218, Your Lordship, is it paragraph?
Internal page 5. of the.
Internal page 5, please. Your Lordship may kindly see last but fifth line, that the land tribunal, Your Lordship finds it.
That the land tribunal.
Land tribunal members had visited the suit schedule properties and dismissed the application filed by the
That's
ancestors.
that Honorable High Court, that's the land, yes, that's the land tribunal.
Please.
That land tribunal members have visited that suit scheduled properties and dismissed the application filed by the ancestor of the defendant. Yes.
That the defendants are interfering with the plaintiff's peaceful possession. Before that, what Your Lordship read was that the High Court had also remanded fresh consideration. And before that, Your Lordship, there were 10 years lapse. So ancestors of defendants have done it. Then next round, these people, this is round 3 before Honorable High Court and round 5 before the lower court. Next, Your Lordship may kindly see the relevant portion at page 221, para 6. The respondents have filed objections. The objections, they stated that they were granted the land as per case number 1959-60. Page 221, Your Lordship, internal page 8.
221, yes.
Page 8, Your Lordship, para 6. This is respondents who are us, Your Lordship.
Yes.
The respondents have filed objections, and objections state that they were granted land as per case number 3 of 1959-60 by the special DC by norm abolition. They have further stated that the ancestors of the appellants have been granted 1/4 occupancy rights in the suit schedule property as per the aforesaid case. That the special DC for Remands had rejected the claim made by the ancestors of the appellant by order dated 24/1962 in case bearing number 13 of 1959-60 and other documents. Therefore, both have filed their cases. We have succeeded in 1959-60 in case number 3. They have failed in case number 13.
Yes.
And other documents as discussed above, that the respondents are in absolute possession and enjoyment of suit schedule property, and that the Revenue Appellate Tribunal in appeal number bearing number in 1962 had rejected the appeals filed by the ancestors of the appellants vide order dated 4/3/1964. That on 10/9/1974, after a lapse of 10 years, ancestors of the appellants have made another attempt at the suit schedule property by filing independent application in Form 7.
Notice we'll hear that matter. We'll hear. Yeah, since the order is passed in that July.
Please.
2024.
Correct.
We'll hear that. Yes.
Please, Your Lord.
Yes, you are appearing as a caveator.
Please.
Yes, caveator is directed to take notice. Read this matter on 3rd June.
Please,
Yes, we'll
obliged.
hear that.
Meanwhile, maybe statement.
No. No, mister. It is order is passed almost 8 months back.
But they are disturbing now.
Yeah. Yes. Let us see. Yes. Submission is accepted. In the meantime, directed to comply of subjection. Yes.
For order serial number 32, Saravana S for appellant.
I appear for
RS
the
Umesh.
respondent number 10.
Yes.
In this matter, the respondent number 10 is an institution which belongs to the community. We have filed the adjournment suit from 1976 onwards and we took the possession. In 2012, a suit for partition is filed by the relatives of the tenants who suffered the decree. Suit is dismissed. On the date of filing of the, admission.
Now, why it is posted today?
I have filed an application.
For what?
Permit me to put up fresh construction after obtaining the sanction plan for the community purposes. Because after the admission of the matter,
There is your application.
the application is filed IN number 1 of 25. Please.
Lords, I need to file objection because your lordship, my lords, by orders dated 22/2/2024, after hearing had passed the interim order, this application will overreach your lordship's order.
No, IA 1 of 2025 is filed with the respondent.
Yes.
Number 10, please.
Permission
Yes.
to put up the first application, have verified, modified, aforesaid order. So and so, under that circumstance, registry is directed to post the matter before the Honorable after obtaining the necessary order from the Chief Justice.
No, this is the order of the court. If your lordship were to see the application,
Your
virtually it seeks to overreach your lordship's order dated 22/2/2024.
No, that what is this order passed by this court?
No, on 22/2/2024, after hearing them, lordship directed them not to put up construction.
No, it's not like that.
2024.
It's not like that.
Wait, Mr.
I was putting up shed. I was
Finally there.
putting up a shed.
Finally there.
Order sheet is before.
Please.
Yes.
Let me issue notice to respondents here. are directed not to put up any further construction in the suit scheduled property till next date of hearing. However, they are permitted to carry on the work of connecting sewage line and electricity line. Appellants here are directed not to interfere with the respondent's position over the suit scheduled property. Yes.
Now they have filed the application to permit them to put up the construction. Not, so I will file my objection. This will overreach the orders of your lordships. I will file objection.
Yes.
Except R10, all the plaintiffs and other defendants, they claim to be the relatives.
Application, let us see what, yes.
I will file my
And your lordship kindly fix the date because the community wanted, the association wanted to put up a construction for the, purely for the benefit of the community students.
Yes.
And also to augment income. Your lordship, see the attitude of the appellant has not paid the process till date after 22/2/2024.
This court has said that
Please.
you may be permitted to put up a construction. If you want, you can seek for an vacating that.
Correct.
Modification again is that you are seeking an order which has been granted.
Revisit that.
Yes. My own order is you are this thing. If you have any grievance that you can file an application for vacating.
It's only for the clarification that
It is not. for
I
clarification.
want, that's why I made an application.
No, if you want
Permit me
clarification, I
to,
will clarify now itself.
permit me to take fresh plan from the authorities and to put up construction. It's not that the
Respondent hearing is-
continuation of that process.
Put up further construction in the suit scheduled property till next date of hearing. However, they are permitted to carry out work of the connecting sewage line and
That's all.
electricity line.
That has been done. That has been done. I'm not claiming any equity before this court. If the appellant succeeds, except the R10, all the other parties will get the property. If the respondent number 10 files an affidavit before this court that it is not going to file an equity, it is for the benefit of the entire parties. It is the society who invests the money to put up construction for the benefit of the community.
Permitted to carry on the work of connecting sewage and line electricity. The appellant herein are directed not to interfere with the respondent position. Suit scheduled property. Yes, you are only permitted.
On that day. That's why I made this application because the respondent number 10 in their meeting, they have taken a decision to put up a fresh construction after obtaining the permission
What is
from
that,
this
your
court.
application? Where is that application?
I number 1 of 25 years.
Where is that? 1 of 20. Extract ಮಾಡಿದ್ರು. Issue notice, respondent herein are directed not to put up a construction. Appellants herein is directed not to interfere. Subject to people respond seeking permission to put up the fresh construction. And said application would have very modified that aforesaid order. But the circumstances registration. Yes, you file an objection.
Friends, I will file objection.
What is that?
That's
Time may be fixed because next week.
ಅವ್ರಿಗೆ this application seems to be a disguise for final hearing. ಅದು ಇದ್ರೂ ಪರವಾಗಿಲ್ಲ. Matter date may be
ಅಲ್ಲ,
fixed. we will add
parties
them.
ಗೆ-
Final hearing cannot be before me that you have to
ಅದಕ್ಕೆ
file an
that's it.
objection only.
Seems that is the reason the application they have filed.
ಪ್ರಾಸೆಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರು ಇವತ್ತಿನವರೆಗೂ ಒಬ್ಬ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೂ ಪ್ರಾಸೆಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅವರು.
ನಿಮ್ದು ಅಪ್ಲಿಕೇಶನ್
ನಾನು ಕೇಳಿದ್ದೆ ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಹೇಳಿ.
ಏನ್ ಮ್ಯಾಟರ್ ಬೇಕಾದ್ರೆ
Notice ತಗೊಳ್ತೀನಿ ನಾನು.
ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಹೇಳ್ಬಿಟ್ಟು ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ. ಗೋ ಬಿಫೋರ್ ದ ಸೇಮ್ ಡೇ.
ಬೇಡ ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ ಪ್ಲೀಸ್.
Yes,
ನಮ್ಮ ಮುಂದೆನೆ ಬರುತ್ತೆ ಅದಕ್ಕೋಸ್ಕರ.
On 3rd June.
Please, ma'am.
If it is possible before vacation.
ಇಲ್ಲ
ಆಗೋದಿಲ್ಲ.
I will take a chance please.
ನಮ್ಮ senior ಇರಲ್ಲ. Will be out of.
Applications way you have started arguing, no? I know that all other my GMCPC's matter will be GMCPC matter ಗೊತ್ತಲ್ಲ. ನಾಳೆ ಎವಿಡೆನ್ಸ್ ಹಾಕೊಂಡಿರೋ ಸ್ವಾಮಿ, ನಾಳೆ ಹಾಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಇಲ್ಲಿ ಏನಾಗಿದೆ, ಪ್ರಾಪರ್ಟಿ ವೇಕೆಂಟ್ ಪೊಸೆಷನ್ ಇಲ್ಲದೆ ಎಲ್ಲ ಪೂರ್ತಿ ಡೆಮಾಲಿಷ್ ಮಾಡಿ ಒಂದು ಸಣ್ಣ
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆದ್ರೆ ಆರಾಮಾಗಿದ್ರೆ ನಿಮ್ದು ಇಯರ್
ಅಲ್ಲ ತಮ್ಮ ಮುಂದೆನೆ ಬರುತ್ತೆ ಈಗ. ಯಾಕಂದ್ರೆ
ಹೇಳಿದ್ದು ಬೇರೆ ರೋಸ್ಟರ್ ಇದ್ದು ಆರಾಮಾಗಿದ್ರೆ ನಿಮ್ದು ಇಯರ್ ಮಾಡೋಣ. ಈಗ ಸಿ ಮೈ ರೋಸ್ಟರ್ 200 ಮ್ಯಾಟರ್ಸ್
ರೋಸ್ಟರ್ ಇಲ್ಲ ಅಂದ್ರೆ ತಮ್ಮ ಮುಂದೆನೆ ಬರ್ತೀವಿ ಇವಾಗ ಆರ್ಡರ್ ಆಗಿರೋದು.
ಸೇಯಿಂಗ್ ದಟ್
I got it.
ಇವಾಗ ಅದು ಫ್ಯಾಗ್ ಅಂಡ್ ಅಲ್ಲಿ GMCPC ದಿನಕ್ಕೆ 200 ಮ್ಯಾಟರ್ ಮೂವ್ ಮಾಡ್ತಾರೆ.
I got it. Only request is that if possible before vacation I will take a chance.
ಆಗಲ್ಲ.
If possible.
Hardly in 5-6
25th or like.
Let us see.
If possible to satisfy my client also because.
Yes, on 29th.
Please.
Yes.
Objection. Let there be an objection to before that. 19th March I heard the copy on him.
Yes. Yes. Interim order granted earlier is extended till next date of.
Cell number 33, but
This case, my lord.
Yes.
I am appearing for petitioner. Challenge before this honorable court.
Legible copy. Yes.
I'll produce that can be read.
Yes.
I have challenged, my lord, order passed by the trial court that is, my lord, at page number 148. That is order sheet, my lord, that which we have entire order sheet. That appointment of a commissioner for, my lord, division in FDP proceedings 3 of 2002.
Yes.
My lord, kindly see ink page number 28. There are two suits, original suits.
No, suit for?
Suit for one is partition, one for injunction. That is OS number 106/83 and 106, and my lord, another suit is 324 of 2009.
Partition and?
Partition and separate position.
Yes.
Then, my lord, this that said suit came to be decreed. Kindly see in page number 50. OS number 106 of 83 is decreed and 324 is dismissed. Then, my lord, appeal came to be filed. Kindly see, my lord, the appeal which we have produced, relevant portion of the appeal, my lord, order. I'll draw your lordship's attention to. My lord, kindly come to ink page number, my lord, 95. Both appeal came to be filed. One appeal I have filed, another appeal, my lord, the defendants have filed. Para 23, my lord, ink page number 95. I have already discussed Supra, even though the plaintiff we having share in item number 1 and 2 of the plain scheduled properties. Those properties are not available for partition as they are already sold by the first defendant before filing the suit and also after filing the suit to several persons as the defendant, first defendant from 83 sites. In second item, if the suit scheduled property and sold the different persons and some of the properties have been constructed buildings. I have also pointed out, Supra, that the first defendant redeemed the mortgage by paying the mortgage money, mortgage amount created by her father. Therefore, the defendant has to be adjusted during the partition. The evidence on record disclosed that the defendant 4 to 5 had sold their shares in item number 1 and 2 of the suit scheduled properties to the defendant, first defendant. Therefore, she was having 13/15 share in item number 1 and 2 of the plain scheduled properties. Under these circumstances, in order to protect the right of bona fide purchasers and also affect equitable partition, it is necessary to order share of the plaintiff to adjust in the unencumbered portion of the land in item number 3 to 5. As pointed out, Supra, there is also lapse on the part of the plaintiff in prosecuting the suit and their grave opportunity to the defendant to sell item number 2 of the suit scheduled properties to the different persons as the plaintiff did not having being the suit for partition in initial stage, and they have converted the suit for partition after lapse of 13 years of filing the suit. As discussed, Supra, plaintiffs are entitled for 1/15th share each in the suit scheduled property, as all the suit scheduled properties are admittedly ancestral properties of the father of the appellant. Then, my lord, kindly see, on going through the above judgment decree, the trial court can be seen that even though there is a clear evidence on record to show that first item of the scheduled property has been adjusted by government, acquired by the government and not available for partition, of trial court has decreed the suit with respect to the said properties also.
Yes, now what is that you are?
Ultimately, my lord, court hold that insofar as site sold to be adjusted, operative portion of the order, it 98, my lord.
Yes.
That I am the purchaser of the property in item number 2.
Yes.
And the court has hold that that property has to be allotted first defendant only.
Where is that operative portion?
Operative portion is 98, my lord.
Yes.
The appeal RA number 46 is partly allowed. The judgment and decree passed by the additional civil judge so-and-so JMFC Anakal in OS number 106 is modified. The suit in OS number 106/83 is partly decreed. The plaintiff number 1 and 2 in OS number 106/83.
Item number 2, suit scheduled property shall be allotted to that share of the defendant number
1.
5.
Even
so that right and possession of the purchaser of the suit,
yes,
in that properties is protected.
Protected. Then, my lord, kindly see, they have filed appeal before this honorable court. In the RFA, my lord, 3018 of 2006 and 67 of 2007, as against the said order. In that said order, my lord, that they have made a withdrawal application. However, by withdrawing, my lord, that we have objected. The trial court order has not been has to be considered by the trial court. Accordingly, the court, my lord, while permitting the withdrawal of the appeal, court has referred the above said order, and my lord, the ultimately permitted to withdraw.
Yes.
Kindly see the operative portion of the
They
order.
are withdrawn only RSA.
RSA.
Allige RFA.
Page.
RA is confirmed.
Yes, 121, page 121. ಇದನ್ನ reproduce ಮಾಡಿ, because my lord, trial court has to consider ಅಂತ.
Now what is that?
ಈಗ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ, without referring this, trial court has passed impugned order.
Where is that?
That is my lord, inquiry number 148. Para 4. The petitioners have filed application for appointment of a commissioner. Para 140, page 148. In FDP 3 of 2002. The petitioners have filed application appointment of commissioner effect the partition of 1/5 share or one of the
Now it needs.
it is noted that the petitioner and defendants have got 1/5 share in the
ಆಯ್ತು, ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಕ್ ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ದಾರೆ. ಆದ್ರೆ ಇದ್ರಲ್ಲಿ ಏನಾಗ್ಬೇಕು, ಕಮಿಷನರ್ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತಂದ್ರೆ ಎಲ್ಲಾ ಪ್ರಾಪರ್ಟಿನು, ಬಿಕಾಸ್ ದಿಸ್ ರೆಫರೆನ್ಸ್ ಆಗ್ಬೇಕಾಗಿತ್ತು ಈ ಆರ್ಡರ್. ಈ ಆರ್ಡರ್ ಬಿಕಾಸ್ ಕಮಿಷನರ್ ಹ್ಯಾಸ್ ನಾಟ್ ನೋನ್ ದರ್ ಇಸ್ ಎನ್ ಆರ್ಡರ್. ಈ ಹಿಂಗೆ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ಕಮಿಷನರ್ ಈ ಆರ್ಡರ್ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಮಾಡಿ.
No, commissioner has to give a report in terms of that RA.
ಅದೇ ಅದು ಏನಾಗಿದೆ, ಅದನ್ನ ಮಾಡಿಲ್ಲ ಅವರು ಆರ್ಡರ್ ಅಲ್ಲಿ.
ಎಲ್ಲಿದೆ ರಿಪೋರ್ಟ್?
ಅಲ್ಲ ರಿಪೋರ್ಟ್ ಅಲ್ಲ ಇದರಲ್ಲಿ
ಕಮಿಷನರ್ ವಿಲ್
ರಿಪೋರ್ಟ್ ಹಾಕಿಲ್ಲ. ಮೊನ್ನೆ ಆರ್ಡರ್ ಆಗಿದೆ. ನಾವು ವಾರೆಂಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಇಶ್ಯೂಡ್. ಈ ಆರ್ಡರ್ ರೆಫರ್ ಆಗಿ ಇದ್ರ ಪ್ರಕಾರ ಮಾಡಬೇಕು ಅಂತ ಕಮಿಷನರ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರೆ ಅವ್ರು ಮಾಡ್ತಿದ್ರು. ಇಲ್ಲಿ ಏನ್ ಡೈರೆಕ್ಷನ್ ಇಲ್ಲ. ಸೊ ಸಿಂಪ್ಲಿ ಸಿ ಹ್ಯಾಸ್ ದ ಲರ್ನೆಡ್ ಜಡ್ಜ್ ಹ್ಯಾಸ್
an implied, mister. He has to execute that order which is passed by.
With great respect to your lordship.
How can you say that he is not?
ಕಮಿಷನರ್ಗೆ, ಕೋರ್ಟ್ ಕಮಿಷನರ್, ತಹಶೀಲ್ದಾರಿಗೆ ಅಪಾಯಿಂಟ್ ಆದವರಿಗೆ ಇದು ರೆಫರ್ ಹಿಂಗೆ ಮಾಡಿ ಅಂತ ಹೇಳದೆ ಇದ್ರೆ ಪಾರ್ಟಿಷನ್ ಅವ್ರು ಡೈರೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತಾರೆ. ಬಿಕಾಸ್ ಲಾರ್ಡ್ ಹಿ ಡೋಂಟ್ ನೋ. ಇದೊಂದು ರೆಫರ್ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಸಾಕು.
ಅವರು ಇದನ್ನ ರಿಪೋರ್ಟ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಗ್ರಿ ನೋಡಲ್ವಾ
ಅವರು? ಬಿಕಾಸ್ ಕೋರ್ಟ್ ಕಮಿಷನರ್, ಬಿಕಾಸ್ ದಿಸ್ ಇಸ್ ಇನ್ FDP ಪ್ರೊಸೀಡಿಂಗ್ಸ್, ಡೈರೆಕ್ಟ್ಲಿ ಈ ರೆಫರೆನ್ಸ್ ಇಲ್ಲದೆ ಇದ್ರೆ ಹೈಕೋರ್ಟ್ ಮತ್ತೆ ಅಪಿಲೇಟ್ ಕೋರ್ಟ್ ರೆಫರೆನ್ಸ್ ಮಾಡಿದೆ, ತಾವು ಈ ಆರ್ಡರ್ ನಲ್ಲಿ ಇದನ್ನ ರೆಫರ್ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರು ಸಾಕು ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗೆ. ಇದೊಂದು ರೆಫರ್ ಆಗ್ಬಿಟ್ರೆ ತಹಸೀಲ್ದಾರ್ ವೈಲ್ ಪಾರ್ಟಿಷನ್ ಎಫೆಕ್ಟಿಂಗ್ ದಿ ಪಾರ್ಟಿಷನ್ ಸೈಟ್ ಓನರ್ಸ್ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ತಾರೆ. ಇಲ್ಲ ಅಂತಂದ್ರೆ 5 ಭಾಗ ಮಾಡಿ ತಂದು ಹಾಕ್ಬಿಡ್ತಾರೆ.
PC to appoint a Tahsildar. Now where is that application filed for an FDP?
FDP application, my lord, kindly see ink page number 140. Ink page number 140. For the reasons, ink page number 140 starts from my lord 139.
Effect the partition of 2/5 share of the suit schedule property.
Yes.
Item 2(5) by affecting the partition with meets and bonds, put the plaintiff in separate position, shares in that interest and justice at equity.
ಈ ರೆಫರೆನ್ಸ್ ಇಲ್ಲದೆ,
Yes.
please. Therefore, my lord, I am seeking, my lord, a stay of that portion of the order.
How issue notice. Stay of order dated 27/3/2025, passed in the FDP number 3 of 2002.
2002. Appeal pending ittu.
Yes. Passed by third additional civil judge JMFC Anekal till next date of hearing. Yes. Legible copy. Yes. Office objection is overruled. Yes. Yes.
My lords,
May I have your lordship?
serial number 76.
Kindly, my lord.
My lords, serial number 76 was substantially heard by your lordship last time, and it is not reaching, and the execution proceedings are stranded, my lordship. And the DHR senior citizens are.
You want after vacation, I will fix date. Before vacation, I can't, mister.
Time at least. Before vacation, any date and time may be fixed, my lordship.
Every day I will give. I will
But
say
it's
that
not
every day
reaching, my
will
lordship.
not
It is
reach. What?
2 terms, we are almost 12 times, my lordship.
ಎಲ್ಲಾ
Kindly-
ಮ್ಯಾಟರ್ಗಳನ್ನು ಎಲ್ಲವೂ ನನ್ನ ಮುಂದೆ ಒಂದೊಂದ್ಸರಿ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದಾರೆ. What to do?
Because your lordship had heard substantially that matter. My colleague Aditya.
What had all these things. Heard, pass an order. That's all. Yes.
My lord, sorry, my lord, one matter your lordships have adjourned to 22nd relating to auction of the property.
Yes.
Today, my lord, the auction at the spot was over. The court is taking up auction today. We submitted to the court that your lordships are seized with the matter. There's an IA pending. Court is saying there's no stay. I'm going to proceed with court auction.
No, that we have said that they can proceed only that.
Yes, those 24, my lord, they didn't get proper bids. Some made up bids were received. They didn't follow the procedure. We brought all this to notice of the executing court. This morning, my lord, this was submitted. The learned judge is even refusing to take our objections on record.
No, what they are going to pass?
The court is holding auction now in open court. Without a proclamation, without notice, nothing.
No, in respect of that.
Those flats only, my lord.
That we have no objection if it is
No
price has come.
Correct,
let
but
them-
the price, my lord, they got 1/3 the price.
Yes.
But there was no bidders at all. So one flat ಯಾರೋ ನೀವು ತಗೊಳ್ತೀರ ಅಂತ ಅವ್ರ ಹೆಸರು ಬರ್ಕೊಂಡ್ಬಿಟ್ರು.
No, the 20, beyond the 24 flats, they can't do anything.
They're
If
not
they are
doing,
not doing anything.
These 24 only, my lord, the procedure they followed is completely wrong. And this is brought to the notice of the land presiding officer today in the commercial court. He's not willing to not even say, all right, we'll postpone it and we'll await the order of the Honorable High Court. He doesn't say this copy of the application is placed before him.
Yes, Monday, we'll see on Monday. Yes.
Would it be in the end of the list, my lord?
No,
I'll take
other side has to be served. And
I will
yes,
serve, my lord, and inform.
There are other connected matters also. Monday, let us see that.
ಅಲ್ಲ ಇದು ಒಂದು ಮ್ಯಾಟರ್ ಮಾತ್ರ connected, my lord, are by individuals.
Then Monday, we'll see that on that Monday. Yes.
My lords,
Second list, 40? 49. Second list. Second list all adjourn again.
my lord, serial number 18, my lord. My lord,
Interim order extended.
my lord, serial number 18 has been passed over, my lord, for compliance of office objections. My lord, I am yet to receive a document. May I request that the matter may be taken up 22nd, my lord.
Serial number?
2018, my lord, 18.
You are appearing for
The petitioner, my lord.
the request of counsel for the petitioner. ಯಾವತ್ತಿಗೆ ಹೋಯ್ತು? Pass over ಆಗಿದೆ.
Pass over, 22nd, my lord.
This matter on 22nd.
Your
Great.
Lordship,
My lord, serial number 61.
18, in the meantime, office objection. 18 ಪಾಸ್ ಓವರ್ ಆಗಿಲ್ಲ. ಪಾಸ್ ಓವರ್ ಏನು ಯಾವ್ದು? 22 ಎಂಟ್ರಿ ಮಾಡ್ರು ನಿಮ್ ಕೋರ್ಸ್ ಅದು ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 49.
ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್ ಈಗ ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರ 2:30ಗೆ ಇಲ್ಲ ಪಾಸ್ ಓವರ್ ತಗತ್ತಾರ?
ಏನು ಕೇಳ್ಬೇಡಿ ಎಲ್ಲ
ಈಗ 2:30ಗೆ ಪಾಸ್ ಓವರ್ ತಗತ್ತಾರ, ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ
ಯಾವುದು ಸೀಕ್ರೆಟ್ಸ್ ಕೊಡಲ್ಲ ಸರ್. ಆಮೇಲೆ ನನ್ ಬಂದು ಒಂದು ಕೇಳ್ತಾರೆ, ಬಂತಾ ಇದೆಯಾ ನೋಡ್ತಾರೆ.
Sir, serial number 18, 22nd, sir. ಅದು ಸ್ವಲ್ಪ ಕನ್ಫರ್ಮ್ ಆಯ್ತಲ್ವಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 18 ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು, ಇವಾಗ ಕೇಳಿದ್ನಲ್ಲ 22nd.
ಆಯ್ತಾ?
ಓಕೆ.
ಬೇಡವಾ?
ಅಲ್ಲ ಬೇಕು, ಅದಕ್ಕೆ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೋತಾ ಇದೀನಿ ಅಷ್ಟೇ.
ಯಾರು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಳ್ಳಲ್ಲ. ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಎಲ್ಲ ಔಟ್.
ಮೆಮೊ ಬುಕ್ ಇಲ್ಲ ಸರ್ ಅಲ್ಲಿ ಇದೆ.
ಇಲ್ಲ ಯಾಕಂದ್ರೆ ಸಬ್ಬಿ ಗರಂ ಇರಲಿಲ್ಲ ಕಲ್ಯಾಣ.
ಪಾನ್ಕ ಎಷ್ಟು ಬೆಳೆಯಲ್ಲ ಸಖತ್ತಾಗೈತ್ರಿ ಪಿಕಲ್ ಪಂಚ್ ಬೆಲ್ದನ್ ಪಾನ್ಕ ಅದಕ್ಕೆ
ಇದು ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು ಸರ್ 28.
ನಾನು ಅರುಣ್ ಸಾಹೇಬ್. ಹಾ. ಏನಮ್ಮ 20 ಯಾವ ಲಿಸ್ಟ್? ನೋಟಿಸ್ ಹೇಳಿ ಸರ್. ನಾಳೆ ನಾಡಿದ್ದು ರಜೆ. ಮಂಗಳವಾರ ಪ್ಲೀಸ್. ಹಾ, ಇವತ್ತು ಬಂದಿದ್ದೀವಿ ಸರ್. ಹತ್ತತ್ರ ಬಂದಿದ್ದೀವಿ. ಇವತ್ತು ಹತ್ತತ್ರ ಇದ್ದೀವಿ. ವೆರಿ ನಿಯರ್ ಬೈ ಇದ್ದೀವಿ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 34 ನಾವು. ನಿಮ್ದೆಷ್ಟು? $83. ಹೌದೌದು. ರೀಚ್ ಮಾಡಿಸ್ತಾ ಇದ್ದೀರಾ? ಏನಪ್ಪ ಬೇಡ, ನಿಮ್ ಲಿಸ್ಟ್ ನಿಮ್ದೇನೆ. ಇವಾಗ ಕೂಡ ಫೈಲಲ್ಲಿ ಇರ್ತದೆ. ಅವ್ರಿಗೇನ್ ಬೇಡ. ಯಾವ್ದೋ ಒಂದು ಬರ್ಕೊಂಡಿದ್ದೀನಿ ನಾನು ಅದಕ್ಕೆ. ಆಯ್ತು ಬರ್ಕೊಳಪ್ಪ. ಹಿಂದೆ ತಲುಪಿಲ್ಲ ಅಂದ್ರೆ ಆಟೋಮೆಟಿಕ್ ನಾಟ್ ರೀಚ್ ಮ್ಯಾಟರ್ ಅಡ್ಜರ್ನ್ ಆಗುತ್ತೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಫುಲ್ಲು ಕೋರ್ಟ್ ಇದೆ, ಫುಲ್ಲು ಜಾಸ್ತಿ.
ಪೋಸ್ಟಿಂಗ್ ಮಾಡಕ್ ಪೋಸ್ಟಿಂಗ್ ಮಾಡಿಸೋದು ಅದೇ ಹೇಳಿದ್ದ ನಾನೇನು ಹೇಳಕ್ ಕರೆದ್ರೆ ನೀನೇನ್ ಪೋಸ್ಟಿಂಗ್ ಕೊಡು. ಓಕೆ
Yes, serial number 153, my lordship. Case. Lordship may kindly accommodate me on 26th, my lordship. I will take a chance for 26th Saturday, working day.
153, the request reached this matter on Saturday.
Interim order, my kindly.
Interim order granted earlier is extended to next day.
This honorable court kind leave. Serial number 158 was mentioned last week and your lordship had directed it to be listed on 4/6. ಅದು before vacation I had requested orders ಅಥವಾ 2:30 ತಗೊಳಕ್ ಆಗತ್ತೆ ಅಂತ ಅಥವಾ ಆಗಲ್ಲ ಅಂತಂದ್ರೆ 4/6 ಗೆ ಅಡ್ಜರ್ನ್ ಮಾಡಿದ್ವಿ ಬಟ್ ತಿರ್ಗಾ ಬರ್ತಾ ಇದೆ ಅದು. Every 2 days 158.
158.
I am there is urgency for me. ನನಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಬಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಸೆಡ್ ಆರ್ಡರ್ಸ್ ಕು ತಗೊಳಕ್ ಆಗಲ್ಲ.
I remember that. Yes, 150 na?
158.
158. ಯಾಕ್ರಿ ಅವತ್ತು ಹೇಳಿದ್ವಲ್ಲ ಯಾಕ್ರಿ ಮತ್ತೆ
ಅಲ್ಲ 446 I got to know that it was adjourned on the request of the council whatever. Because I moved later and then later on it was listed ಮೊನ್ನೆ ಅವತ್ತು ಲಿಸ್ಟ್ ಆಗಿತ್ತು and after that today it is listed. There is just 10 minutes of that is all submission.
5 minutes ಬೇಕಷ್ಟೇ.
End of the list or any date next week I can.
Only if it is reached I will take that. Yes.
ಆಗ್ಬೋದು.
Yes.
Reach ಆಗಿಲ್ಲ. I
Let us see if they were taking a chance, let them take.
ನನಗೆ 5 minutes ಬೇಕಷ್ಟೇ ಅವತ್ತಿಂದ ಅದೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅವರು ರೀಚ್ ಆದ್ರೆ ಅವ್ರು ಮಾಡಿ ಅಂತ ಹೇಳಿದೀನಿ ನೋಡೋಣ ಬಿಡಿ ಆಯ್ತು.
ಅಲ್ಲ ನನಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ 5 minutes ಸಾಕು ನನಗೆ ಅಷ್ಟೇ ಯಾವತ್ತಲ್ಲ.
Even if your urgency you said after vacation she
ನಾನು
wants.
ಹೇಳಿದ್ದು 2:30 ತಗೊಳಕ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬೇರೆ ದಿನ ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ.
No, I know the mister, it has happened in before my court only, but she wants still matters to be there in that list. Let it be there. Let us see that. Yes.
Please.
Yes. Yes.
Serial number 34, Jayaprakash Shetty B.
Matter. DCF already paid on 15/12.
What is that office objection? Court fee has been paid.
Paid. That is on 15th.
Yes.
Now the officers raise objection.
To be stated and registration certificate to be, IA is to be challenged in the writ petition. Writ petition is not maintainable against the order dated so and so. What is this, Mr.?
Common order has been passed on IA number 123. IA number 1 is concerned under order 39 rule 1 and 2. Sought for a temporary injection not to sublet the property. IA number 2 filed under section 12A1 of the Commercial Court Act. Exemption from approach is the premediation. IA 3 filed by me for rejection of the plaint on the ground that without invoking section 12A in terms of the judgment of Supreme Court, the suit is not maintainable.
Yes.
My application was rejected on the ground that the judgment cited by me is a partial automation case is in respect of the suit for recovery.
Which is that IA in which there is an appeal maintainable before the commercial court.
That is IA number, no, they file IA number 2 for exemption to file a suit. There is no urgency application filed under section 12A. 12A is for
No, IA number 1 is challenging in this, which is that IA number?
IA number 1 under order 39 rule 1 and 2 H page 25.
Order 39 rule 1 and 2.
Is IA number 1.
Against that there is an appeal. You have to go before the
No,
division bench.
there is a common order has been passed. There is no separate order. Even otherwise also, it may not affect me also.
No, if you are challenging that order, even though a common order has been passed, in respect of that IA, you have to file an appeal. It's an,
please.
Even though order has been passed commonly, which is affected, you have to be challenged there. In respect of that office.
2 and 3, it's
yes, you confirm that only a 2 and 3.
Please, Lordship, kindly see the IA, next IA filed.
What is that 2 and 3?
2 and 3, 2 is application filed under section 12A, 1 of the Commercial Codes Act, seeking for exemption from pre-institution mediation.
3?
3, rejection of the plaint filed by me. Section 12A is it mandates that
your application for rejection is dismissed.
That there is mandatory provision is not followed.
That is dismissed.
That is dismissed.
Then you amend that prior only for 2 and 3.
2 and 3 I will
pass off. Yes.
Yes, I will.
Serial number 35, HM Madhusudana.
For the petitioner, my lord. My lord.
Yes.
My lord, may kindly look into the page, ink page number 34, my lord. Half subjections 34 on ನಿಮಿಷ ನೋಡಿ. It's an petition filed by the petitioner against the order passed by the Honorable Senior Civil Judge Court and the day 1 orders, Your Honors.
Order passed under
39 rule 1 and 2. An ex parte order, my lord, may kindly appreciate ink page number 34. On 29/3/2024, Your Honor may kindly appreciate on the same day itself I have filed the wakalat for defendant number 1. The same can be looked into, my lord. On the same day, defendant number 1 has filed the wakalat, but however, without serving any copies, and then order has been passed against me. Your Honor, kindly at this moment, the sum and substance of the case of the
office is raised the objection regarding that maintained bit.
ಅದೇ 43 rule 1 ನಲ್ಲಿ appeal ಹಾಕೋಬೇಕಾಗಿತ್ತು ಅಂತ. Your Honor, may kindly I have not challenged the 39 rule 2 regarding the entire order passed by the honorable court. Whether an order can be passed when the wakalat has been filed by the defendant, an ex parte order can be passed, my lord. Under rule 19 ನಲ್ಲಿ, my lord, may kindly appreciate rule 19 ನಲ್ಲಿ
the said suit the present plaintiff
provided
application to change the kata since the declaration suit is pending in the suit should property same parties alienate the suit should property change the kata it leads to multi-suit as delay and matches defendants anybody is claiming hereby.
May permits me, Your Honor, kindly please. Rule 19 of rules of practice ali, every interlocutory application shall after presentation be numbered and posted before the court for orders, provided that when any party likely to be affected by it has already entered appearance by pleader, no such application shall be posted unless such pleader has been served with notice
That
of
is
the
a
application.
ground.
My lord, may kindly when
That is a ground
even though
challenging
the
order which is
passed by. Your Honor, may
that against that order passed under 39 1 and 2 there is an appeal provided.
Provided under 43 rule on right, but my lord, may kindly appreciate at this moment the sum and substance of the case a compromise.
No, you argue on that maintenance.
Order 43 rule 1 ನಲ್ಲಿ My lord, 43 rule 1 ರಲ್ಲಿ an order under 39 order under rule 1 and 2 and rule 4 and rule 10 of order 39 inside this one. An appealable.
Where is that
The order
39
43 rule 1 plus R, my lord.
R.
R.
Yes, any order under order 39 rule 1 and 2 and rule 4 rule 10. Yes.
It is an appealable order. Your Honor, my case before this honorable court, whether an ex parte order, when the defendant has appeared the wakalat, Your Honor, order 39 rule 3 comply ಮಾಡಬೇಕಾದ್ರೆ, Your Honor, when the non-appearance, Your Honor may kindly appreciate issue suit summons and TA notice comply with provision of order 39 rule 3 of CPC ಅಂತ ಮಾಡಿದ್ದಾರೆ. When the defendant has already appeared, Your Honor may kindly look into order 39 rule 3 of CPC for a moment.
Before, my lord, may I read, my lord? Before granting of injunction, court to direct notice to opposite party. The court shall, in all cases except where it appears that the object of granting injunction would be defeated by the delay, before granting of the injunction, direct the notice of the application for the same to be given to the opposite party.
39.
Rule 3, my lord, 3A. 3 ಮತ್ತೆ 3A. 3 applicable ಆಗೋದು provided that where it is proposed to grant an injunction without giving notice of the application to the opposite party, my lord. Here is the case where when I have already filed the wakalat. ನಾನು ವಕಾಲತ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ವೆದರ್ ಎಕ್ಸ್ ಪಾರ್ಟಿ ಆರ್ಡರ್ ಕ್ಯಾನ್ ಬಿ ಗ್ರಾಂಟೆಡ್ ಮೇಲೆ ನಾನು ಅವತ್ತೇ ಹೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿಗೆ ನಾನು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇವಾಗ ಅವತ್ತೇ ಫೈಲ್ ಮಾಡ್ತೀನಿ ಅಂತ. ದ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಡೈರೆಕ್ಟೆಡ್ ದ ಅಪೋಸಿಟ್ ಪಾರ್ಟಿ ಸರ್ವ್ ದ ಕಾಪೀಸ್. ನಾನು ಸರ್ವ್ ಮಾಡ್ತಾ ಅನ್ಕೊಂಡಿದ್ದೀನಿ, ಬಟ್ ಹವೆವರ್ ಆನ್ ದ ಸೇಮ್ ಡೇಟ್ ದ ಆನರಬಲ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಪಾಸ್ಡ್ ದಿ ಆರ್ಡರ್ಸ್. ಯುವರ್ ಆನರ್ಸ್ ಮೇ ಕೈಂಡ್ಲಿ ಅಪ್ರಿಷಿಯೇಟ್ ಅಟ್ ದಿಸ್ ಮೊಮೆಂಟ್ ಇಷ್ಟಕ್ಕೆ ಆಗಲ್ಲ ಸ್ವಾಮಿ. ದಿಸ್ ಒಂದ್ ನಿಮಿಷ ಸಮನ್ ಸಬ್ಸ್ಟೆನ್ಸ್ ಕೇಸ್ ಹೇಳ್ತೇನೆ, ಆಮೇಲೆ ಇಫ್ ಆನರ್ಸ್
I am not convinced that. I am not convinced that. I am not convinced that I said appeal is maintainable.
All appeal is maintainable, my lord. But however, the prima facie, my lord, whether 39 rule 3 comply ಮಾಡಕ್ಕೆ when the defense
In that appeal you taken a ground that not before this court. Yes, tell.
liberty to file fresh appeal ಅಂತ ಮಾಡಿ.
Yes. The office has raised an objection regarding maintainability on the ground that the order which is challenged is passed under order 39 rule 1 and 2. The parties has a remedy of appeal under order 43 rule 1R. Since the order, since in the prayer they're seeking set aside that order passed on IA number 1 and 2, which is passed under 39 1 and 2, rule 39 1 and 2 of CPC. Therefore, office objection is sustained. Accordingly, the petition is
seeking liberty, your honor.
Yes, dismissed as not maintainable with liberty to the petitioner to approach appropriately.
Bill number 36, VB Ravishankar.
Petitioner, your lord. In this case, Lord, I undertake to wakalat for respondent number 1 plaintiff. Lord, the matter is before 24th of this month. The lordship may kindly have it on 23rd. In the meantime, my lord, if they serve a copy of the writ petition, I'll file, my lord, if required, statement of objections.
I'll serve a copy upon them.
You have any objection for 22nd or 23rd?
I don't have the simple reason whether the court had become a functus officio. Once an order has been passed, whether the court can recall the same order.
Anyhow, you want
And relying upon a judgment of the this court now.
24th ki there.
Yes, 23rd. Yes, at the request of counsel for that.
I'll serve a copy.
You will take notice for
I'll take, my lord, for respondent number 1, Puneet C.
Now leave this matter on 23rd. I will not say that you will take notice, Mr.
Please, my
Once
lord.
it is say take notice, it will go in the B group. Again, you will be in the trouble.
Please, your lords.
Then we can't-
Then there is urgency in the matter now, your lords.
Notice one tashna service.
ಆಗ್ಬೋದು.
See, I can't pick one matter from the B group.
I understand,
Because
my
of
lord.
this problem. Therefore,
Please,
let it be in the same. You
23rd,
appear on that day.
23rd.
Yes.
Office objections will be overruled, your lords. Al ಒಂದು office objections ಏನಂದ್ರೆ 2 to 4 are complied, your lords. ಆಮೇಲೆ
No, now
last
we will do one thing. You take notice. Let that office objection is there. Then it will be listed in the
1 to 4, 2 to 4 are complied. The first office
ಆಯ್ತ್ರಿ
objection.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತಾನೆ ಇರ್ಲಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಮೇಲೆ ಬರ್ತದೆ. Otherwise, without hearing the matter, if it is go B group, then it will not reach me.
Please, your lords.
Because I can't take one matter. You know that every day, so many advocates are waiting that for B group matters. What to do? Yes. You are taking notice to whom?
Please, my lord, for respondent number 1, plaintiff Giriamma.
Yes, so and so is undertake to appear for respondent number 1. Office is directed to show his name. Please this matter. Counsel for the petitioner is directed to serve one set of copies. Please this matter on 23rd.
Please, your lords.
Serial number 37, Varadaraj PM.
I'm appealing for a petition on Malasita. Similar parties are there. One more petition, Malasita 9649 of 2022. Kindly request you to clip that both the matter and give next week, Malasita.
All this matter along with the so and so.
Date may be fixed in next week, Malasita.
ಅದು ಯಾವತ್ತಿದೆ? ಅವತ್ತೇ ಬರುತ್ತೆ ಅದ್ರ ಜೊತೆಗೆ. Yes.
Next week.
Next week, yes.
Serial number 38, Murthy
Acceptable.
TL.
Furnishing of PF. Yes, Murthy.
1 week time.
Week's time is granted to do the needful.
And through
Serial
hand
number
summons
39,
also.
Rakesh
Kindly
Kini.
say hand.
And
by
summons
hand.
you have not taken that.
I will serve the day after tomorrow. By hand through and court also.
ಅಲ್ರಿ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಕೊಟ್ಟಿದ್ದು ತಗೊಂಡಿದ್ದೀರಾ ಇಲ್ವಾ?
ತಗೊಂಡಿಲ್ಲ ಅದು ನನ್ನ
And fresh hand summons. That's what you have to do. Yes. Week's time is granted.
ಥ್ರೂ
to-
ಕೋರ್ಟ್ ಆಗಿರ್ಲಿ ಸಮಯ ಅಡ್ವೊಕೇಟ್ ತಗೊಳಲ್ಲ ಅಂದ್ರು ನಾನು ಹೋಗಿದ್ದೆ ಆಫೀಸ್ ಹತ್ರ ರೆಫ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ
Summons to the service of the
ಥ್ರೂ ಕೋರ್ಟ್
respondent.
ಅಂಡ್ ಬೈ ಹ್ಯಾಂಡ್.
No, you want to take hand summons to that party.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
ಆ
ಬೈ ಹ್ಯಾಂಡ್
ಕೊಟ್ಟಿದ್ವಲ್ಲ,
ಅಂಡ್ ಥ್ರೂ ಕೋರ್ಟ್ ಆಲ್ಸೋ. ಥ್ರೂ ಕೋರ್ಟ್ ಆಲ್ಸೋ.
Through court what? Notice.
ಎಸ್.
ಅದಿದೆ process ಕಟ್ಬೇಕು ನೀವು ಅಷ್ಟೇ. You want process, paid process, yes. Week's time is granted to pay the process to issue notice to respondents.
Serial number 30, 39, Rakesh Kini.
I appear for petitioner, my lord. In this matter, trial court advocate has served a copy on the other side, my lord. There is no acknowledgement. The each problem is on 24th, my lord, 22nd, matter is posted for judgment. On last date of hearing, it was posted for argument. Lords, I indicated I last time, but time was not granted. Now it's posted for judgment, my lord. Because may humbly be heard, my lord.
No, now then it is not served. You serve a hand summons and when is that next matter?
22nd, my lord.
22nd. You serve it on hand summons and we'll have it on 22nd.
22nd.
Yes. Pudi. The petitioner is permitted to take out hand summons to respondent number
1.
Respondent number 1. ಅವ್ರೊಬ್ರಿಗೆನಾ?
ಒಬ್ಬರಿಗೆ ಬೇರೆಯವರಿಗೆ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿ.
Yes, respondent number 1. Lease this matter on 22nd. Yes.
Serial number 40, Tumbegi Prabhu Gowda.
In this matter, I appear for the petitioner.
Respond number 3, my lord.
Lords, I am seeking only mandamus to not take up my application before the Lord of the trial court to and pass the order. Lord, page number 95 is my application. Lord.
Yes.
Lord, it is not decree holders, not of the writ petition. Lord, I have sought before the Lord of the trial court that Lord to permit the decree holder to Lord of the execute
No.
warrant.
Yes, what is that?
Lord, the suit is for Lord of the declaration and injunction, and Lord of the same was decree, and Lord of the directed the Lord of the respondent number 1 and 2 to Lord of the demolish the Lord of the unauthorized structure and hand over the possession. Lord, that could be seen from page number 35 is the Lord of the judgment. Lord of the operative portion is page number Lord of the page number 58 Lord operative portion. Against which Lord of the respondent number 1 and 2 Lord herein have approached Lord of this honorable court. Lord of their appeal RFI is not also dismissed, and
Yes.
Lord of the Lord of the specific order has been passed. That could be seen from page number 93 Lord.
No, you are the plaintiff.
I am the plaintiff Lord.
Yes,
Suit is decreed.
Your suit is decreed.
Decreed Lord.
Then appeal has
Against
been
which
filed.
Lord of the respondent 1 and 2 defendants over Lord filed the Lord of the RFA. Same was dismissed.
Yes.
And Lord directed them to Lord of the demolish the unauthorized construction and Lord of the hand over the position since they have not done. Lord, in execution petition, we have filed an application for Lord of the demolition of Lord that structure. Lord, the court has not
Happened that in
Lord that while executing the Lord of the decree, Lord of these Lord of the respondent number 1 and 2 Lord of set up their sister to Lord of the file an objector application which has been filed. Lords, in the Lord may take Lord of the operative Lord of the page number 28 Lord of the order sheet.
Yes.
Lord, the second para Lord of the bailiff filed the report. Counsel for the objector has stated that as per the order of this court, property in possession is not demolished. Not it is objectors, not in the possession of the objector, not demolished. And part of the property in possession of the judgment debtors have been demolished. And my lords, kindly see, my lord, kindly take my application, my lord, page number 95, my lords. What I sought is,
Yes.
my lord, the please to permit the decree holder to execute the warrant against the judgment debtor with liberty to contest the claim of the objector. Lords, may I take Lord of the page number 140, Lord, that is the plan, Lord, which has been submitted by the court commissioner.
140.
140, Lords. Lord, sketch, Lord of the sketch, Lord. That in sketch, Lords, my property is C, A, H and F, Lord, the decreed property.
CA.
C, A, H and F, my lords.
Yes.
This is the decree, my lord, the court decree. My lord, they, objector is claiming C, B, my lords, G, F, my lord, they are in possession of the property.
A, B, G, H ಇದೆ.
My lords, C in the Swami,
C ಎಲ್ಲಿದೆ?
A to C, my lords, and H to F. Lord, what the decreed, suit is decreed for.
No, C I didn't find that.
C, my lords,
C.
after B ಆದ್ಮೇಲೆ ಮೇಲ್ C ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ.
Yes, yes. Yours is?
ಅಲ್ಲಿಂದ ನಾವು ಡಿಗ್ರಿ ಆಗಿರೋದು ಸಿ ಎ ಎಚ್ ಅಂಡ್ ಎಫ್, ಅಲ್ಲಿಂದ ಅಲ್ಲಿವರೆಗೂ ಡಿಗ್ರಿ ಆಗಿದೆ.
H and F, yes.
Yes. Objector now, my lord, claiming is she is in possession of C, B, G and F.
C, B,
G and F.
G and F. This dotted mark and that is this.
ಅದನ್ನ ನಾವು ಬಿಟ್ಟು ಉಳಿದಿರೋದು ಓಡಕ್ಕೆ ನಮ್ಗೆ ಪರ್ಮಿಷನ್ ಕೊಡಿ ಅಂತ ನಾವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀವಿ. ಸಿನ್ಸ್ ಇಟ್ ಇಸ್ ಪೆಂಡಿಂಗ್, my lords, that is why my lord only take up this, my lord, the application and my lord, the pass the orders is the only my submission.
No, that it is respectfully pray this honorable court please to permit that degree holder to execute the warrant against the judgment debtor.
Application is pair number 95, my lord.
No, ನೀವು application ಅಲ್ಲಿ ಹೇಳಿದಿರಾ only this portion ಅಂತ.
Yes, my lord, kindly take up, my lord.
ಆಯ್ತು, let him consider in accordance with law.
ಅಲ್ಲ.
Let them argue. Yes. Now, who are you?
I am the objector before the trial court.
Let that application consider in accordance with law after giving
ಅಲ್ಲ,
it.
ಅವ್ರು ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ ಅಬ್ಜೆಕ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಮುಗಿದ್ಮೇಲೆ ನಾನು ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ ಅಂತಲ್ಲ ಅದನ್ನೇ ಹೇಳಿದಾರೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿ?
We are claiming entire property.
Now, where they have said that after that objector application will consider.
ಪೂರ್ಣ ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ. ಪ್ರೇ ಫಾರ್ ಟೈಮ್ ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ಸ್. ಅವ್ರು ಓನ್ಲಿ ಕಟ್ ಅಪ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಷ್ಟೇ ಹಾಕಿದ್ದಾರೆ.
Where is that? You don't have that.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ ಇಲ್ಲ ಅನ್ಕೊಂಡು ನಿನ್ನೆ ಕಾಪಿ ಸರ್ ಮಾಡಿದಾರೆ, ಹಾಗಾಗಿ ನಾವು ಅದು ಇದು ಮಾಡಕ್ಕಾಗಿ
Where is that order sheet?
My lord, I have produced, my lord, I have produced, my lord, kindly see the
ಎಂಟೈರ್
order
ಆರ್ಡರ್ ಶೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
my lord, the up to, my lord, the
ಅದಕ್ಕೋಸ್ಕರ
27/1/2025 ವರೆಗೂ ಮಾಡಿರ್ತೀವಿ.
ಅದಾದ ನಂತರ ಮಾಡಿಲ್ಲ ಅವರು.
ಅಲ್ಲ, ಅದಾದ್ಮೇಲೆ ಇದು
ಹಿಯರಿಂಗ್ ಆಗಿದೆ, ಬೋತ್ ಸೈಡ್ ಹಿಯರಿಂಗ್ ಆಗಿದೆ. ಆಫ್ಟರ್ ಹಿಯರಿಂಗ್ ಬೋತ್ ಸೈಡ್
ಎಲ್ಲೈತ್ರಿ ಅದು ತೋರ್ಸ್ರಿ.
ಪೇಜ್ ನಂಬರ್ 25, my lord, the last order sheet 29. 29 is the, my lord, last order sheet, my lord, which is posted on, my lord, the 27/1. ಅದು ಅಲ್ಲಿವರೆಗೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
No, is there any reference to that
ಇಲ್ಲ
application?
ಇಲ್ಲ sir. my lord, they are also aware that, my lord, there is no such reference.
No, application filed by you.
Yes, my lord.
Regarding that, any reference?
ಇಲ್ಲ ಸರ್.
ಅಲ್ಲ, regarding, my lord, that has been not been considered. That is why, my lord, I am come up before this honorable court.
1/1/25ಕ್ಕೆ
Objection.
This is was that report submitted by that
house.
Objectors his position not be demolished. Hence the plaintiff has carried out the part of the demolition work as per the order of this court.
Yes.
Hence bailiff has carried out that part of the demolition ಮಾಡಿದಾರಲ್ಲ.
ಅಲ್ಲ, ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದು ಇವ್ರ ಜಜ್ಮೆಂಟ್ ಡೇಟರ್ ಪೋರ್ಷನ್ ಇನ್ನ ಪೂರ್ತಿ ಆಗ್ಬೇಕು. My lord, now he come up with the objector application.
ಇವ್ರದ್ದು objector application let it be decided. It is their only
their portion. That is my grievance. That is the only
part ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ.
ಅಲ್ಲ, ಪಾರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಪೂರ್ತಿ ಮಾಡಕ್ಕೆ ನಮ್ಗೆ ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು.
Hence bailiff has carried out part of the demolition work as per
that is why, my lords, we have made an application.
Yes. Where is that application?
95 is the, my lord, the application.
Yes, let that application be considered.
I will file necessary objections. Because of that, the court already heard the matter from both sides. After hearing both sides, the court came to opinion that after disposal of this subjector application, that application will be considered.
Where is that?
They have not produced the 2 days before that, they have served the copy.
No such order.
The copy.
Sorry, my lord.
Wait. I will record your statement and you will produce
I
tomorrow.
will produce the entire order sheet.
No, if you are sure, I will record that. You have stated that court has passed such an order.
Today I am not having the entire order sheet.
I am not on that. You produce. I will grant it. What you are submitting is correct.
After perusing the order sheet, I will submit it. Pray for time to file objections.
No, now what you said is correct.
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಕೋರ್ಟ್ ಆ ತರನೇ ಒಪಿನಿಯನ್ ಕೊಟ್ಟಿರೋದು. ಅದಕ್ಕೋಸ್ಕರ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡ್ತೀನಿ, ಒಂದು ಡೇಟ್ ಕೊಡಿ.
I will record that what you said is.
ಅಲ್ಲ, ಅದು ಆರ್ಡರ್ ಶೀಟ್ ನೋಡೇ ಸಬ್ಮಿಟ್ ಮಾಡಿ, ಯಾಕಂದ್ರೆ ನನ್ನಿಂದ ತಪ್ಪಾಗಬಾರ್ದಲ್ಲ.
As if you are submitting that you have seen that order sheet, he has not produced that full order.
ಇದೆ, after hearing both sides.
An advocate, you have to be there for assisting the court.
Please, my lord, after the filing of the objections by the objector, the court heard the both sides. After hearing the both sides, the court came to the opinion that after disposal of the objector application, that application will be disposed.
That is what I
will produce the order sheet.
No, you said no, that I will record it and you produce tomorrow.
ನಾಳೆ ಆಗಲ್ಲ ಸರ್, ನಾಳೆ ರಜಾ ಇದೆ.
Yes, learned
next week.
Learned counsel for You are appearing for which respondent, Mr.?
I'm not, I'm appearing for the respondent number 3.
Yes. Learned Counsel appearing for respondent number 3 has submitted that executing court pass an order that application filed by the degree holder will be considered only after considering that application filed by the objector. To that effect, he will produce that order sheet. Leave this matter on 22nd.
22nd ಸಿಗಲ್ಲ ಸರ್.
23rd. ನೀವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರಿ.
ಅವ್ರಿಗೆ ಪ್ಲೀಸ್.
ಅದಿರ್ಲಿಲ್ಲ ಅಂತ ಗೊತ್ತಾಗುತ್ತಲ್ಲ. ಎಸ್. 23rd.
Serial number 41, Basavaraj.
For the respondent in this matter, I have filed a memo that the writ petition may be allowed, my lords.
Yes. What is that relief he sought, Mr.?
Milords.
He sought for direction to the trial court to hear on preliminary issues and decide the same before proceeding further.
What is that preliminary issue?
So kindly come to page number 45. Whether the suit is additional issue, my lord. Whether the suit is barred under section 47 CPC. Recast issue number 6. Whether the defendant number 5 and 6 prove that the suit is barred under article 134 of the Limitation Act. Well, sir, the trial court, the previous honorable presiding officer was pleased to heard on these issues. Heard on these issues and posted for orders. Immediately it got transferred. And newly assumed presiding officer did not heard on this issue. And passes order that it will be considered along with the main. So we challenging that order, we filed the present writ petition. Now they filed a memo. Respondent number 1 is contesting the respondent. Writ petition may be allowed and direct the trial court to hear the.
Why the trial court has said that it has to be heard along with that main?
My lord, see, no sound order has been passed.
That,
my lord, that is at page number. I have produced the entire order sheet.
No, you just
please,
show me
please,
that.
please. Well, page number 80, kindly come to page number 84.
84.
Please.
Yes.
Case is called out. Stage is for orders on additional issue number 1 and recast issue number 6. So as to treat them as preliminary issue. It appears those issues will be considered as merits of the case, hence posted for plaintiff side further evidence.
Yes, tell. Suit for?
Well, the recovery of possession with damages.
Position. Yes.
Recovery of possession with damages.
Yes, yes.
Please.
This petition is filed by defendant number 5 and 6 under Article 227 of Constitution of India, seeking a direction to the trial court to decide the preliminary, decide that issue, additional issue number 1, recast issue number 6 as a preliminary issue. Since preliminary issue, the plaintiff has filed in a suit for recovery of money.
Possession.
Recovery of possession of the.
Recovery of possession.
Please.
After service of summons, defendant has appeared through their counsel and filed a written statement. On the basis of the pleadings of the parties, trial court has framed that issues. The additional issue number 1 has been framed in respect of maintainability of the suit. And also recast issue number 6 is also on maintainability. The matter was posted for hearing that additional issue number 1 and recast issue number 6 as a preliminary issue. Thereafter, the trial court has directed that the preliminary issue can be also considered along with that other issues. The only grievance of the petitioner that since the court has already posed this matter for consideration of preliminary issues, the matter can be decided first on preliminary issue. Learned counsel appearing for that respondent plaintiff has filed in a memo contended that plaintiff has no objection to consider additional issue number 1 and recast issue number 6 as a preliminary issue. In view of the above writ petition is disposed of. The trial court is directed to decide first that additional issue number 1 and recast issue number 6 on merit in accordance with law after giving uppers to both the parties.
Please.
That's similarly, my lords, writ petition 6889 of 25, my lords. Same, parties are same, the properties.
Properties are
Same,
both.
that is also
Post ಆಗಿದೆಯಾ?
Not posted today. Not posted
posted
today.
today. But may I request it be posted next week?
Only you both
Same-
are there.
Same parties, my
Please,
lords.
please.
Same,
Adjacent
Same,
property.
same.
Same relief also.
We'll post it today itself.
Yes, my lord.
Please.
Six-
Same, my lord.
Post it and disposed of.
Please, same,
ಅದರಲ್ಲೂ ಮೆಮೊ
ಅದ್ರಲ್ಲಿ ಮೆಮೊ ಹಾಕಿದೆ.
same ಅದ್ರಲ್ಲೂ ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ.
6889 of 2025, my lords.
I will write it, I will read it and give it.
filed in a memo dispensed so on. It will also be clubbed along with that and disposed.
Please.
Yes, much obliged.
Yes.
Grateful, much obliged.
Number.
6889.
Mohan MS for petitioner, Anirudh Suresh,
I represent for the petitioner.
Yes.
Seeking password, yes, senior.
Password.
Password.
Yes, password.
serial number 43, Chetan Desai,
Lordship, 152 application, Lordship, came to be dismissed only on the ground that petition has to be filed, not the application. But the provision 152 says that the application has to be filed. That is the only ground for the dismissal of the.
But notice service ಆಗಿಲ್ಲ.
Notice service agide, Lordship. I am filing the track record, Your Lordship, of
Where is that?
RPAD.
Service ಆಯ್ತು ನೋಡಿ. ಐದು ಜನ ಇದ್ದಾರೆ. ಡೆಲಿವರ್ಡ್ ಯಾವ ಡೇಟ್ ಇದೆ? Learned counsel for the petitioner has produced memo ಹಾಕಿದ್ದೀರಾ?
Memo ಹಾಕಿದೆ.
Along with memo postal track to show that notice has been served to that respondent. The same is taken on record. Notice to respondent as held sufficient. Yes, what is this, Mr.?
Your Lordship, only the, Your Lordship, in a position of, in a delivery warrant, in an execution petition, it came to be noticed that a third floor has been omitted in the decree. But it was there in the suit, Your Lordship.
Yes.
That we wanted to insert in the,
Is to amend the clerical mistake in the scheduled portion of the degree by restoring the word either entire third floor. Petition is accompanied by that affidavit of the plaintiff stating that verifying the plaintiff came to know there is a clerical mistake in the scheduled portions of the degree. Third floor was omitted by calling the degree. Yes, where is the degree?
Schedule, Your Lordship, the decree is at page number 77, Your Lordship. In the schedule column.
77.
77. Entire third floor has been omitted. Whereas in the plaintiff, Your Lordship, at page number 19, Your Lordship, schedule
90.
19. Entire third floor is mentioned in the plaintiff, Your Lordship. And suit came to be
scheduled ಗಿಂತ ಮೇಲೆ ಎಂಟೈರ್ ಥರ್ಡ್ ಫ್ಲೋರ್ ಅಂತ ಇರ್ಬೇಕಾ?
ಶೆಡ್ಯೂಲ್ ಕೆಳಗಡೆ, Your Lordship.
ಶೆಡ್ಯೂಲ್ ಆದ್ಮೇಲೆ ಎಂಟೈರ್ ಥರ್ಡ್ ಫ್ಲೋರ್ ಅಂತ.
ಥರ್ಡ್ ಫ್ಲೋರ್ ಡಿಗ್ರಿಯಲ್ಲಿ ಅದನ್ನ ಡಿಗ್ರಿಯಲ್ಲಿ ಅದನ್ನ ಒಮಿಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಏನು ಹೌ ಇಟ್ ವಿಲ್ ಮೇಕ್ ಡಿಫರೆನ್ಸ್?
Lordship, when we filed execution case and delivery warrant was issued, and the Amin says that without mentioning of a third floor, I can't execute the decree. That is the only thing.
Now, why your application is rejected?
Only on the ground that we have to file a petition, not the application.
Degree is drawn in that now.
The impugned order is at page number 11.
Is it petition? 150.
It's application, Lordship. 152 says that it's application. Even so moto can court can so moto.
Amendment of the judgment and degree order, clerical or arithmetical mistake in the judgment degree. Error therein from the extent resolution. Yes, Tali. In this writ petition, petitioner called in question order dated 30th/1/2025 passed by 16th, 17th additional City Civil and Session Judge Bangalore in OS number 4962 of 2006, whereby IA filed by the petitioner plaintiff under section 151 of CPC is dismissed. Petitioner plaintiff has filed in a suit for
Declaration and possession, Your Lordship.
declaration
Came to
and
be
possession.
decreed.
Declaration and possession. The suit is decreed
And
by
our-
judgment and degree dated. Filed in a declaration possession. Suit is decreed on 13th March 2015.
15 years. Your Lordship.
2015.
And defendant filed RFA, it came to be dismissed.
Yes. While drawing the degree, learned counsel for the petitioner submits that while drawing the degree, the scheduled has been wrongly mentioned. The word third floor has been omitted. Since the same is typographical error, he has filed an application under section 152 of CPC. The trial court has dismissed that application only on the ground that application filed under section 152 is not maintainable. They have to file in a separate petition. It is very clear from section 152 of CPC. If there is any clerical or arithmetical mistake in the judgment, degree or order or error arising therein from any accidental slip or omission may at any time be corrected by the court either of its own motion or on application of any of the parties. Therefore, filing in a separate petition is not necessary. In view of the above, the order passed by trial court liable to be set aside. Accordingly, writ petition is allowed. Order dated so and so is set aside. The trial court is directed to reconsider that application filed by that petitioner plaintiff under section 151 of CPC in accordance with the, after giving an opportunity to all the parties.
Cell number 44, Raghuram Kadambi.
Here for the petition. But there are two office objections. There are two
Yes.
office objections. First is that the plaintiff number,
Plaintiff number 4 not made a party.
there are 4 plaintiffs in the suit. This is a petition filed by the plaintiffs.
Yes.
Out of these 4 plaintiffs, one of them, my lord, was at the time of filing of the petition was not available. He's a senior citizen. He was not in Bangalore.
Yes, he
Hence,
don't
the
want-
others have, my lord, filed the petition on behalf of all of them. The second office objection is that,
Legible copy. Yes, that is
please,
not
on
necessary.
page
Yes.
80, my lord, of the petition, that was the certified copy that we
Yes.
obtained.
What is that now you are challenging?
Lord, this is a petition for speedy disposal, Lord, of, there's a suit for declaration and injunction. Lord, the party, Lord, the plaintiffs are retired or serving, Lord, officers of the armed forces or their families, Lord. The dispute pertains. Suit for, my lord, declaration and injunction. Suit prayer, your lordship will get at page 88. The issue, my lord, in the list pertains to
What is the stage in the suit?
hearing on, my lord, IA. Plaintiff evidence has not even begun. The issue and the anxiety is that the plaintiffs are, it has been 5 years, my lord, since the suit was filed. The plaintiffs are senior citizens between 65 and, my lord, 90 years of age.
Where is that plaint?
Plaint, my lord, your lordships will get it at page 67 of the petition, annexure B. Please, 67, the plaint begins.
Yes.
Prayer, your lordships will get at page 88. First prayer is for declaration that the apartment penthouses in the Sandeep Vihar complex are capable of dual occupancy and can be used as two separate dwelling units. B and C, my lord, are consequently injunction, restraining the defendant from interfering with the right of occupation of the plaintiffs.
Dual occupancy, and as such they can be used as two separate dwelling units. Against whom you are filing?
Lord, the sole defendant in the suit is an association. We of course dispute that this was a legitimate association. It's a registered association under the Apartment Owners Act of 1972. There was, my lord, they have begun interfering with the use of the apartments that are the subject matter of the suit. Not basically
now
what
that why that matter has been
Lord, it's pending
from so many times.
Lord, I'll just explain. There are a number of applications that have been filed by the plaintiffs. In total, around 30. Please, I appear for the plaintiffs are the petitioners before your lordships.
Yes.
There are the suit is a representative suit under Order 1, Rule 8 of the CPC. During the pendency of the suit, what has happened is some of the tenants have moved out and gone away. Some of the, my lord, owners have also passed away and have sold. The properties have changed hands.
Now,
As
what
a-
is the stage? Now that
Hearing
defendant is not dragging that matter.
Please, no, the defendant is not, my lord, dragging the matter.
Now what is the stage?
Hearing on applications.
Application?
There are a number of impleading applications that are pending, filed, my lord.
How can I direct that if I fix the date, then applications court cannot be decided on merit?
But the applications, though there are many in number, are really only formal applications that are all the same, my lord. The applications seeking to bring on record, implead certain persons who have, my lord, gained an interest in the property that's the subject matter of the suit. That is all those applications are.
If it is allowed, they may challenge and all. Then the purpose of
The only anxiety is, I have some interim protection today. I don't deny that.
Yes.
The only anxiety is that the plaintiffs, my lord, may pass away their
you see that if, unless there is such a circumstances, Supreme Court said don't fix that. We take notice. Let us see on the other side. By hand summons.
Please.
Yes. Issue notice. In addition, petitioner is also permitted to take out hand summons to respondents. Yes, submission is accepted. Office objection is overruled.
Serial number 45, Gangadhar A.N. for petitioner, Nagareddy V.
Yes.
Prefer the petitioner, please.
Yes.
Respondent number 1 to 3 minutes. Sorry.
Yes.
Serial number 45, Gangadhar A.N.
This matter,
Nagareddy V.
He is the only
he
contestant.
is the advocate for the respondent.
He
So
himself is
he
the party.
unfortunately forgot to wear the robe. That's why. Next week,
Next week, yes. Leave this matter next week.
interim order may be extended.
Interim order granted earlier is extended till next date. Yes.
Number 46, Arvind N. for petitioner, Venkatesh
Hearing
C.R.
for petitioner, my lords. Lords, we have sought for mandamus to dispose of the matter as early as possible, my lords. The suit is of year 2009, my lords. My lords, plaint is at page number 12, my lords.
Now, what is the suit for?
Suit for partition, my lords.
Suit for partition.
Yes, my lords.
What is the stage in the suit, Mr.?
My lords, the stage was plaintiff evidence partly has been done, my lords. After that, the impleading applications has been filed. Based on that, the notice has been issued, my lords. There is a white notice on this. 2009 in the
Pleading application, whom you want to implead?
My lords, I have not impleaded, my lords. The plaintiffs has impleaded.
You are the defendant.
I am the defendant, my lords. Defend number
He
13.
wants to implead whom? You are
My
the.
lords, I am
Please,
not,
please.
they are impleaded.
During the pendency of the suit, my lord, if some property was alienated by some defendant, my lord. In the meantime, we file a application, that application should be considered. My lord, the
ಏನಾಗಿದೆ application? ಎಷ್ಟು?
1 Rule 10, my lord, only one application
Rule
is
10,
pending.
one application.
Already the defendant have lead evidence, but class exam is not completed. My lord, another 2 matters are clubbed along with this suit, but they have not seek their suit in the writ petition. They have not seek the relief also, my lord. The present writ petition in challenging the for direction
respect to the OS number 1230 of 2009. Another two suits are 573 of 2009, 574 of 2009.
Filed by whom?
Filed by the another one of the defendant.
Defendants.
Another, kindly take up the page number.
ಅದು
Page number
same subject.
suit for declaration
Let's-
filed by the someone, another one, Ubedullah Khan. He's also
ಅದ್ರಲ್ಲೆಲ್ಲ
respond.
ಏನಾಗಿದೆ?
So both suits, both three suits are
Same
clubbed.
stage, my lords.
ಅಲ್ಲ ಕ್ಲಬ್ ಮಾಡಿ ಮಾಡ್ತಾ
Club ಮಾಡಿ same ಮಾಡ್ತಾರೆ.
ಕಂಟ್ರೋಲ್ ಡೈರೆಕ್ಷನ್ಸ್ ಆದ್ರೆ ಮೂರು ಕಂಪ್ಲೈ
ಹೌದು. What happened is, my lords, before 2001 and 2 itself, the partition has been taken place, my lords, registered partition did. After that, my lords, the one of the son has filed this suit, my lords, in the year 2009.
It's wrong submission, my lord. If there is any, why they are not produced before this court read?
ಆಯ್ತು ಅದ್ರ ನೀವು ಅಲ್ಲಿ
Please,
ಡಿಸ್ಪ್ಯೂಟ್
please,
ಮಾಡ್ಕೊಳ್ಳಿ. ನಾವು
please.
ಐ ವಿಲ್ ಡೈರೆಕ್ಟ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಸೂಟ್. Yes.
Please.
Within 1 year, let us.
Yes, my lords. Much obliged.
This petition is filed by defendant number 13, seeking direction to dispose of the suit OS number 3261 of 2022 as expeditiously as possible. The plaintiff has filed in a suit for partition. After service of summons, defendant has filed in a written statement. On the basis of the pleadings of the parties, trial court has framed that issue. Now that matter is set down for evidence. Since suit is of year 2009, the counsel for defendant 13 petitioner has seek for early disposal of the suit. Alternate counsel appearing for the plaintiff, respondent number 1, has no objection to direct the trial court to dispose of the suit as expeditiously as possible. In view of the above, without expressing any opinion on the merit of the case, trial court is directed to dispose of the suit as expeditiously as possible, not later than 1 year from date of receipt of copy.
Along with another three suits.
ಬಟ್ಟೆ ಮಾಡ್ಬೇಕಲ್ಲ ಇದು ಅದು ಕ್ಲಬ್ ಆದಾಗ.
Please.
Much obliged.
All pending applications.
Serial number 47, Ayantika Mandal for petitioner.
Not appear for petitioner, my lord.
OS number so and so. ಅದರದ್ದು ನಂಬರ್ ಕೊಡಿ. Other two suit number will say since it is clubbed, all ಮೂರದ್ದು suit number ಹಾಕ್ಬೇಕು. Yes. Yes, Mr. ನೀವು ಆಚೆ ಹೋಗಿ ಕೊಡಿ ಆ ಕಡೆ ಅಲ್ಲಿ ಅವ್ರು ಹಾಕಂತಾರೆ ಇವ್ರು ಆರ್ಗಿ ಮಾಡಿ. Yes.
Yes, my lord. Appear for the petitioner in this case, my lord.
Number is
There is office objection on maintainability, my lord.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ?
ಹಾ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟಿದೆ?
ಸರ್ 47.
47 non compliance of subjection. Council submissions may not be able to maintainable asked by the learned so on such and such. Yes, what is that maintainability, Mr. Why?
Yes, my lord. My lord, office has raised objection saying my WP is not maintainable in light of section 115 of CPC, my lord. Revision petition.
Under section 8 of Arbitration and Conciliation Act.
Yes, my lord.
Now, what is that order here you are challenging? Order passed under section 8.
Yes, my lord. My lord, the petitioner had filed a summary suit, my lord, under order 37 for a recovery of money, my lord.
Your application under order 8 is dismissed.
Yes, my lord.
Then
No,
you have
not
to
my
file an
application, my lord. The defendant, who is the respondent here, had filed an application under section 8 of Arbitration Act, saying there is an arbitration clause. Petitioner is the employee and the respondent is the employer, my lord. There is a
No,
salary.
now that your application is dismissed.
My suit is dismissed, my
Your
lord.
suit is dismissed.
Yes, my
IA
lord.
is allowed.
Yes, my
Then
lord.
you have to file in a CRP. Not
No.
that writ.
No, my lord, but my lord, there is a judgment of the Honorable Apex Court, if I may produce. My lord, at para number 3. If I may be permitted to read, my lord.
Yes.
By the impugned judgment and order, the High Court has dismissed the writ petition under Article 227 of the Constitution of India, observing that the writ petition under Article 227 of the Constitution of India is not maintainable, as remedy by way of revision under Section 115 CPC is available to the appellants/plaintiffs. As observed by this High Court in canton of decisions, and even in the decisions considered by the High Court, the view taken by this petition under Article 227 of the Constitution of India would not lie. That does not mean that writ petition under Article 227 of Constitution of India shall not be maintainable at all. There is a difference and distinction between the entertainability and maintainability.
That is what that.
Yes.
See this court, but when we have an alternative remedy, we are not exercising the discretionary power. Court said, see, petition is maintainable.
Yes, my lord.
If there is an alternative remedy, it is for the court to exercise the discretion or not.
My lord, but in the
That is why that maintainability is Allah.
however, to say that writ petition under 227 of India shall not be maintainable is not tenable.
Not maintainable is not tenable. But if there is an alternative remedy, it is for the discretion of the court to entertain or not. When there is a specific remedy under 115, then full bench of this court also has taken a view. Therefore, you have to file a revision. If it is a commercial suit, then revision is not maintainable. But here is this thing, original order.
Yes, ma'am.
If you show me any judgment that order passed under Section 8 of the Arbitration and Conciliation Act, revision is not maintainable.
I will research on that.
Research. Under very same order, if it is
Yes, ma'am.
not maintainable, then we can enter. Otherwise, under 115 of CPC, what said? If that application is allowed, the effect is that suit is terminated, then revision has to be filed under 150.
Yes, ma'am.
Yes, at the request. Read this matter next week.
Serial number 48, Ramu KS.
My lord, the date may be given.
You want date? Yes, 26th.
Great.
Serial number 48.
Yes, annexure K and N to be made as a series.
I have connected, I have corrected to this thing, but this one is not, it's only for a reference I have filed the.
Yes, what is this?
My lords, this is with regard to the enhancement of compensation, my lords. The National Highways Authorities have acquired my land.
What is
for,
that?
no, I had filed an enhancement, my lords, that was allowed. Now the National Highway Authorities have challenged the said award, enhanced award, my lords. Now what has happened is during the course of the proceedings, they have stated that there is no jurisdiction in so far as the enhancement award, since the Deputy Commissioner 3 has no powers to pass such awards, and it has to, and on that ground it has to be set aside, my lord. So which is stating that it is a Section 34 of the Arbitration Act clearly said that it is opposed to public policy. Now the only this thing I had sought for is only for production of the official documents, that is the Gazette notification and circulars that has been issued by the state and the central government.
Opponent has filed an application to permit it to produce that additional document. You sought for production of additional document.
Yes, my lord. Then the court section 25, my lord, page number.
What is that order passed by the?
Yeah, my lord. Section 25, my lord.
Yes.
Here, therefore, the proposed documents are necessary. The said reason does not fall within the exceptional
from para 11. Para 11.
Para 11. Sorry, my lord. The first respondent has filed the above said application after substantial arguments are addressed before the parties. The reason for production of the proposed document stated in the affidavit that the petitioner in the course of argument has raised administrative and jurisdictional issue. Therefore, the proposed documents are necessary. The said reason does not fall within the exceptional circumstances. The proposed documents were not formed part of arbitral proceedings. They are referred to some, the Honorable Supreme Court in so and so held that the proceeding under section 34 should not be conducted in the manner as civil suits that frame the issues. Therefore, considering the scope and object of 34(2) of Arbitration and Conciliation Act, the first respondent has not made
No,
out
that show me that under Arbitration and Conciliation Act, you can file an application for additional documents.
No, my lord, this is not, this is actually what has happened is, after the award was passed, during the, when the National Highway authorities participated in the proceedings and they did not raise this issue, my lord, with regard to jurisdiction. Subsequently, what happened was there was a transfer of DC.
Yes.
And there, what has happened is now, actually DC was appointed on.
No, Mr. Counsel, only legal points.
Yes, my lord.
In the arbitration petition
Yes, my lord.
filed under section 34,
Yes, my lord.
under which provision we are invoking to production of the documents?
That is 151 CPC, my lord.
Where is that? Show me any judgment, because this section 34 Arbitration and Conciliation Act as specific provisions has been made, all provisions of the CPC is not applicable.
I understand, my lord.
You show
That
me
is-
any judgment that proceedings under 34(2), you can file an application.
Yes,
for-
one, this is enhanced award, my lord. There is one gazette notification, my lord. That is page 183, my lord. Page 183 it starts and 184 kind. In pursuance of the subsection 5 of 3G of the National Highways Act 1956, the central government hereby appoints the officer mentioned in column 2 of the table below to be arbitrator for the purpose of the said subsection, who shall exercise the powers conferred and perform the duties imposed.
No, that is for under 3G of National Highway Act.
Yes, yes, my lord. They,
See, after that award passed under National Highway Act, then award can be challenged under section 34 of
yes, my
arbitration.
lord. That is true. my lord.
Whether it is permissible for filing an application for production of the documents, give any judgment. You find out any judgment on that point.
Yes, my lord.
Yes, 21.
Um,
21,
22nd, my lord.
22nd.
22nd and 23rd, my lord.
Yes, 23rd.
23rd.
You get any judgment on that proceedings under 34, you can file an application. Yes.
Serial number 49, yes, Doreraju for petitioner, Shiva Ramakrishnan.
Apply for the respondent for 3 months.
Appearing for this.
File an application for recall of this, or to reopen and recall the order of the writ petitioner. The writ petitioner dismissed in this particular case on the ground that the FSL report has already been
Is
received
that rectification of the office objection revision IA2?
at the convention of deal application ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ ನನ್ನ ಹಾಕಿದ್ದೀನಿ 9 ದಿವಸ 28/2/2025 ಆರ್ಡರ್ ವಾಸ್ ನೆನ್ನೆ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ ಕೌಂಟರ್ ಅಲ್ಲಿ
Application is not come.
ಅದು ಬರೀ 9 ದಿವಸ ಡಿಲೇ ಇದೆ ಸ್ವಾಮಿ ಐ ಕ್ಯಾನ್ ಕನ್ವಿನ್ಸ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಬರೀ 9 days ಡಿಲೇ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ
9 days delay application ಬೇಕಲ್ಲ.
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ ನೆನ್ನೆ ಹಾಕಿದ್ದೀನಿ ಕೌಂಟರ್ ಅಲ್ಲಿ ಸೀಲ್ ಇದೆ
Directed to put up that.
But then, your lordship, because this writ petition was dismissed on 28/2/2025 on the ground that FSL report has already been received by the trial court based on only on that ground. We have challenged the order of the trial court, IA number 16 and 17. Idರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ? The defendant petitioner,
You are the petitioner.
plaintiff in the lower court.
You are there. You are there. This is an order passed on merit.
No, your lordship. ಬರೀ FSL report, ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು, the trial court had made an order.
Pursuant to that order passed by the trial court, now that report is
Ah,
already in the.
so
It cause any prejudice to the petitioner on that circumstance.
on merits it was not decided, your lordship.
The merit of the case, writ petition is dismissed. The trial court is directed to proceed with this matter. Yes, what is
Yes,
that?
IA number 16 and 17, your lordship. We have challenged IA
What
number.
is your application?
Your lordship,
Application put up must. Yes.
application ಇದೆ ಸ್ವಾಮಿ, condition of delay application ಮಾತ್ರ ಇಲ್ಲ.
Yes. You have any objection for condoning the delay?
ನಾವು 9 ದಿವಸ ಇದೆ
My lord, sir, it is the discretion of this court, but I have objections to the IA for reopening the matter.
Have you filed an objection?
I may be permitted to file my objections, my lord.
On the, and also application, if you want to file, and you file it at a
Please.
time.
Your lordship, a small submission, because the lower court 24ನೇ ಇದೆ ಕೇಸ್ 24/4 sorry 24/4 ಇದೆ, and I'm not seeking for interim stay because there's already interim stay before. But then FSL report ಬಂದಿದೆ ಅಂತ ಅದು interim stay vacate ಆಗಿ dismiss ಆಯ್ತು. Then we came to the knowledge in the application FSL report ಬಂದಿಲ್ಲ ಅಂತ. That's the reason again
Who has said that FSL report has come?
it was in the order sheet itself.
Because it was our it was my submission, my lords. Because what
FSL.
is, it was my submission because the trial court has recorded that the FSL report had come. In fact,
FSL report is not come.
my lords, what had happened is, in the report, what the FSL has done is, has intimated me to file, to pay fees. Fees katti anta id madidare. I have already paid the fees today, and in fact, the matter is in before the FSL for forensic evidence. Matter is posted for 25th. Matter is posted on 25th this month for the awaiting the FSL report. The petition may not be restored, my lords. What happens on 25th will be considered, and matter will be
FSL
proceeded.
report has, will be reached on 25th.
No, sir.
My lords,
No, your lordship.
we can take a chance, my lords.
I'll take a, I'll
We
just
can
explain,
take
your
a
lordship.
chance. Maybe your lordships may have it immediately after 25th. If the matter doesn't come on the report doesn't come on 25th, your lordship may
Yes,
consider.
26th, leave this matter on.
Your lordship, a small submission, your lordship. Why? Because on the last date of hearing, they told that the FSL report onto the disputed signature have already come to the trial court. But then when the trial court opened the seal cover, it was only no FSL report had come.
Now, he is also not disputing. Now that because he has not paid that amount, it has not come.
Yes.
If it is come within the 25th,
25th.
it's okay. Otherwise, we'll see that whether what that order has been
Please.
passed here.
Please.
26th.
My lords, 20.
Your lordship, as final chance, because again, if 25th it does not come, again they'll come and tell the same thing again. ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ ಅದಕ್ಕೆ next date ತನಕ ತಿರ್ಗಾ wait ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ ನಾವು ಮಾಡ್ತೀವಿ ಅಂತನಾ?
ಇಲ್ಲ
You are expecting that?
ಇಲ್ಲ ಸ್ವಾಮಿ, because now also the same, because
Expecting what I am going to pass an order?
no, your lordship.
Don't go.
ಆಯ್ತು ಸ್ವಾಮಿ.
He has said it is reasonable. Therefore, I said we will see on 26th. You are expecting that I can pass so and so order. Yes.
Much.
Cell number
26th, let us.
Please,
Yes.
please.
Cell number 50, Arun BK for petitioner, connected matter. Service awaited.
Awaiting service of notice.
Lord, the respondent, my lord, has been served through his counsel appearing before the trial court.
No,
I have
who is
filed-
contesting? R1 or R2?
R2, the R1, my lord, has filed the.
No, R1 is served.
R2, my lord, has filed the objection. R1, my lord, is not contesting.
R2 is.
Please,
But R2 is, notice is not served.
Please.
You take hand summons.
My lord, he has been served to his advocate appearing before the
But
trial.
that is not a service under the rule.
My lord, in fact, my lord, they are following up on the matter. They are
No,
deliberately
therefore,
evading
they are
service
taking
of
this
summons.
advantage.
Please, if my lord,
Take hand summons and serve it and move that matter.
that was also attempted, my lord. If my lord, my humble submission is, I'll convince this honorable court on merits. If an interim order of stay is granted, they'll appear before this honorable court. Otherwise, my
You
lord,
have served the council.
of course, my lord, we have served it and a necessary memo has been filed before this honorable court.
Yes, what is this matter?
My lord, the matter, my lord, is arising out of an application under Order 9, Rule 7, wherein it was dismissed on the grounds, my lords, which are not tenable under the law. The petitioner, my lord, my lord, the suit, my lord, is for declaration.
Where is the plaintiff?
Please. Please, the suit, my lord, is one for
Declaring that sale deed dated so and so.
executed by the defendant number 1 in favor of the defendant number 2 in respect of the scheduled property is not binding upon the plaintiff. My lord, in this matter, the paper publication was issued. Admittedly, my lord, the summons was not personally issued to the petitioner. The petitioner, both the legs, my lords, of the petitioner are amputated below the knee.
Now, what is that order you are challenging?
The order, my lord, is at page number 13, my lord, dated 10th of June 2024. I may be permitted to take my lord.
What is that application you have filed under Order 9 Rule 7?
9 Rule 7, my lord, is that it was deemed
Deciding
that.
that ex parte order.
Please, to set aside the ex parte order.
Where is that ex parte order passed?
At page number 13, my lord.
1-3.
Please.
No, ex parte order of the trial court. Now, this
Please.
is an order which is sought for set
Please,
aside that.
Order sheet, my lord, is, I have, it is not annexed along with the writ petition, my lord, but I have it with me. I can produce it now.
Give that to.
Please. Order sheet. 2016 suit though.
Why that ex parte? You have not served the notice.
My lord, the impugned order itself captures what has happened, my lord.
Yes.
Yeah, I'll point out the relevant portion for the, before this honorable court.
Yes.
At
Paper
page
publication.
15, my lord.
Page 15, paper publication has been taken.
Please.
Yes. Read.
And on, please.
Para 8.
Please. Further, it is submitted that plaintiff and the defendant number one, being the brother and sister, have hatched a conspiracy to knock off the hard-earned money of the defendant number two. It is submitted that the defendant number one has approached the defendant number two, stating that he is the sole and absolute owner of the entire scheduled property, being the only son of late B.M. Chaudhaya, by producing so it is submitted that the sale notice was issued.
Sale notice was issued.
I'm sorry. I may be permitted, my lord, page 17, my lord, para 15. On perusal of the records, it is clear that the summons to the defendant number one was issued by way of paper publication in Kannada Prabha Daily newspaper on 25/1/2017. Therefore, my lord, personally notice, my lord, has not been served. It was a notice issued by way of paper publication, substituted.
Therefore, I
service.
want to see in order.
Please.
Under order 5, rule 19 and 20, there is a procedure which has to be followed before going for a paper publication.
Please.
Whether that has been followed.
A fixture. Please.
Then order 5, rule 19. Now you have to see that in that order sheet, whether that procedure has been followed.
Please.
Because there is no any explanation or finding regarding that aspect.
Please.
No, after that it is there in that the defendant number one has not challenged the service of summons and submitted due to that constant traveling of his business. He was not residing in the said address. Therefore, someone was written with unclaimed. You are in defendant number one.
Please, my lord.
Is it, Mr.?
Please, my lord. Please.
Then it is written with unclaimed.
That is, my lord, in the other suit. There are two suits. 3455 is, my lord, wherein the summons are returned as unclaimed. In the suit, my lord, which is filed by the respondent number one.
In the cost title in the claim and the application made by the defendant number one. Now you read further in that.
Please.
You read in para 15.
15, please.
It is.
Yes,
it is observed that.
Please.
Para 15.
Please. It is on perusal of the records. Accordingly, this court held the service of summons as sufficient and placed the defendant number one ex parte on 7/4/2017. It is observed that the address of the defendant number one mentioned in the cost title of the plaint and the application made by the defendant number one are one and the same. The defendant number one has not challenged the service of summons and submitted that due to constant traveling on his business, he was not residing in the said address, and therefore the summons was returned unclaimed as unclaimed. My lord, this, my lord, is an error which has crept in, but the records, the trial court, my lord, itself has recorded that the service of summons, it was not unclaimed, it was issued by way of paper publication.
Now, where is that? You have to point out in that order sheet.
Order sheet. Please, my lord.
Suffering from chronic diabetic and his legs are amputated and do the case registered as has not given any explanation or reason for not appearing before the court. Therefore, in the facts stated application, defendant number one has not given valid reason for his non-appearance at the court in 7. Reason for non-appearance at the court. Though the summons was served by way of paper publication. Therefore, this court is approving.
My lord, there is no affixture, my lord, which has taken place. I may be permitted to pass on the order sheet before this honorable court.
There is a reason below the defendant is keeping out of view the purpose of providing for the other reasons summons cannot be served on ex parte already. Order summons to be served by affixing the copy thereof.
Right.
Order for the defendant is known as so for the paper. Acting under subgroup 1 and that the service by an advertisement. Where the court acting under subgroup 1 order service by an advertisement to the. No, there is no this mandatory provision that affixer is mandatory. There are two options, either affixing or that paper publication.
Please. A fixture, my lord, has not been affected.
Court has, it is for the court, if the court satisfied,
Please.
either service by affecting copy or paper publication.
Please. My lord,
So that by paper publication they have done it. In other case you have appeared. 9 years you have not done it.
my lord, he was not residing in India. He was traveling abroad on account of business. Now, my lord, the primary reliefs prayed for in the suit is against the petitioner. The other party, my lord, is only a formal party. Now, my lord, that the limbs of the petitioner have been amputated. He has no source of income. In case he is deprived, my lord, of his right of placing his defense on record.
What is the stage in the trial court now?
Cross of PW1, my lord. But the common trial is being held in both the matters, and it is still in the preliminary stage. If I may.
In other case you have filed an objection, written statement.
No, in both the cases, both the petitioner was not available, was aware of both the cases, my lord. He filed two applications in both the matters.
Where is
Both
the other matter?
applications, in the connected matter, connected case in
Where is that connected? Oh,
Please.
both are here. Yes.
36043
Yes.
of
Heard.
2020.
Learned counsel for the petitioner. Stay of further proceedings in OS number 3721 of 2016 passed by 30th Additional City Civil and Session Judge Bangalore till next date of hearing. Yes,
Highly
see, now they will come.
I appear for respondent number 2 in this matter. Kindly have it on next week, my lords. We will file the.
He has rightly said. He has rightly said they are watching.
No, my
Therefore,
lords.
I also wants to test it. I do it.
No, my lords. We
No,
are
it's
held up
right.
in court all 19, my lords.
Yes, anyhow that you are appearing. Now that don't, what is the next date in the suit?
21st, if I'm not mistaken.
I need to seek instructions, my lords.
Monday,
The next date,
21st, my lord.
21st.
Please.
Then don't precipitate. Otherwise, if you are agreed, I will impose cost and ask him to appear and file an objection by next date
My lords,
itself.
next week we will argue the matter, my lord.
You argue, but
We didn't receive the copy, madam.
My lord,
They
I
will
have,
be directed to serve the copy.
acknowledgement is placed before this honorable court.
why I have this thing? If they are served by counsel, in spite of that, they have not appeared means they are taking chance. Let us see. If court is not granted any, that
No,
is
my
the
lord.
main ground for.
Any date in
He
next week,
convinced
my
me to grant an estate today. Yes.
Any date in next week, my lords. Kindly, ma'am.
What is the next date, Mr.?
21st, my lord. 21st, next Monday, my lord.
Monday is the case, Mr.
ಇವತ್ತು-
Monday I will not
ಇವತ್ತಿಂದ
precipitate, I
21st.
will have it Saturday. You will undertake not to precipitate.
My lords, I need to seek instructions, my lords.
Then I will grant interim order without your absence, with your absence, you appear later.
My lords, kindly have it on next week, my lords.
No.
Without interim order.
No, I will grant time, but don't take any precipitative action on 21st before the trial court. Then I will, even if the trial court is urgent after vacation, I will grant time till after vacation also.
Date also may be fixed, my lord. And if an interim order, my lord, is granted.
may be
and the
taken
date
on
is fixed,
21st
On the
itself,
next
my
date, my lord, I'll be prepared and I'll argue the matter, and it can be disposed of as per the.
Yes. We'll have it on 26th, till then not to precipitate this matter.
My lords, kindly have it on 21st itself, my lords, without interim order.
Yes, 21st.
Please.
Yes, leave this matter.
Let them undertake not to precipitate, my lord. Let them undertake.
21st, your case is on 21st.
Finally ಅಂತ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇವತ್ತು ಫೈನಲಿ ಅಂತಿತ್ತು, ಮತ್ತೆ it got adjourned to 21st. If something goes on, then the valuable judicial time, my lord, will be.
Now, what is that, 21st is for what?
Cross examination of PW1.
Cross examination.
Please.
Then it's not in a final order. Let us see. That is the case, then we'll further proceedings may be stayed. Yes.
Please.
Grateful.
Serial number
Highly
51 Adjourn, serial number 52, Andish Gowda GB.
Lord, the sole
52, yes.
sole respondent already referred the writ petition before this honorable court. In writ petition 26554 of 24, in which, my lord, the impugned order has already stayed. My lord, kindly connected this writ petition along with 26554 of 24, and I may be permitted to take notice on the council, my lord, one Maruti Reddy.
Yes.
And kindly fix some date, my lord. This is covered by my lord judgment only. This is regard, my lord, the payment of the stamp duty.
Yes.
At the first instance, my lord, the trial court determined the stamp duty based on, my lord, suit for specific performance based on the GPA agreement of sale and affidavit.
Yes.
Trial court at the first instance determined duty penalty, my lord, 41 lakhs. As against that, my lord, the writ petition has been filed.
Yes.
In the writ petition, my lord, the trial court, my lord, the set aside and the direction has been issued to the trial court to calculate based on, my lord, the section 21 and 41E. Now, my lord, since the subject matter of the land is an agriculture land, the value, my lord, less than 10 crores.
Yes.
The trial court determined, my lord, based on the SR value. And, my lord, the directed to pay the stamp duty, my lord, 11 lakhs and odd. Being agreed, my lord, it is for the deputy commissioner, my lord, ought to have determined.
Yes,
as by, my lord, judgment, my lord.
Yes, now that who has to take notice?
My lord, one Maruti Reddy GA.
Yes, Maruti Reddy GA is directed to take notice for respondent number 1. Is this matter along with the so and so?
26554 of 24.
26th.
Please, my lord.
Serial number 53, Lokesha K for petitioner, P. Mahesha.
I appearing for
Yes.
respondent 1 and 2, my lordship.
Yes.
Now, my lordship, in this matter, my application has to be considered because, my lordship, for withdrawal of the amount.
ಇವತ್ತು 99,000 ಕಟ್ಟಿದೀವಿ ಸ್ವಾಮಿ. ಇವತ್ತು 99,000 ಕಟ್ಟಿದೀವಿ. ಇವತ್ತು 130 ಕಟ್ಟಬೇಕಿತ್ತು. UPI ಲಿಮಿಟ್ ಕ್ರಾಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ನಾಳೆ ಅಷ್ಟೊತ್ತಿಗೆ ಇನ್ನು 31,000 ಕಟ್ತೀವಿ. ಆಸ್ ಪರ್ ಅವರ್ ಅಫಿಡವಿಟ್. 28th ಅಷ್ಟೊತ್ತಿಗೆ ಕ್ಲಿಯರ್ ಮಾಡಬೇಕು ಅಂತ.
ಏನಂತ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ರೆ?
ಅಫಿಡವಿಟ್ ನಾವು ಆಲ್ರೆಡಿ 1 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ವಿ. ಇವತ್ತಿಗೆ 1,30,000 ಕೊಡಬೇಕಿತ್ತು. 28 ಅಷ್ಟೊತ್ತಿಗೆ ಇನ್ನೊಂದು 2,30,000 ಕೊಡಬೇಕಿತ್ತು. ಇವತ್ತಿಗೆ 31,000 ಕಮ್ಮಿ ಕಂಪ್ಲೈ ಮಾಡಿದೀವಿ.
Yes.
ನಾಳೆ ಮಾಡ್ತೀವಿ ಅದು ಇನ್ನು ಮಿಕ್ಕಿದ್ದು. ಇಲ್ಲ ₹1 ಆಗಿದೆ.
Some progress is there. Yes, we'll have it on Monday.
Malad.
We also will be permitted to take back 92 lakhs, but let the matter be pending. Monday.
ಆಗ್ಲಿ. ಪೂರ್ತಿ ಕೊಟ್ಬಿಡ್ಲಿ, ಆಮೇಲೆ ಮಧ್ಯದಲ್ಲಿ ನಿಂತ್ಕೊಂಡು ನೀವು ಅರ್ಧ ತಗೊಂಡಿದ್ದೀರಾ ಅಂತ ಅಂದ್ರೆ let him pay that entire this.
ಅಲ್ಲ, ಅರ್ಧ ಆಲ್ಮೋಸ್ಟ್ ಆಗೋಗಿದೆ ಸ್ವಾಮಿ. ಅವ್ರದ್ದಾಗ್ಲಿ ಮತ್ತೆ ಇವರು ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ಸ್ ಇಫ್ ದೇ ಫೈಲ್ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ಸ್ ಅದನ್ನು ಕ್ಲಿಯರ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ.
ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಪ್ರಕಾರ ಯಾವತ್ತು ನೀವು ಫುಲ್ ಅಮೌಂಟ್ ಕಟ್ಟಿ?
28ಕ್ಕೆ.
28ಕ್ಕೆ.
ಹೌದು.
ಆಯ್ತು, ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ 28th itself. ಮತ್ತೆ ಕ್ಲಿಯರ್ ಆದ್ರೆ ಎಲ್ಲ ಮುಗಿಸ್ಬಿಡು.
Malaship, my application is.
ಆಯ್ತು, ಇಷ್ಟು ದಿನ ಇದ್ದೀರಾ?
ನಮ್ಮ ಪಾರ್ಟಿದು this is 4th round, Malaship. ನಮ್ಮ ಪಾರ್ಟಿಗೆ
ನಾವು
2 ವರ್ಷದಿಂದ
parties are getting relief.
ಇಲ್ಲ, ಅದಕ್ಕೇನೆ ನಂದೇನು
the case where all parties are getting relief.
ಇಲ್ಲ, ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ಗೆ ಅವ್ರದ್ದೇನು ತೊಂದರೆ ಇರಲ್ಲ ಬಿಕಾಸ್ ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ಸ್ ಅಮೌಂಟ್ is in deposit for the past 6 months, Malaship. Without any interest.
Where is your application?
Malaship, my application is there.
I will dismiss that application. Then you have no voice.
ಸೈನ್ ಹಾಕಿಲ್ಲ ಅಂತ ಅದನ್ನ ಇಲ್ಲೇ ಮಾಡಿ.
ಅಲ್ಲ, ಅಷ್ಟೊತ್ತಿಗೆ ಅವ್ರ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಆದ್ರೆ ಕೊಡ್ಲಿ ಸ್ವಾಮಿ.
ನಂದು ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಲ್ಲಿ ಕೊಟ್ಕೊಳ್ತಾರೆ.
ಇಲ್ಲೇ ಕ್ಲೋಸ್ ಆಗ್ಬಿಡುತ್ತೆ, ಎಲ್ಲ ಮುಗ್ದೋಗುತ್ತೆ. ನಾನು 25 lakhs I have deposited before the trial court.
ನೀವ್ ಎಷ್ಟು ಬರ್ಬೇಕಂತೀರದು?
Malaship, it is around 29 lakhs.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರದೇ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಪ್ರಕಾರ 26 lakh I have paid 1 lakh. ಅದಕ್ಕೋಸ್ಕರ ಕೇಳ್ತೀನಿ.
In the 28th you have filed the memo calculation.
I will not be in station on 28th, my lordship.
29th
26th ಗೆ ಇಲ್ಲ, 26th ಇಂದ ನಾನು ಇರಲ್ಲ.
26th ಗೆ ಬನ್ನಿ.
26th
ಇರ್ಲಿ ನೋಡೋಣ. You give that memo of calculation.
Yes, my lordship.
Then we will see that if that calculation is accepted, in his presence is not necessary, we'll dispose of it.
Meanwhile, I may be permitted to sign that.
What is that?
Application ಅಲ್ಲಿ ಒಂದು ಡಿಫೆಕ್ಟ್ ಇದೆ.
Yes.
I will come.
Yes, do it. Yes.
Malad,
this matter on 26th.
The payment may be recorded.
ಆಯ್ತು, ಅವತ್ತೇ 26th ಅಲ್ಲಿ ಹಾಕೋಣ ಬಿಡಿ.
19
What is disputing? Yes. Yes.
Serial number 54, Prashant UT for petitioner, Vishnu Hegde.
Your Lordship, are pleased to hear this matter at length in the previous occasion.
For the respondent number 2 in this matter.
This is a case wherein, my lords, without fixing the base price, the property belonging to this petitioner has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord, has been sold in execution. The petitioner, my lord Not only that, my lords, order 21 rule 66 is not complied by not fixing the price of the property. Secondly, my lords, the trial court.
I have to hear, I've forgotten everything.
My lords, I will not take more than 2 minutes, my lords, of your lordship's time to highlight the facts.
Let us see, we'll pass over, all pass over matters. If it is over, then
I will leave it to your lordship, please.
let us see.
I do understand, my lords, this court is heavily loaded. And
No,
GMCPC matters
No, the
concerned,
problem is, I am ready to take contesting matter. If I take,
it will take too much of time.
others
Rest of
10 to
the
15
advocates have to
matters,
wait, please.
that is how.
I don't want that to happen, please.
Yes, let us see.
Please,
Pass
please,
over.
please.
Yes.
Bill number 55, Arvind H. for petitioner, Ravi Shankar S.
Let's appearing for petitioner, my lords. Yes. Let's in this matter, my lords, I am pressing interim order, my lords. The notice has been served, my lords. They have not.
Yes, what is that interim order?
My lords,
What is that matter?
the already, my lords, same subject matter has been stayed by this honorable court, my lords, same FDP.
No, you just give the brief facts.
Your lordship only is passed.
What is this?
Let's here in this my survey number is 80/3. Yeah, the order has been passed for 80/2, my lords. Is same FDP, same OS number, my lords. This is survey number.
In this writ petition itself is allowed,
Yes, my lords.
disposed of.
Yes, my lords.
Yes, what is this, Mr.? Your solution.
My lords,
Who is your opponent?
let's respond number 1, my lords, Rajanna. My lords, here, my lords, respond number 1 has filed a suit in 337 of 2005, my lords, which came to be decreed, and decree has been passed in the year 2022, my lords. There, my lords, I am not a party to the OS and also to the FDP, my lords. By agreeing by that, my lords, we have challenged in RA number 55 of 2024, my lords, which is at page number 70. Suit for partition, my lords. My lords, the background of the case is, my lords, kindly come to page number 133, my lords.
Yes.
My lords, this is the first sale deed, my lords. It has been sold in the year 16/9/1940, my lords, by the plaintiff's family, my lords.
Yes.
Later on, my lords, my vendor has been purchased the said property in the 2007, my lords. It is at page number 142, my lords.
Yes.
My lords, later on, the property has been converted to non-agricultural to residential purpose, which is at page number 159, my lords. It's a conversion copy.
Suit for partition is decreed.
Yeah, decreed, my lords. There we are not parties, my lords.
Yes,
These
you-
sale transactions and all took place.
Yes, you have challenged that before RA.
Yeah, yes, my lords. I have challenged before the RA. My lords, the interim application has not been considered, my lords. Being agreed by that, I am before this court, my lords.
In RA, no.
RA, my lords, no order has been passed. My lords, that IA, my lords, order sheet is at page number 127, my lords.
120.
127.
What is that? 127. Yes, when you have filed an RA.
My lords, I have filed RA in the year 2. My lords, it is at RA. It is at page number 75, my lords. In 17/7/2024, my lords.
Huh?
17/7/2024, I have filed a RA, my lords.
Yes, along with that, you have filed an application.
Yes, my lords.
Amele?
And my lords, it is at page number 127. The order has been passed, my lords. They have issued emergent notice based on these applications.
Council. RA 55 of 24.
Yes, my lords.
How did that appellant council so and so? Yavat emergent notice issue ಮಾಡಿದ್ದು 28/7/24.
Yes, my lords.
How did that appellant council IA affidavit document produced by the appellant appeal is filed by the setting aside the judgment. So and so. IA filed under 150 appellants are not parties to the proceedings in the court. There is that appellant filed then above appeal they contended with they are affected with the order. CP seeking an injunction. Matter at state appears just and proper to hear that respondent. ಆಮೇಲೆ ಏನಾಯ್ತು 27ರಿಂದ?
My lords, notice await ಅಂತ ಹೋಗ್ತದೆ ಸ್ವಾಮಿ.
ಇನ್ನು ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ ಅವರೇ.
ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ ಅವ್ರಿಗೆ.
What is this connected matter?
Connected, my lords, kindly, my lords, come to page number 73, my lords.
ಅಲ್ಲ ಇದು ನೀವೇನ್ ಜಡ್ಜ್ಮೆಂಟ್
ಅಲ್ಲ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾಕಂದ್ರೆ 73 ಅಲ್ಲಿ ಸೇಮ್ ಸರ್ವೆ ನಂಬರ್ ಮೇಲೆ ಸರ್ವೆ ನಂಬರ್ 80 is a vast extension of 13 acres ಮೇಲೆ ಅದರಲ್ಲಿ ಒನ್ ಪೋರ್ಷನ್ 80/2 ಗೆ ತಾವು ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀರಾ ಸ್ವಾಮಿ. ನಾವು 80/3 ಮೇಲೆ 73 ಮೇಲೆ ಸ್ಕೆಚ್ ಅಲ್ಲಿ FDP ಸ್ಕೆಚ್ ಅಲ್ಲಿ 80/2 ಗೆ ಆಲ್ರೆಡಿ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ ರಿಟ್ ಪಿಟಿಷನ್. 80/3 ಇನ್ ದಿಸ್ ರಿಟ್ ಪಿಟಿಷನ್ ವಿ ಆರ್ ಬಿಫೋರ್ ದಿಸ್ ಆಲ್ರೆಡಿ ಮೆಲಾಡ್ಸ್ FDP ಹಾಕಿನ ಮುಂಚೆನೆ ಪೋಡಿ ಆಗಿ ಕನ್ವರ್ಷನ್ ಎಲ್ಲ ಆಗಿದೆ ಸ್ವಾಮಿ. 80/2 ದಟ್ ಐ ಪ್ರೊಡ್ಯೂಸ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ ಮೆಲಾಡ್ಸ್. 80/3 ವಿ ಆರ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಮೆಲಾಡ್ಸ್. ದ ಸೈಟ್ ಆಗಿದೆ ಮೆಲಾಡ್ಸ್, ಸೈಟ್ ಫಾರ್ಮೇಶನ್ ಆಗಿದೆ, ವಿ ಆರ್ ದ ಸೈಟ್ ಹೋಲ್ಡರ್ಸ್ ಮೆಲಾಡ್ಸ್. ದೇ ಆರ್ ಟ್ರೈಯಿಂಗ್ ಟು alienate and disturb the possession ಮೆಲಾಡ್ಸ್. ಐ ಹ್ಯಾವ್ ಆಲ್ಸೋ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಮೆಲಾಡ್ಸ್. ಮನೆ ಕಟ್ಕೊಂಡಿದೀವಿ, ಎಲ್ಲ ಲೇಔಟ್ ಫಾರ್ಮೇಶನ್ ಆಗಿದೆ, ಎಲ್ಲ ಆಗಿದೆ ಸರ್. My original vendor purchased in the year 1940 millets before freedom millets. Suppressed.
Directed to dispose of application.
Millets, interim millets, why? Because they are trying to change the kata and trying to alienate millets. Kindly see page number 244, photographs millets. Millets.
What is the next date in that appellate court?
Millets, it is at July, the date is fixed in July millets.
There, in that case, there was an interim order, then there both the parties were there. Either
That's here also same party millets. Here also I was served through.
No, counsel is there, nobody is representing.
Yes, millets. And summons tagona kelidre millets. I took and summons also millets because kindly see the photographs millets. 244. Mane ella katkoni, they are trying to disturb millets. That's why status quo adru kodi so.
Ade ನೀವು appeal file ಮಾಡಿ ಈಗ ಆಲ್ರೆಡಿ 1 ವರ್ಷ ಆಗಿದೆ.
ಹೌದು ಸ್ವಾಮಿ. ಅದಕ್ಕೆ ಅಲ್ಲ, ದಟ್ಸ್ ವಾಟ್ ಮೆಲಾಡ್ಸ್ ಬಿಫೋರ್ ರೀಚ್ ಆಗ್ತಾ ಇರಲಿಲ್ಲ ಸ್ವಾಮಿ. ಅದು ಇಷ್ಟು ದಿನ ಅದು
if you want, I will direct it to dispose of. What is the next date in that appeal, Mr.
Melods? I will
because all the parties they are not represented in before the appellate court.
No Melods, all the party only respond number 1 is the contesting respond party Melods. Only respond number 1 has took the FDP in his favor Melods.
ಅಂತ ಅಂದ್ರೆ ಇವರು
ರಾಜಣ್ಣ
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? ರಾಜಣ್ಣಗೆ
ರವಿಶಂಕರ್ ಅಂತ.
ಅದೇ ಅವ್ರು ಬಂದು ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ತೀವಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂದ್ರೆ ಐ ಕ್ಯಾನ್ ಡೈರೆಕ್ಟ್ ಟು ಡಿಸ್ಪೋಸ್ ಮಿಸ್ಟರ್.
ಎಸ್ ಮೆಲಾಡ್ಸ್ ಅವರು ಬರ್ತಾ ಇಲ್ಲ ಮೆಲಾಡ್ಸ್. ಕೈಂಡ್ಲಿ ಮೆಲಾಡ್ಸ್ ಸ್ಟೇಟಸ್ ಕೋನ್ ಆದ್ರೂ ಕೊಟ್ರೆ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಇದರಲ್ಲಿ ತುಂಬಾ ಮೆಲಾಡ್ಸ್ ಬಿಕಾಸ್ the alienation was took place in 1940 ಮೆಲಾಡ್ಸ್. I produced the sale deed also.
No Mr.
in the previous that same matter ಮೆಲಾಡ್ಸ್ FDP 7 ನೇ ಸ್ಟೇ ಮಾಡಿದಿರಾ ಸ್ವಾಮಿ ನೀವು ಅದರಲ್ಲಿ?
No, there they have agreed for disposal of the appeal itself.
Yes my lords. ಆಮೇಲೆ ಅದರಲ್ಲಿ 80/2 ಗೆ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ರೆ ಸರ್. With respect to 80/2, let's see.
Both the parties are agreed there. Here they are not there.
Same parties my lords, same this thing my lords. That's why status konaದ್ರು.
You get him. Yes, pass on.
Yes, much obliged.
You get him. If he comes, then you can dispose of.
ಇವರ ಒಂದು ಅಮಲ್ ಸಬ್ಮಿಷನ್ ಇದೆ ಇವರ. ನಮ್ದು ನಂಬರ್ 51 ಆಪೋಸಿಟ್ ಪಾರ್ಟಿ ಬೆಳಗ್ಗೆ ಬಂದು ನಮ್ಗೆ ಗೊತ್ತಿದ್ದಂಗೆ ಅಡ್ಜರ್ನ್ ಮಾಡಿಸಿದ್ದಾರೆ. ಅವ್ರದ್ದು ಇದು ಇದೇ ತರ ಫಾಲ್ಸ್ ಅಫಿಡವಿಟ್ ಹಾಕಿ ಕೇಸ್ ಹಾಕಿರೋದು ಇವರ.
ಯಾವತ್ತಿಗೆ ಹೋಗಿದೆ?
ಇವತ್ತಿತ್ತು ವರ 51 ಇತ್ತು ನಮ್ದು ನಂಬರ್.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಟೈಮ್ ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿರಲ್ಲಪ್ಪ.
ಅಂದ್ರೆ ನಾ ಇಲ್ಲೇ ಗೊತ್ತೇ ಇಲ್ಲ ಅವರ ಇದೇ ತರ ಮಾಡ್ತಾ ಇದಾರೆ ಅವರು.
ಆಯ್ತು, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಒಂದು ಡೇಟ್ ಕೊಡ್ರಿ
ದಯವಿಟ್ಟು. ಇಲ್ಲ ಇವರ ಅದು ಸ್ಟೇನಾರ ವೆಕೇಟ್ ಮಾಡ್ಕೊಡಿ ಇವರ ನಿಮಗೆ.
Yes, will on 4th June. Yes, 4th June date ಕೊಡಿ. Yes. Yes.
Serial number 56, Nishant KV petitioner, Sadashivaya KG.
The second respondent in.
Malad, the appropriate applications has been filed.
But I am sorry, Malad. The writ petition came to be filed against a dead person. Malad, it is only an inter-alia application filed before the trial court in a suit for declaration and injunction. At that point of time itself, the second defendant was no more.
Yes.
They filed, they proceeded the matter and they sought for injunction before the trial court. The trial court refused to grant an injunction. Thereby they filed a writ petition before this honorable court.
Only one submission is that on 30th
the writ petition came to be filed.
They filed a memo stating that the respondent number 2 is dead.
The writ petition, no, he is a related.
Knowledge regarding to death of
the petitioner is a related. Please let him submit. The petitioner was related to the person who is a IAS officer, was serving in the service department. department. My lord, he died. My lord, both the parties, the petitioner as well as the respondent herein, we have purchased the properties. I property one portion, they also property another portion. When such being the state of affairs, BS also belongs to Delhi only. They know the facts, and he died on, my lord, you let me kindly see, on 9/5/21 itself. The suit came to be filed on 22/4/24 after a lapse of 2 years. But they filed a suit before this court and wanted an injunction that was refused by the trial court, and they filed a writ petition. In the impeachment, they obtained an interim order saying that my property has to be stayed.
No,
By virtue of that.
where is that plaint?
Please, Manoj, that has been produced at,
Prayer Melody is at page number 45.
Plaint.
yes.
Plaint Melody is at
Please,
page
Manoj,
number 34.
this page 34.
34.
Yes, Manoj.
Yes, who is that?
No, the second respondent in the suit.
No, suit for?
Suit for
Melody
declaration.
and recovery of money also.
Yes.
My lord, there is no privity of contract with the
You are appearing for whom?
first respondent.
First respondent. What is that relationship between first and second
My lord,
respondent?
he is a seller. The second respondent was a seller to me as well as my learned friend. My lord, they purchased the property, different property. I purchased different property, and there was no, and there was an agreement.
There is the order under order 39 rule 112.
39 rule 112, no order came to be passed by the trial court.
Page number
Yes,
242,
ma'am.
Melody.
They produced.
242 of the petition may kindly be seen.
242.
242, Melody.
ಏನಾಯ್ತು?
Notice has been issued. Summons has been issued. Melody. The interim orders was not granted. I filed an application under 39 rule 1 and 2. Not
Before
to
that
change the
issue-
nature, not to alienate Melody. The trial court Melody did not grant the relief. Therefore, I filed a present petition. Melody,
What
what
is
has
that
happened?
interim order granted here?
The
Melody, the interim
The
order was.
respondent are directed not to alienate, encumbrance, create third party rights over that suit scheduled property.
yes, ma'am.
Yes, not to create third party
My
interest.
lord, one thing is, my lord, I am the bona fide purchaser, and earlier agreement which was obtained by the petitioner before this summer, that has been cancelled by the document, by registered document.
Now, what is the next date before the trial court?
Trial court, my lord, it is
3/7,
going-
Melody.
Please, let me submit. The court, the matter is listed before taking the steps. Without saying, in spite of there is an order passed by this honorable court, there is no bar for the trial court to proceed with the matter. In spite of it, the matter is listed to 3/7/2025. 3/7/25.
No, where is that
Your lordship was pleased to pass an order on that.
interim order granted by this court will not come in the way of the trial court to proceed with that matter in accordance with law?
No, my lord, having
No.
invested the huge money, I could not develop the property or sell the property or do it anything. Therefore, my lord, I requested this honorable court, let the applications pending for injunction be considered by the trial court at an earliest. That's all I want.
Now that if a injunction is granted,
Yes, my lord.
then that LRs which will come on record later, they will say that we have not been heard.
My lord, the suit itself is filed against a dead person.
ಆಯ್ತ್ರಿ ಡೆಡ್ ಪರ್ಸನ್ ಗೆ ಗೊತ್ತಿಲ್ದಾನೆ
My
ಹಾಕಿದ್ರೆ
lord, it is for the court. It is for the court. Ultimately.
My knowledge is also important.
Ultimately, it is for the court to decide whether the application is maintainable or not.
ಅದು ಅಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡಿ ಅದನ್ನ ಎಂಟರ್ಟೈನ್ ಮಾಡೋದು ಬಿಡೋದು ಅದು
ಹೌದು.
ಈಗ ಇಲ್ಲ if you are agreed till the disposal of that application, this parties are directed to not create third party interest will be the trial court, he will directed him to take steps immediately after that.
They filed an application before the trial court also. That has not been considered. They are deliberately prolonging the matter. Now, my lord, the matter is listed to 3/7.
No, application for LR notice has been served.
Notice
No,
has been issued, man. Issued.
But because the address of the person is not known to anybody. They have not given the correct address.
ಮತ್ತೇನ್ ಮಾಡ್ತೀರಿ ಈಗ ಅಡ್ರೆಸ್
It is for the party to take a
My knowledge,
ಅಪ್ಲಿಕೇಶನ್ ಮಾಡ್ಬೇಕು.
in
That
my
has to be
knowledge,
done, my lord. Now, my lord, as it is, my lord, from April to July, it has been posted. But therefore, my lord, the interim order injunction is passed against me only, not against the dead persons also. No, my lord. Therefore, I requested the Honorable Court, let the trial court dispose of the application for injunction at an earliest by fixing the date.
No, can it be passed without bringing LRs on record? If it is an ex parte, it's okay.
It is not against them. They have sought against me only.
There is that application. Is it only against
Let me
you?
kindly see.
Yes, then we can clarify that.
Yes, my lord.
Yes, where is that application?
Page number 49.
49.
14.
This is the property which I purchased by me in the year 1968, 28.
Yes, Mr. You are seeking, please to restrain the defendant number one.
Number one, my lords, because he is
Yes.
claiming that he is in the possession
For
of
me
the
only.
property.
Now that to deciding this application, bringing an LRs is not required.
Yes.
Because his relief is only against him.
Yes,
I will direct it to consider that application.
yes.
Till then that interim order will be continued. Yes.
That may be, my lord, may request, my lord. Now the long date has been given by the trial court.
We are permitted to prepone that.
That may be done.
Yes. That's
Since
all.
the vacations are also coming in the middle, my lords.
Why you are worried? It is for the court, Mr.
Please.
Yes. In this writ petition, petition is filed by the plaintiff challenging order dated 23/4/2024 passed by Principal Senior Civil Judge JMFC Magri in OS number 289 of 2024 on IA number 1 and 2, whereby refused to grant ex parte temporary injunction order. Plaintiff has filed in a suit for declaration.
Declaration and recovery of money, my lords.
But in
Declaration
fact,
and recovery of money.
page 148 may kindly be looked into. They created an agreement that they themselves has cancelled the agreement itself.
Filed in a suit for declaration and recovery of money. Along with that, plaintiff he has also filed an application under order 39 rule 1 and 2 seeking ex parte injunction order restraining defendant number 1 and his agent from changing the nature of the suit schedule property till the disposal of the suit. The trial court has refused to grant any ex parte injunction order.
May I interject, my lords? There is another application also not to alienate. IA number 1 and 2.
ಆಯ್ತು ನಾನೇ ಕೊಡ್ತೀನಿ ಅಲ್ಲಿ ಅವ್ರಿಗೆ. Yes. IA number 1, yes. IA number 2 for not to alienate that suit schedule. ಎಲ್ಲಿದೆ IA number 2? No, it's for R1 only.
D1
D1 only. Yes.
Even
IA number 2 for not to alienate that suit schedule property. The trial court has refused to grant ex parte injunction order and issued a summons to the defendant. Being agreed by the same, the plaintiff is before this court. This court, by order dated 25/4/2024, granted an interim order directed. Respondents are directed not to alienate, encumber or create third party rights over the suit schedule property till next date of hearing. That interim order was continued till today. Now, the injunction application is filed seeking a temporary injunction only against that defendant respondent number 1. Defendant number 1, respondent number 1. Even though defendant number before the trial court is dead application to bring LRs is pending on record, pending for consideration. There is no difficulty for the trial court to consider IN number 1 and 2 filed by the plaintiff under Order 39 Rule 1 and 2, since interim injunction is sought only against that defendant number 1.
Please, please.
In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to consider that application filed by plaintiff petitioner under Order 39 Rule 1 and 2, IN number 1 and 2, as expeditiously as possible. The respondent defendant number 1 is permitted to prepone the case
Please.
after service, after intimating that plaintiff
Within,
the interim order granted by this court will continue till disposal of that application.
my lord, time may be green, dispose of the application because my lord, we have already filed return statement and objections also. Only thing is the matter has to be heard by the trial court. That is that stage. Yes.
Now that the problem is.
Understand, my lord. I understand with regard to vacation, but my lord, another 1 month will be there.
No, I will say that.
In that man,
within 8 weeks.
8 weeks from today.
8 weeks from today. Within 8 weeks from today.
Please.
First over matter.
Grateful.
Serial number 4, Ravi Kumar NR for petitioner, JN Naveen. Serial number 4, Ravi Kumar NR.
This case, my lord, kindly, there is the annexure L, my lord. The earlier writ petition filed by the petitioner before this honorable court, the application filed by the petitioner for appointment of the court commissioner has been rejected by the trial court.
Now that, why it is passed over in the morning, officer?
Morning, the cavator has taken the pass over.
Our ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿ. Yes, what is this?
My lord, the earlier, my lord, for the appointment of the court commissioner application has been rejected by the trial court. That has been challenged before this honorable court in, as per the annexure L, my lord, in page number 180, my lord. This honorable court has allowed my writ petition and directed the trial court to appoint the taluk surveyor to identify the decree schedule property, my lord.
Where is that order?
Order at an annexure L, my lord, page number 180, my lord.
L.
In the operative portion, my lord, in the fourth condition.
Page number?
Annexure L, my lord.
Page number,
180.
180.
180, the page all change ಆಯ್ತಂತೆ.
L is 180.
L, my lord. This honorable court has allowed the writ petition and in the operative portion, in the fourth, my lord, the executing
Order
court.
passed by that execution
Court is directed to obtain the report from the taluk surveyor.
IA filed by under order search is allowed. Executing court is directed to obtain that report of the taluk surveyor within 1 month from the date of the communication of this order. Proceed to execute the judgment and degree.
Yes, yes. Now kindly there is the page number 39, my lord. 39.
Yes.
In the 39, in the operative portion of the trial court order, my lord, case is called out. The decree holder is present. The counsel for the decree holder filed the memo and produced the order passed in the writ petition number 242 of 2025 dated 18/2005. Therein, the Honorable High Court of Karnataka has allowed the writ petition and ordered to appoint the taluk surveyor to identify the decretal property. Hence, the taluk surveyor Chikmagalur is hereby directed to identify the decretal property and submit the report, issue intimation to the taluk surveyor. Accordingly, call on 14/3/2025. Kindly peruse the next page, my lord. On 14/3/2025, without receiving the taluk surveyor report, again the court has ordered to appoint the ADLR, my lord. Case is called out. Sumoto court has passed the, my lord. The ADLR Chikmagalur is hereby appointed as the court commissioner to identify the technical property. The ADLR Chikmagalur is hereby directed to expedite the entrusted task without causing any delay. Call on 23/2025. On 23/25, the commission report has been received, my lord. And thereafter, both the councils filed the objection, and thereafter the judgment.
ADLR report is issued.
Taluk survey report also received, my lord.
Why that again ADLR has been appointed?
The reasons not known, my lord. The reasons not. I mean, thereafter, my lord, this petitioner's council filed the application under Order 14, Rule 10 to summon the court ADLR to give the to clarify the report given by them. And thereafter, the court commissioner has summoned. He has present before the court, and he has produced the document, and he has examined SCW1, and also the document has been marked, and he has fully cross-examined by both the council, decree holder and judgment debtor. Thereafter, case was posted for orders. And kindly next page, my lord, the order was not ready, and thereafter on 2/4/2025, without rejecting or accepting both the Taluk surveyor or ADLR report, the court suo moto has ordered by considering the facts and circumstances involved herein, it is necessary to secure the report from the executive engineer, PWD Chikmagalur, to decide the aspect involved herein. Therefore, the executive engineer, PWD Chikmagalur,
This execution of what partition suit?
Allah, the decree, position and declaration, position and injunction. That has
Yes,
been.
Mr. Why court go on?
Again and again.
Officers report.
ಇಲ್ಲ ಅಲ್ಲ ಅದು ಮುಂದಕ್ಕೆ ಹೋದಿ ಸ್ವಾಮಿ ಅದು ಓನ್ಲಿ ಇನ್ಸ್ಪೆಕ್ಟ್ ಆಫ್ ರೋಡ್ ಅಷ್ಟೇ ರೋಡ್ ಎಷ್ಟಿದೆ ಅಂತ ಮುಂದಕ್ಕೆ ಹೋದಿದ್ರೆ
ಅಲ್ಲ why that nobody has filed it? See, when this two commissioner report is there,
ಪ್ಲೀಸ್
then why that again three commissioner report contradictory three
ಅವ್ರ ಕಂಟೆನ್ಷನ್
And my lord, my submission, my lord, the PWD engineer.
ಪ್ರಾಪರ್ಟಿ ಅವರು ಬಿಲ್ಡಿಂಗ್ಸ್ ಏನ್ ಕಟ್ಟಿದ್ದಾರೆ ಅದು ನಮ್ಮ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ನಾವು ಹಾಕಿರೋದು. ಅವ್ರ ಕಂಟೆನ್ಷನ್ ಪ್ರಾಪರ್ಟಿ ನಮ್ದ್ರಲ್ಲಿ ಬರಲ್ಲ ರೋಡ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಅವ್ರ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ದಾರೆ. ಅದಕ್ಕೋಸ್ಕರ ಓನ್ಲಿ ಫಾರ್ ಲಿಮಿಟೆಡ್ ಪರ್ಪಸ್ ರೋಡ್ ಎಷ್ಟಾಗಲ್ಲ ಇದೆ ಅನ್ನೋದಕ್ಕೆ ಮಾತ್ರ.
ಅಲ್ಲ ಅವ್ರ ಕಮಿಷನರ್ ಮತ್ತೇನೆ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರ?
ಅಲ್ಲ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ಲ, ಅವ್ರದ್ದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ಲ ಮಾಡಿದ್ರು.
Why go on that making? And why that so moto they have taken that?
So moto
nobody has filed an application.
Nobody has filed an application based on the contention of the petitioner's lordship. Only to report, secure the report in respect of the width of the road. Road ಎಷ್ಟಿದೆ ಅಂತ ಅಷ್ಟೇ ಸ್ವಾಮಿ.
There is that either you have not filed an application, he has not filed an application.
ಅಲ್ಲಿ ಮುಂದಕ್ಕೆ ಹೋದರೆ ಸ್ವಾಮಿ. Therefore the executive engineer PWC is hereby directed.
After evidence and all, if court comes to the conclusion saying that I am not able to decide this case even on the basis of that ADLR and so and so, therefore his court has find that so and so. ಆವಾಗ ಅಪ್ಲಿಕೇಶನ್ ಆಫ್ ಮೈಂಡ್ ಹಾಕಿ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಇಟ್ ಕ್ಯಾನ್ ಬಿ.
ಅದು ಬರಿಬೇಕಾಗಿತ್ತು, ಅದು ಬರಿದಿಲ್ಲ. ಇಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ, ಡೈರೆಕ್ಟೆಡ್ ಟು ಸಬ್ಮಿಟ್ ಎ ರಿಪೋರ್ಟ್ ಆಸ್ ಟು ವಿಡ್ತ್ ಆಫ್ ದ ಹಿರೇಕೊಳಲೆ ರೋಡ್ ಅಟ್ ದಿ ಲೊಕೇಶನ್ ಆಫ್ ಉಪ್ಪಳ್ಳಿ ವಿಲೇಜ್.
ದೇ ಶುಡ್ ಗಿವ್ ದ ರೀಸನ್. See, in both commissioner report this issue has not been answered, therefore it is required, therefore I am directing that. Nothing is there.
ಅದನ್ನ ಅಬ್ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
ಅದು ಏನು ನಾವು ಅಸ್ಯೂಮ್ ಮಾಡ್ಕೊಂಡು ಹಿಂಗ್ ಇರ್ಬೋದು ಅಂತ.
ಅದರ ರಿಪೋರ್ಟ್ ಅವರು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಮಾಡಿದಾಗ
ಕಮಿಷನರ್ more than that, my lord,
that is the contention of the petition.
Another submission, if I submit before this honorable court, it is very aspirational, my lord, because the court suo moto telephonically called the PW engineer to the court and directed the PW engineer to submit the report before 4:30. Before 4:30, why the court has taken such interest, my lord? And moreover, my lord, the second respondent herein was the fifth JDR. He is also colluded with the decree holder, that is the first respondent.
I will hear, now we will stay that further question.
Stay ಕೊಡೋದಕ್ಕೆ ಸುಮ್ಮನೆ ಇವತ್ತು ಆರ್ಡರ್ಸ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. I will submit only this reason, your worship. Commissioner was submitted a report, your worship, to the court. At that point of time,
no, without referring to that, let him decide on that earlier commissioner report submitted by both the ADLR, and even ADLR is also not necessary when this court has specifically dated. Yes, ADLR, but it cannot go on buying without any giving any reason.
But road width ಅಷ್ಟೇ ಸ್ವಾಮಿ, road width ಎಷ್ಟಿದೆ
they can't do it in their whims and fancy, Mr. They have to give a reason.
That is the contention of the petitioners put forth.
Yes, then we'll hear that. Yes.
And the notice to the respondent is also required, my lord, because he is also colluded with the first respondent.
ಅವರೇ
And my
He's
lord,
of the JDR.
and the PW engineer, he is also one of the relative of the second respondent. That is also very important here. That is why.
No, we are not examining all these things.
Please, ma'am.
Where this order has been passed without application of mine.
Yes.
That will be considered, yes. Or stay of further proceedings.
ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಬೇಡ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡ್ಲಿ
Yes,
ಓನ್ಲಿ ಇನ್
they have-
ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿಸ್ ಆರ್ಡರ್ ಅಷ್ಟೇ.
Then you can proceed with that other.
Otherwise. ಯಾಕಂದ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕನ್ಫರ್ಮ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
Pay of impugn order dated 2/4/2025 passed by which court? Principal Senior Civil Judge and CJM Chikmagalur in execution number 68 of 2024 till next date of.
ಅದೊಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಇಟ್ ಇಸ್ ಮೇಡ್ ಕ್ಲಿಯರ್ ದಟ್ ಮಾರ್ಶಿಪ್ ದಿ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಪ್ರೊಸೀಡ್ ಬೇಸ್ಡ್ ಆನ್ ದಿ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್.
ಅಲ್ಲಿ further, my lord, one
This order will
submission.
not come in the way of,
One submission, my lord.
this interim order will not come in the way of that. The executing court to proceed with that matter
One
on the
submission.
basis of.
ಕಮಿಷನರ್
One submission, my lord. ADLR and Taluk surveyor has submitted the report before the court. He has also clearly examined and he has also marked the document and identified the degree schedule property. If that is executed, then we have no problem at all.
ಆಯ್ತು, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದೀನಲ್ಲ, ಇದನ್ನ ಬಿಟ್ಟು ಅದನ್ನ ಮಾಡಿ ಅಂತ.
ಅಷ್ಟೇ ಸ್ವಾಮಿ.
Yes. It will not come in the way of the trial court to proceed with that execution petition on the basis of report submitted by ADLR and Taluk surveyor in accordance with.
Please.
Serial number 8, KV Narasimhan for petitioner, Dinesha EP.
Aviator had not turned up in the morning.
Yes, Mr.
Please, my lord. Not
Serial number?
8, my lord.
8, sir.
Yes.
The
Yes.
difficulty is
Now you
this.
argue that, yes.
Well, the difficulty is this. What happens is, my lord, an order of temporary injunction is granted in favor of the plaintiff.
Yes.
I am for the defendant.
Yes.
My lord, I have filed a miscellaneous appeal.
Yes.
My lord, in the miscellaneous appeal, my lord, at the first instance, my lord, notice have been ordered.
Yes.
Thereafter, my lord, he starts evading taking the service of the notice. My lord, I take a fixture and then, my lord, he appears. And my lord, now time is granted, my lord, for filing of his objection. The matter stands listed, my lord, on 24/4/2025.
Now, why that morning is passed over? You
He
are
did not, he was not there. Aviator was not there.
No, what I have
Now,
expressed as
my
to
lord,
dispose of.
Now, what my lord suggested is, my lord would direct the miscellaneous appellate court to dispose the miscellaneous appeal within a time frame.
Or if he has come.
Now, police protection application is there. What I said, my lord, is I requested my lord to consider keeping it in abeyance until and unless the miscellaneous appeal is decided.
Now you give that brief facts.
Please, my lord.
Yes. Now you are the plaintiff.
My lord, I am the defendant, my lord.
Defendant.
My lord, the suit is, my lord, for temporary injunction.
Yes.
Concerning the property, my lord, in question.
Yes.
My lord, the interim order, my lord, is granted on 19th of December 2023.
Yes.
Temporary injunction, my lord, is granted.
Yes.
My lord, I immediately file a miscellaneous appeal on
Yes.
9/2/2024.
Yes, your miscellaneous appeal is pending, but they are proceeding with that.
Now, police protection, IA, my lord, he goes and participates in the trial court.
Now, where is that appeal, miscellaneous appeal order sheet?
My lord, order sheet, my lord, commences from page number 44.
You have filed an application for stay also?
Yes, my lord, I have filed an application for stay. It is at page
44.
number 41.
40?
41 is the stay application. Page number 41.
Yes, now what is that order sheet shows?
My lord, the order sheet shows, my lord, on the first day, page number 45, my lord, notice is ordered, returnable by 4/3/2024.
Yes.
Then, my lord, he remains absent. He keeps on evading.
Yes.
My lord, I can't serve him. Eventually, my lord, I take substituted service in form of a fixture. My lord, a fixture is permitted and I take the fixture. By then it is 13/12/2024. Immediately, my lord, he turns up. He turns up, my lord, and he says that he'll participate in the proceedings. Then, my lord, 27/3/2025, the matter was posted for him to file the wakalat.
Yes.
My lord, he is seeking time there for filing of the objection. Now, the next date, again, my lord, for filing of the objection is 24/4/2025.
Now that, which is that police protection order?
My lord, the police protection order is at Annexure L, page number 58.
Annexure L.
Annexure L, page number 58.
Yes.
Now,
Stay of order dated 12/2/2025, passed by additional civil judge JMFC, Kerpet, in OS number 15 of 2022 till next date of hearing.
Great.
Serial number 10, Manjunath Prasad V.
APO for the petitioner, my lord. My lord, the petitioner is the plaintiff number 3 before the trial court, my lord. Filed the suit for partition and separate possession, my lord. His application for impleading is rejected, my lord, against which the petition is preferred.
Serial
my
number
lord. 10, my lord.
10. Suit for?
Suit for partition and separate possession, my lord.
Yes.
My lord, the plaintiff at the time of filing of the suit, my lord, one of the family members has not been inserted, my lord. Now, my lord, filed the impleading application to implead the proposed defendant number 7, my lord. And the defendants have not filed any objections to the application, my lord. But the Lucknow judge has rejected the application on the ground of that the application is filed belatedly, my lord.
Who is she?
My lord, she is one of the daughter, my lord.
Yes, read reasoning. Why?
The affidavit, my lord.
More than 7 years has been already lapsed. If the plaintiff wants to implead the party in the suit, they could have filed that present application at the initial stage. Now the plaintiff he has moved the present application only with the intention to drag the proceedings of the case. If he is the necessary party to suit, plaintiff could have been doing that application at the initial stage. If silence not moved any application to end of suit. It is so. Suit for?
Suit for partition and separate possession.
Yes. Who is there in the possession of the property?
Plaintiffs are there.
You are in the
and-
possession of the.
Yes, madam.
Then therefore you are filing an application for impleading after 7 years. See,
Yes, madam.
court has rightly held, there is no bar, but you have to see that intention. If it is court go on dragging that, you are in the position, you can enjoy.
And my lord, even the defendants are jointly in the possession of the property, my lord.
Who are jointly in the position? Who are there in that? What is that relationship between plaintiff and defendant number, the application, applicant, impleading applicants, proposed applicants?
Proposed applicant is the one of the sister, my lord. My
then
lord,
ನಿಮಗೆ-
kindly see page number
ಆದ್ರೆ ಗೊತ್ತಿರ್ಲಿಲ್ವಾ ನಿಮಗೆ sister?
My lord, it is informed that the Chikka Mannamma was died, my lord. But later she.
ಆಯ್ತು ಬಿಡಿ, partition suit ಅಲ್ಲಿ they can be impleaded in that final degree proceedings itself. Let them come. Why do you want now that?
Otherwise, it leads to multiplicity of
Delaying
the
that.
proceedings, my lord.
Now that application notice has been issued to that proposed party.
No, my lord.
Without issuing notice, it is dismissed.
Yes, my lord. And even the defendants have not filed any objections to that, my lord. Even they say no objection to allow the
Take
application.
notice. Yes.
Interim order, ma'am.
Notice only, no. Yes.
One date may be fixed, my lord, after vacation.
You serve it and move that matter. Yes.
Much
Serial number 19, R. Gopal.
Yes.
But I am defendant number 1. I am challenging annexure A, my lord, regarding marking of documents. Trial court says, my lord, this is inadmissible in evidence for various reasons. Your lordship may kindly turn to, my lord, page 16 at para 9. That suit for partition is filed by the plaintiffs. I am first defendant. I am opposing on several grounds, my lord, the partition suit. My lord, at the time of my evidence, this was sought to be confronted, this document. Court says, my lord, it is inadmissible evidence. Still, my lord, court orders for impounding, etc. Kindly see, my lord, para 9 of the order. Perusal of the document discloses that it is dated.
Para 9 page?
Page, my lord,
Yes.
16.
Yes.
Perusal of the said document discloses that it is dated 11/7/2010. Same is in between defendant 1, plaintiff 2 and 3. Document, if read in its entirety, it can be seen that there is allotment of space in the said document between defendant 1, plaintiff 1 to 3. The documents reads as under. Lord, it is not registered. It is, Lord, para 10. This is the extract of the document. Therefore, para 10. Therefore, if the reciters of the said document are considered, it can be seen that there is a division of properties under the said document, which is the suit of the plaintiff against defendant is one for partition and separate possession. In the plaintiff argument, there is no pleadings about this document dated 11/7/2010. The document produced is a Xerox copy, not even original. It is on a white paper. No foundation is laid for production of the secondary evidence. The reciters of the document clearly disclose that it is a partition deed. The Honorable Supreme Court of India in a recent division, so and so, so and so. Thus, if a document that is required to be stamped is not sufficiently stamped, then the position of law is well settled that a copy of said document as secondary evidence cannot be adduced. Therefore, when the document, though is styled as a panchayat deed, is in fact a partition deed under which the partition is effected. Therefore, same being the Xerox copy and also insufficiently stamped document, unless proper duty and penalty is paid, in my opinion, it cannot be
Now,
admitted.
what is the stamp duty for partition deed, Mr.?
That is, my lord, a nominal amount will. I think, my lord, that is 200 or 300, whatever it may be.
10 times 2,000 ರೂಪಾಯಿ ಕಟ್ಬಿಟ್ಟು ಸುಮ್ಮನೆ ಮುಗಿಸಿದ್ರೆ ಮುಗಿದೋಯ್ತಲ್ಲ.
ಅಲ್ಲ, ನಂದಲ್ಲ, ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. It is not, his case is not based on this partition deed. He is asking for partition and separate possession. There is no pleading at all with regard to this document. The trial court says, my lord, it is inadmissible evidence, but still, my lord, it impounds. My lord, when it is inadmissible in evidence for various reasons, my lord, it is on a white paper. It is not registered. It is under the document according to the judge, my lord, himself. Partition has taken place. Your lordship knows, my lord, if recital of in a document, if something oral has been recorded, saying that past partition has taken place, reduce it into writing, then it won't need registration. But whereas, my lord, under the document itself, partition has taken place.
No,
then
is it partition is under the documents?
yes, my lord, that is what the finding. That is what the finding. My lord, para 10, my lord. Therefore, if the recitals of the said document are considered, it can be seen that there is a division of the properties under said document. Under that document, it is not a past recital of a past partition, my lord, reduced into writing. It is a case under that document partition has taken place. That is also, my lord, Xerox copy, even not original produced. Therefore, my lord, it was inadmissible in evidence. Totally, my lord, the learned judge should have, my lord, stopped at that, saying that it is inadmissible evidence. It can't be marked. There is no question of impounding, etc., my lord, because his suit is for partition. He has not placed any pleading. In the pleadings, he has not covered about this document at all. Lord, I have the copy of the document. Your lordship may kindly see. This is on a white paper, not even. This is the one, my lord. Along with a memo, it is produced. Not even pleaded, my lord. Learned judge somehow, my lord, tried to extract in his judgment, in his judgment.
Yes, heard issue notice. Stay of further proceedings in OS number 5 of 2016, pending in the file of Senior Civil Judge JMFC Harriera till next date of it.
My lord, notice to summon to, my lord, only plaintiff matra kottare sakagatte. Dispense, my lord. I am seeking dispensation of notice to 7 to respondent 7 to 18, my lord.
The memo dispensation
For 7 to 18. Only to issue notice, my lord.
Notice to
1 to 6.
No, you will do one thing. You will only stay that order.
Stay that order, my lord. That is what I have sought for.
Yes.
Stay that order only, my lord, I have sought for, not for the proceedings.
Order dated 6/1/2025. Passed by so and so court in OS number 5 of 2016 till next date of hearing. Yes. Submission is accepted. Office objection is moved.
Notice only to R.
Yes. File in a memo. Dispense.
Cell number 24, Srinivasan T.
Yes.
Defendant's writ petition. Two applications were filed to recall PW6 for reopen and recall PW6 for cross-examination. Those applications came to be rejected on the ground that ample opportunities were given to this defendants and they did not cross-examine him. Whereas it is the case of the defendants that the very execution of the agreement of sale is disputed and denied and they have not executed the agreement of sale as such. So that being the reason, an opportunity ought to have been given by the trial court to see that they put forth the full case in their defense.
When you see, read that para 3. Para Para 3 is that objection. Where is the reasoning? Yes, para 6.
Para 6 of the objections.
Impugned order.
Impugned order.
Yes.
Upon perusal of the order sheet on 25/8/2022, 15/9/2022, 29/9/2022, PW6 was present, but cross has not been done. Subsequently, on 4/11/2022, 10/11/2022, matter has sought to be settled, but it has not happened. Hence, the matter was posted for cross-examination PW6 on 1/12/2022. Though PW6 was present on 5/1/2023, cross-examination is not done. Hence, cross-examination is taken as no cross-examination posted for further defense evidence. The defendant has not led defense evidence from so and so.
ಏನು ಮತ್ತೆ?
Lots
ಅವ್ರನ್ನು ಕ್ರಾಸ್ ಮಾಡೋದಿಲ್ಲ, ನೀವು ಮಾಡೋದನ್ನ ಟೈಮ್ ಕೊಡ್ತಾ ಹೋದ್ರೆ ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
ಎಲ್ಲ ಒಂದು opportunity ಕೊಟ್ರೆ
ಇನ್ ಎಷ್ಟು ವರ್ಷ ಮಾಡಕ್ಕಾಗತ್ತೆ ಅಲ್ರಿ?
My lords may kindly appreciate the written statement filed by me, page 38, para 12. The court, the defendant submits 13. The defendant submits a survey number 161 of Malur, in which sites are found was a total service in land regranted to the defendant, his brother Chikana, by the Assistant Commissioner Kolar, with certain conditions that the Chikana and one Abdul and so had colluded together and filed the suit for specific performance of contract and temporary injunction to protect the.
What you want to show in that?
I have to show that this agreement of sale has not been executed by me.
Who has stopped you to prove that? They have given so many opportunity, but you have not make use of that. Who has stopped you? Nobody has restrained you to do that. Court has granted you. You are not cross-examined even PW6. How many times he has appeared before the court? Then after closing that defense evidence, you are not led in evidence. What court can do, Mr.?
Defense evidence subsequently it has been led. And now I have to cross-examine PW6. That is what is left, and the matter is posted for arguments on 29/4.
No, that is what that when arguments are posted, then all this has to be done. No, Mr.
My lords may kindly appreciate to do substantial justice.
No justice. Now that
An
delay is
opportunity-
also that.
An opportunity may be
That we
given.
consider delay is also, limitation is also in come in that way. Where is that property situated?
Malur, my lord.
Huh?
Malur.
What is that?
It is all converted sites, man.
Sites?
Sites.
Yes. You deposit 15,000. For if it is, you succeeded, then that amount will be paid to that plaintiff. Subject to that, I will grant stay, Mr. Yes.
Nominal amounts.
Yes. Heard issue notice. Stay of further proceedings in OS number 139 of 2013, pending in the file of Senior Civil Judge Malur. Subject to condition, petitioner has to deposit 15,000 rupees before this court within 2 weeks from today.
Please.
Yes, submission is accepted. Office objection is complete.
Cell number 28, Nataraj Baba case.
The petitioner, my lords.
Yes, Mr. Nataraj, what is this? Preamble portion. Typed
Preamble
copy.
portion is not required, my lords.
Yes.
Typed copies, my lords.
Annexure A, IA number is mentioned as IA, same is.
My lords, it is wrongly mentioned, my lords.
Need typed copy. Yes, what is this?
My lords, suit for cancellation of general power of attorney, registered general power of attorney dated 29/6/2011, my lords. With the incomplete trial, my lords, suit has been decreed, my lords. We are the defendants, my lords. Unfortunately, my counsel was not appeared because of his ill health, my lords. And suit has been decreed, my lords. Immediately we came to know that suit has been decreed. We have filed appeal before the senior civil judge, my lords. In the senior civil judge, my lords, we have filed an application for stay of execution of the decree, my lords. Under 41 Rule 5 application, my lords. Under the trial court, my lords, without assigning any reasons, straight away rejected my applications, my lords.
Where is that?
That is page number 19, my lords. Annexure A, page number 19, my lords. Even it is mentioned as suit for permanent injunction, it is stated, but it is not for permanent injunction. It is for the cancellation of agreement. General power of attorney. Kindly see page. Appellants have filed the appeal against the respondent for the relief of permanent injunction.
IA number 1 is filed, it is IA number 2, my lords. IA number 1 is filed under 41 Rule 5 Red Bit 151 of CPC, seeking to stay the operation, execution and effect of the judgment and degree date so and so. Passed by the additional civil judge and JMFC, Kollegal in OS number so and so. On considering the appeal averment, IA affidavit and document placed on records, this court is of the considered opinion view that the appellants have not made out any prima facie case and matter required for consideration. Therefore, I proceed to pass following.
Is there any delay?
No delay, my lords.
Yes. Or issue notice. Stay of judgment and degree dated 22/3/2024 passed by additional civil judge JMFC Kollegal in OS number 39 of 2013 till next date of hearing.
Office objection may be overruled.
Yes, submission is accepted. Office objection is overruled.
Cell number 34, Jayaprakash Shetty B.
In this case for eviction of the eviction filed by the respondent plaintiff.
What fee has paid?
Paid and everything.
What is that maintainability in view of the
No,
problem?
in the so far IA number 1 is concerned, I will not insist, but it will not affect anything.
Deleted that.
No, it will not affect it. I only question the validity of the order passed by the common order passed on 8/1.
No, you have clarified in that IA,
Please.
in the prayer.
Prayer restrict to IA 2 and 2 to 3, 2 and 3.
Yes. Yes. Yes, what is this, Mr.?
Suit for a decree of eviction filed by the respondent in respect of the unfinished project. I contested the suit solely on the ground that the mandatory provision under section 12A of the Commercial Court Act is not followed. In this regard, I filed an application for rejection of the plaint, citing the judgment of the Partial Automation case of Supreme Court. My IA was rejected solely on the ground that, see, observation made in the Partial Automation case is in respect of suit for recovery. This is a suit for possession and eviction.
Where is that?
Your Lordship will find it page 96.
But that matter is now referred to that larger bench. Constitution bench is refer ಮಾಡಿದಾರೆ.
Has not come so far. No, it is.
It is referred subsequent non-judgmentally. It is not mandatory. Then Supreme Court referred that whether it is in a mandatory in that. Otherwise, that judgment Partial engineering.
Partial automation case.
Yes, Partial automation case, and Supreme Court said the suit has to be dismissed on that ground.
Please, even not.
Therefore, now that it is referred to that larger constitutional bench to see that whether that was the intention, is it required on that?
That I will verify it.
Yes, we verify that larger bench judgment. Please. What has happened? When do you want? Next week?
25th or 26th? 26th.
26th.
Please.
Raise this matter on 26th.
Serial number 42, Mohan MS for petitioner. Anirudh Suresh.
Petitioner in this case. Suit for recovery, my lord. Engaged a senior counsel, my lord. He is on his legs on quota number 16. Kindly the matter may be taken up 22nd, my lord.
Next week.
22nd, my lord.
Your luck today, 2 times your matter is reached. Mr.
My lord,
see that
this is, my lord,
not
this
even
is,
a single time so many matters has been reached.
this is, my lord, since this is the 6th time the matter is listed. Never reached, my lord.
Yes.
Today is the day matter reached, my lord.
28th, yes.
22nd, my lord. Kindly, my lord.
28th, yes.
22nd.
Yes.
24th is a trial court, it is listed, my
We'll
lord.
see on 28th, yes.
So I'll take a chance on 22nd, my lord. Kindly, my lord.
28th, yes. Yes. 55, you take time, whichever date you want that. Oh, that. Huh? Yes, Monday.
My lord, serial number 54.
Serial number 93,
Serial
my
number
lord.
54. If Lordship may kindly fix some date, I'll be
That's
grateful.
93, my lord.
Matter has been heard at length 4 times, my lord, before. you.
26 ತಗೊಳ್ಳಿ ನೋಡೋಣ ಅವತ್ತು Saturday sitting ಬರಲಿಲ್ಲ ಅಂದ್ರೆ
I'll take.
My lord, serial number 93, my lord.
yes
My lord, interim order may be extended, my lord, please.
interim order you just mentioned the
Please,
interim
please,
order
please.
yes.
Sir, serial number 54, interim order, sir. Sir, 54 interim order. ಆಮೇಲೆ 26 ಹಾಕೊಳಕ್ ಹೇಳಿ ಮೇಡಮ್
Court officer.
ಯಾವ್ದಾವ್ದು ರೀಚ್ ಆಗಿಲ್ವೋ ಎಲ್ಲ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ. ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಲ್ಲಿದೆಯೋ ಕಂಟಿನ್ಯೂಷನ್ ಇದ್ರೆ ಬ್ರೇಕಪ್ ಇಲ್ದೆ ಹೋದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಟ್ಯೂಸ್ಡೇ ಬೇಡ ಅನ್ನೋರು ಎರಡೂ ಸೈಡ್ ಪಾರ್ಟಿ ಅಡ್ವೊಕೇಟ್ ಇದ್ರೆ ಈ ಕಡೆ ಸೈಡ್ ಬನ್ನಿ, ಬಾಕಿಯವ್ರು ಓಡಿ. ಟ್ಯೂಸ್ಡೇ
ಸರ್ ನಮ್ 26th ಅಂತಂದ್ರು 54
26 ಈ ಕಡೆ ಬನ್ನಿ.
97
ಟ್ಯೂಸ್ಡೇ ಸರ್, ಟ್ಯೂಸ್ಡೇ
ಪ್ಲೀಸ್
ಅವ್ರಿಗೆ ಹೇಳ ನಿಮಗೆ ಹೇಳ ಅವ್ರು ಅಲ್ಲಿ ಸರ್ ಟ್ಯೂಸ್ಡೇ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಹೇಳಮ್ಮ ಏನು ಹೇಳಿ ಮೇಡಮ್.
ನಾಜಿಮಾ लाल दबा ट्यूसडे कैंसिल नहीं
कंफर्म करना से कैंसिल नहीं, कैंसिल करे तो वो चांस रहता है।